I'd like to welcome everyone to this Wednesday Free American Show, the Wednesday scheduled show every Wednesday. Welcome to Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. The book we'll be going over tonight, we'll be reading from a book by Charles E. Phelps. It's called The Juridical Equity, Abridged for the Use of Students, Part 1 and Part 2. Now we're going to start on page, on the PDF, it's 291. So we're not going to do the whole book. We're just going to start into a new series here. We're going to start in on the lectures on the equity maxims. So this is by Charles E. Phelps, Juridical Equity, Abridged for the Use of Students, and it's an 1894 book. This private show and or documents are for academic informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of therein reference, and has no interest in any issue referenced to therein, and is not a party to this or any action arising from, and is only acting as an authorized capacity as liaisons to communications between the parties. By reading or using this information, you acquire knowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for ab initio commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding. So let's turn to the preface. The preface of the book opens up and says the scope of this work is sufficiently indicated by its title. Upon the voluminous subjects of equity procedure and equity jurisprudence, it does not profess to be an exhaustive treatise. It does not offer to compete with any existing work. It may be called a horn book, nothing more. It has not been prepared by contract. It is a gradual outgrowth of many years' experience and reflection on the work of practical instruction. There are two ways of teaching equity. One is to take up in succession, with more or less of technical detail, the practical topics treated in some approved textbook until the time limited for that department expires. The other method is more elementary. It assumes that what the young lawyer especially wants is a faculty and a habit of original investigation. Give him that, and he will have no trouble in finding what he wants in the books as occasion requires. It therefore aim is to put the student in complete possession of all the few central principles, which command the whole field. Through mastery of those principles is given by historical explanation, by copious illustration, and by systematic drill. Some of these principles are so comprehensive and fruitful that the one who grasps them in their fullness of conception has already mastered the system of equity. All else is application of these grand truths to particular circumstances. Nice quote in Pomeroy there. The more elementary method is the one reflected in these pages. For the illustration of the principle, the main reliance is, of course, upon adjudged cases. The student should be frequently called on to state from memory their substance in connection with the propositions illustrated. From memory. You don't have to worry about learning 63 million statutes and codes. All you have to worry about is less than 20 maxims. This exercise in the presence of a class gives accuracy of thought, clearness of statement, self-confidence, and that's what many of you lack. It is a discipline to prepare the candidate for his profession, not simply for his examination. In order to apprehend with ease decided cases, the learner must first be made familiar with the mold or form in which they are cast. For this reason, and also because the distinction between law and equity grows mainly out of the essential difference in a procedure, that subject is first presented in brief outline, preceded by a chapter on courts. The effort here is to avoid as much of technical detail as not inextricably involved in the fair outline of procedure. Passing thence to the complex subject of equity jurisprudence, its master principles are reached by two stages. The more fundamental ones, those upon the ground floor, so to speak, are grouped into definition, and afterwards maxims are considered with their illustrations. The definition is simply a piece of temporary scaffolding to aid the student while he is building up a fuller conception of himself, or for himself, after which he will have no further use of it except to refresh his memory and coordinate his results. It is short enough to be remembered and comprehensive enough to furnish the analytical basis for sufficiently full discussion. The maxims of equity are so classified and arranged as to present the form and substance of the connected system. Their contrasted functions are exhibited in two opposite tables under the respective headings of enabling and restrictive maxims. This is merely another device to aid the understanding and memory. Memory. You have to commit this to your memory. With these general principles and their practical illustrations, the course closes. If proper use is made of the cited cases cited, and even of a moderate selection, there will be no time for more. These citations are drawn from the whole field of juridical equity. The student will have incidentally learned much of the practical doctrines. Imperfect as the execution of the plan may be, the plan itself, that is to say, the elementary method of instruction, has received a weighty approval of the American Bar Association. In the report of the Committee on Legal Education submitted by a Saratoga meeting in 1892, the professional technical method of instruction is condemned upon the ground that the entire time spent in the study of the law is too brief and precious to be wasted on merely committing to memory what the learner can find in the books as he wants it. On the other hand, they recommend that the process by which the student's memory is charged only with those fundamental principles which he must always carry there in order to make any use of them, and by which he is given a complete and thorough comprehension of the nature and subject under which all his subsequent acquisitions will arrange themselves according to the very law of thought. The substance of the same idea was concisely stated in a recent address to English law students by Sir Edward Fry, quoting, "Learn in order to know, not in order to answer questions," quoting from Law Q Review for April 1893. An American jurist of international reputation and its latest publication issued from the press since the following pages were printed has placed his unqualified endorsement upon the report above cited, which seems to be also have made a powerful impression upon the Council of Legal Education of the Inns of Court. Dillon on the Laws of Jurisprudence of England and America, 82. Himself a former professor of equity jurisprudence in the Law School of Columbia College, Judge Dillon further concises the course of instruction in our law schools as too intensely practical and technical, and suggests that the great drawback today alike of the teachers and the student is of the non-existence of elementary works written by lawyers of competent learning and experience, designed for the specific purpose of enabling the teacher to teach and the student to learn the elements, the great primordial and essential principles of our jurisprudence. It's not up to me to learn it for you, folks. You got to learn it yourself. All I can do is teach it. You got to get it in your own minds. That takes time. There is no automatic download of this stuff. You got to put the time in. There is no fine wine before it's time. You've got to read and study. If you don't, there is a simplified method for this, 1, 2, and 3 steps. And those 3 steps is, number 1, bend over. Number 2, grab your ankles. And number 3, kiss your butt goodbye. Because you will fail in what you do. Don't understand the material, don't have a grasp of the material, and you will fail. and there is no easy method. We are in a microwave situation in our lives, and that's all we've been taught all our lives. You got to get out of that. You got to become responsible people and realize you have to learn it yourself. There's nobody going to stick up for your substantive rights than you yourself. No attorney's going to do it for you. Continuing on, this textbook is easily perceived to be designed primarily for the Maryland law student, and in the absence of any other book on a similar plan, it may be found helpful to instructors and students elsewhere. It will be seen that there are liberal citations in recent federal and state decisions, as well as from the latest English reports. The references generally are of a character to be serviceable to the equity practitioner, and whom it may also be suggested that among old things for young heads, there may be perhaps be found some new things for old heads. For valuable assistance in the compilation of the table of cases, acknowledgement is due to C. Hopewell Warner, Esquire, and the preparation of the index to the same gentleman in connection with Ralph Remerson, Esquire, both members of the Baltimore Bar and the Maryland University graduates of 1893. For whatever notice he may receive of errors discovered, whether of omission or commission, the writer will be gratefully, and he will also be grateful to the mind which claimed a consoling reflection that, quote, the man who never makes a mistake never makes anything, unquote. March 1894, that was written. So you might want to review the contents of this, and I would highly suggest that you read starting on page 1 and come up to where we're going to be talking about tonight, because that's the foundation and more of an explanation of what equity is if you don't have that down already. So now let's move on to this page in the PDF of page 291. That's chapter 10. This one's entitled Principles of Equity. This is beginning in section 174, How Exhibited. So I doubt if we'll get into the actual maxims tonight, but we're going to lead up into it. And then we'll be jumping between different books with different maxim sections, and we'll be reading and comparing each individual maxim with other books within themselves. So we have to have some kind of a classification and some kind of a ladder to start sticking these things in. And I like the way that this writer Phelps has categorized these. And different authors categorize them in different ways, but I like the way he does it. Principles of Equity. This is on page 251 in the book, or 291 in the PDF. Section 174, How Exhibited. Having learned something of the principles of equity in general, of their sources, and I like the way Bouvier writes about equity, and I've quoted this definition many times on other shows, but he quotes that the source, equity is the source even without the law. Equity is everything. Even without the law, equity is everything. So that's kind of like a misnomer. How can, without law, equity be everything? Because it's the source. Having learned something of the principles of equity in general, of their sources, nature, extent, and of the courts and procedure which are their instruments, it is now time to examine them more closely. In their concrete form, they are exhibited as 1. General maxims, 2. Doctrines, and 3. Particular rules. And it gives reference to Palmer Jurisprudence, sections 360 and 361. Next section, 175, the maxims, which is general maxims under number 1 there. There are a few broad and comprehensive precepts condensed into pithy and pregnant phrases, so pervading the entire structure that together they may be called the grammar of equity. These maxims are of different degrees of universality and importance. They are so elementary, and therefore so general and vague as to require many qualifications. In their proper application consists much of the science of equity, if you really want to call it a science, because really the equity is the God-conscious mind, and I don't think science is too much involved in there, and equity's been since before time began. We didn't just discover this by the Romans. It's been in existence before the history of time. It is the God mind. The Romans didn't discover this. They just acknowledged it exists and incorporated in their legal system. In their proper application consists much of the science of equity. It will be seen presently that the leading maxims of equity are naturally divisible in two classes, one of enabling and the other of restrictive character. So enabling and restrictive. The one illustration of each class may be given in passing as follows. Enabling maxim. Equity regards that as done which ought to be done. Now, he opens up with this one right off the bat. Now, the restrictive maxim. Between equal equities, the law will prevail. Section 176, doctrines now. Those special systems of practical rules governing particular states of fact or branches of equity, elsewhere called heads, are commonly known as the doctrines of equity. Now, those three heads in equity are number one, concurrent, or exclusive jurisdictions first, concurrent is next, and auxiliary. Those are the three heads. Exclusive, concurrent, and auxiliary. Three heads of equity. Now, to the first head, the exclusive jurisdiction, there is a subdivision. And the subdivision, number one, is trust. It's got its own little division all by itself. Number two, fraud, mistake, omission. And number three, specific performance. So exclusive is broken down into three subdivisions as being one head in exclusive jurisdiction. You want the exclusive jurisdiction because it's automatically. Exclusive means to the exclusion of all others. Let me repeat that. Exclusive means to the exclusion of all else. It excludes at law. Continue on. The same term is also employed with a more limited application. Most of these doctrines are the outgrowth of maxims. For instance, the doctrine of conversion and the doctrine of notice will be found upon examination to proceed respectively from the two maxims above cited. The methodical treatment of those doctrines of equity constitutes, in fact, the body of a professedly full treatise on equity jurisprudence and does not fall within the scope of this work. Of the most useful and important of these doctrines, a sufficiently full conception for all the purposes of elementary instruction will be obtained from the study of their sources in the maxims of equity and the illustration of those maxims. And that's what we lack. We lack the understanding. And we'll get the understanding through the illustrations of these different authors as we study each particular maxim. Because your mind needs to be opened up to what actually we're talking about, which is before you, and you just don't see it in your life. We're using this stuff every day, and we don't realize it. We don't see it. It's like walking on the dirt of the ground. You don't see the dirt. It's the substance that you're walking on. Section 177, classification of doctrines. The older compilations were mere digests of decided cases arranged under these three principal heads. Accident, using the term in a very broad acceptation, fraud, trust. So he treats it a little bit differently there, but kind of a misleading thing. Those are the three branches under the exclusive jurisdiction there. Attempts at a more systematic division were made by Maddock, by Lord Resdale, and by Josiah Smith, Spence, and Adams. Get those books also and look at them. Neither of these plans was met with universal approbation. Classification, until recently most familiar to the profession, was adopted by Judge Story following Fontainebleau and Jeremiah, as it was advantage for a more immediate tangible connection with the history of the subject itself, and obviously refers to their origin of equity as merely supplemental to law. This well-known classification distributes the various subjects of equity jurisdiction under the three heads, which referring directly to the courts of law. These heads are, number one, concurrent jurisdiction, which in some other books, the second one's number one, and the concurrent's number two. But in this one, it's concurrent and one, two, exclusive jurisdiction, and three, auxiliary jurisdiction. For reasons already stated, the last of these three heads has become of insignificant importance, which would be the auxiliary. And in fact, today, even so, on the concurrent, the points are moot because there is both jurisdiction and simultaneously in one court. Two separate streams, two separate jurisdictions. The procedures to get into that court have been merged, but the jurisdictions themselves are separate. For reasons already stated, the last of these heads has become of insignificant importance, if not practically obsolete. The recent reforms in legal procedure herein before referred to have obscured the distinction between the first two by removing the basis of fact. The relations between equity and law was a separate system upon which the distinction was founded so far as concerns England and their dependencies and many of the important and influential of these states. And that took place in 1848, by the way. 1848. The reform procedures came in, and they've been doing that since then. That's quite surprising. 1848, and nobody has seen it. It may further be said that what remains of the old classification after the innovations of the state and others have not yet adopted the reform procedure in its entirety is in standing conflict with the tendencies of legislation therein. And finally, the scheme itself, judged on the merits, was one of questionable unity. The writers adopting it do not agree with the arrangement of the topics under the three general divisions of jurisdiction and are not even consistent with their own principles of classification. These topics are grounds of jurisdiction so overlap and run into each other that most eminent of the writers who have attempted to follow out the plans scientifically have been obliged to admit that it is impracticable and illusory. It is in fact admitted that with respect to the exhaustive jurisdiction exercised by courts of equity in matters of trust, etc., it seems impossible to define with exactness its boundaries or to enumerate the precision its various principles. In other words, you can't tell when it is in effect and when it's operating as to anything else. It all looks the same. Very hard to detect it, and that's probably why it's never been discovered. But today the courts are operating in equity. These are trust courts. One of the more recent English authors since the Juridical Act rejects the division as obsolete and confusing by treating as coordinate matters of substance and matters of form, placing side by side titles so incongruous as trust and injunctions, mortgages and interpleaders. The latest American writers on equity jurisprudence take the same view, and the classification referred to now may be everywhere abandoned. It is true that the acute and analytical mind of Professor Pomeroy could not forbear the opportunity of wrestling with its difficulties in a labored attempt to explain by its aid and intricacies of equity jurisdiction as distinguished from equity jurisprudence. The section he devotes to that discussion are most ingenious and subtle, but the least available for practical use of any proportion of his profound and philosophical treatise. And he's talking about number 2, footnote, Pomeroy in the section 136 and 146 to 189. The method of classification of the most recent text writers on both sides of the Atlantic is substantially upon the line somewhat obscurely indicated by Mr. Spence. That's another good one, Spence's book. But since more distinctly traced as a line of division between equity rights and equitable remedies, or between those doctrines where the jurisdiction rests on substantive principles of equity and those founded on distinctive procedure. In the first division of that the equitable rights are included equitable titles under the heads of trusts, mortgages, and assignments of choices in action and future property, and also equitable rights as distinguished from titles under the head of accident, mistake, and fraud, etc. Under the second division, the term remedies does not refer to the rules of practical procedure, but such distinctively equitable relief as specific performance, injunction, reformation, and the like. Practical objection to this plan is that it somewhat awkwardly separates the right from its appropriate remedy, mistake for reformation, accident from re-execution, fraud from cancellation, trust from specific performance or injunction, thus requiring much repetition and to reestablish the broken connection. The only answer to this criticism is that the nature of the subject is incompatible with any perfect system of logical arrangement, and that these various heads of equity jurisdiction, being merely the fruits of the shortcomings of the courts of common law, might be expected that what is not a system in itself, although one of it is a habit of calling it so, but only a supplement to the imperfections of another system, should hardly allow of a merely methodical classification. These considerations, there results that the order to be observed in the treatment of the heads or doctrines of equity jurisprudence should be determined by practical convenience rather than by supposed requirements of scientific precision. And the latest treatise upon the subject seems to be arranged on that plan. And that was Beach on Modern Equity Jurisprudence. Next section, 178, Rules. Particular rules are components of doctrine and are to be distinguished from rules of court. So when we're talking about rules here, we're not talking about rules of court. Unlike maxims, which are narrow and definite in their scope, practical and pointed in their application. There's the maxims. They're narrow and definite in their scope, and they're practical and pointed in their application. They're like the scalpel of a surgeon that gets right down to the meat of the things. He gets right in there. The maxims are like the precision of a surgeon. The first example below groups them together in a number of rules under the doctrine of conversion. The second example is a rule under the doctrine of notice. Number 1, conversion under a will dates from testator's death, under a deed, from delivery, under a decree for sale, from final ratification, and when the scale is dependent upon a contingency, the conversion dates from the happening of the contingency. 2, one who takes with notice of a prior equity may resist its enforcement under cover of want of notice in his immediate vendor. In other words, no notice, bona fide purchaser, who cuts off all equities, supposedly. Section 179. Jurisdictional rules. There are several rules relating to jurisdiction which are too general to be subordinated to any particular doctrine, but are not usually classed among maxims. These rules have nothing to do with jurisdiction over parties. Already referred to under the head of the procedure, they relate to jurisdiction of the subject matter. Now we're talking about the res. Jurisdiction of the subject matter is, in general, the power to head and determine, and more particularly the power lawfully conferred to deal with the general class of subjects to which a particular case belongs. Equitable jurisdiction over the subject matter is defined negatively in the terms of the common law by the first jurisdictional rule. Number 1, equity will not assume jurisdiction where the remedy at law has always been explained, adequate, and complete. To prevent the jurisdiction of the equity from attaching, the legal remedy must be efficient as the equitable, both in respect to the relief itself and the mode of obtaining it. Generally, if a proceeding be coram non judicia, that is, if the court act without jurisdiction, either as to parties or subject matter, the decree is void, may be attacked collaterally, and attempt to enforce execution would be an actionable trespass, and a scale under it would pass no title. A sale under it would pass no title, excuse me. But the assumption of the exclusive legal jurisdiction, legal jurisdiction by the court of equity does not necessarily make the decree void, though erroneous and liable to reversal. It cannot be questioned collaterally. The Supreme Court of the United States holds it discretionary whether to consider the objection or not, and may reverse a decree sui sponte for want of equity jurisdiction, and even where no such objection was made below. It is provided distinctly otherwise by statute in Maryland, and that the objection to the jurisdiction, in order to be available on an appeal, must appear by record to have been made below. Number 2, equitable jurisdiction is in general not ousted by a subsequent expansion of the legal remedy. That's what they've done today. They've expanded legal remedy by codifying more of equity to a look-alike of statutes and codes. And now it's in the statute and code realm, and everybody thinks that that would oust out the expansion, would oust out the equity of jurisdiction due to the expansion of the legal. But it does not oust it out. This rule explains the significance of the word always, as I stressed earlier. It's not everything the way it seems to be all the time. Everything seems to be worded so that if you interpret it literally for what it means, there's always the exceptions and the otherwise. And that's really the direction you need to be going. The word always in the preceding rule and applies whether the legal remedy be enlarged by statute or by what is called judicial legislation. In other words, codification. Codification of equity. To give it a legal connotation, character, a rap, which is false in its nature. Jurisdiction is not ousted by statute unless by express terms or clear and necessary implication, otherwise by agreement. Your waiver. Section 71 in Gibson's book. Waiver by silence. That's your consent, which is your action. Doing nothing is an action that grants consent, you going to jail or being foreclosed upon. Just like, who was it? Judge, who was it, said, one of the Supreme Court judges of the United States said, nobody's in prison except otherwise by voluntary of their own will. That was the Supreme Court judge said that. Number 3, equitable jurisdiction, once having attached to the case, will be maintained for the final adjudication of all rights involved. This rule is one of the many applications of the maxim that equity prevents multiplicity of suits. Its meaning simply is that whenever jurisdiction has once rightfully attached for any legitimate purpose, in other words, one of the children under the exclusive jurisdiction, it will be made effectual for the purposes of a complete relief. The court will determine any incidental questions necessarily involved, and the case will be maintained for the final determination of all questions arising under the claim of any party interested. Or more briefly expressed, when a court of equity has jurisdiction over a cause for any purpose, it may retain it for all purposes. Get out of the courts at law. You don't belong there. Those are made for fictions. There are no substantive rights in the at-law side. You're in the wrong courts, ladies and gentlemen. You need to get into equity. That's the only place where your rights as a real man and woman are enforced. I don't know how we've been missing that for so long. We've been copying the attorneys, going in and doing what they do, and they don't know anything absolutely about equity at all. And you're just duplicating what they're doing, and they're there to suck you in. And once you're in there, you're going to get beat up. Because you think that the court is operating at law, and really, it's operating under equity, and you don't know what equity is. Continuing on, the rule elsewhere is held applicable to orphans courts when exercising equity powers. The rule seems to have been never adopted in the state of New Jersey, and it was at one time supposed to have lost practical importance in the coded states, and the consolidation of law and equity in the same suit having removed all danger of a party being turned out of one court into another. At that particular time, the two courts were separate. It will be noticed, continuing, however, for the references just given to recent decisions in several of those states that the rule is practically operative therein. The fact that the remaining questions necessary for complete adjustment are legal, or that the rights to be finally established are legal rights, or that the remedies required for the maintenance are legal remedies, will not affect the jurisdiction of equity after it has properly attached. Hear what it said? And this principle is not an infringement of the constitutional right of trial by jury. Thus, where an injunction is issued to stay a sale until certain accounts have been settled, the court may proceed to render a personal decree for the balance due. Where the jurisdiction of equity has been rightfully invoked to reform a mistake or in a policy of insurance, full relief will be administered by decree for payment. Section 180, Miscellaneous Rules. In addition to the classes of rules referred to above, there are unclassified rules, not referable to any particular doctrine, generally pointing to practical application of maxims. Everything comes out of the maxims. The following examples are of everyday application in practice. Number one, the Court of Equity will ratify that when done, which, if previously applied to it, would have ordered. So this rule will be once recognized as a direct application of the enabling maxim previously cited, and the more fully treated further on that equity regards that as done which ought to be done. So everything is coming out of these maxims. Two, that one of the two innocent persons should suffer a loss who has most trusted the defaulter, or whose negligence enabled him to commit the fraud, or whoever by reasonable care could have protected himself, or whose conduct has misled the other. Thus, upon this group of cognate rules will be found upon examination to proceed from the same restrictive maxim, which is also the basis of the doctrine of laches, classified hereinafter as the sixth restrictive maxim. Several of the cited cases in the notes illustrate the extent to which the spirit of the rules has been imported into the common law. Imported into the common law. Imported into the common law. And today we can't have common law because there is no real money, because you can't get a money decree for damages. So your common law has been frozen, put into trust. What's taken its place? Statutes and codes. Section 181, Equities. Equities or equitable rights are prima facie well-founded claims to specific equitable relief, such as a wife's equity, the mortgagor's equity of redemption, the equities of reformation, cancellation, contribution, and the like. The wife's equity to settlement out of her own property, which the husband formerly sought to reduce to his own possession by the aid of chancery, has become practically unimportant since the entire property has been secured to her by statute. So they've codified everything, and now you can get an adequate remedy at law. Well, don't forget the exclusive jurisdiction, what excludes all others. Continuing on, as applied to other equitable claims, the term is of constant recurrence, and it has been imported into the phraseology of common, especially the commercial law. In the legal sense, equities are rights incident to a property or contract as between parties, equities between the parties, but not incident to the property or contract from its own nature. In the equitable sense, equities may be regarded as of two classes. One, primary, that is relating to rights or primary rights, titles or estates, and other remedial or relating to remedies. Now that's a little bit confusing because we always look at remedies as being the at-law side, but it's primary rights being remedial, and under the remedial then there's like two breakdowns. There's the remedies at law, and there's the relief in equity. Continuing on, the equity of redemption is the type of first class, and the equities of specific performance, reformation, and others of familiar nature are examples of the other. Equities may be defeated by superior equities. Equities may be defeated by superior equities. When do you ever come into a court with a superior equity? You don't even know equity exists, and you don't even claim equity. And here you're coming in with a mortgage foreclosure, and a mortgage foreclosure by exclusive jurisdiction is exclusively in the jurisdiction of equity, in the first head. And it's coming in and foreclosing you under equity. And you're coming in on that law claim and saying, hey, and you don't have anything near an equitable claim. You have zero equitable claim because you're not expressing it. You don't even know what an equitable claim is to be even expressing it. That's the problem. How could you come in with a superior equity? Equities may be defeated by superior equities, by balanced or equal equities, by laches or acquiescence. And we're all famous for acquiescence, let me tell you. By estoppel or election, by fraud or other inequitable conduct. And that's what we're doing all the time. You're in a breach of a contract that you sign, and it's been expressed as a debtor-creditor contract, and you're in breach of the contract, haven't made a payment, and you expect to go into court and claim that as a defense that you don't have any money. You don't have a superior equity. You don't even have a trust as you're expressing. The only evidence on the plate, and the greater weight of evidence is going to win, is your debtor-creditor contract that you signed, that you're going to make payments for 30 years. There ain't nothing about admiralty. So by fraud or other inequitable conduct, and we've got unclean hands do that, and when we've got unclean hands, read the section on, I think it's section 918 in Gibson's, where it talks about when you're in contempt of court, the court, because of your unclean hands, is looking at you in contempt, and therefore you cannot move forward on a defense. It totally ignores your defense. Unless you come in as a counterclaimant with a brand new claim as counter plaintiff. Or you come in and do discovery and get the unclean hands off of you imputed to the plaintiff because he doesn't have, say, the note, the original note, or the mortgage. So by fraud or other inequitable conduct, or by transfer to a bona fide purchaser without notice, and that's the key, without notice. We're never giving any notices. They differ from legal estates, liens, or charges, which can be divested only by legal modes, such as a conveyance of an estate, or the release or satisfaction of a lien or charge. Chapter 11, the maxims. Section 182 in general. In all systems derived from the Roman law, now, keep in mind I said that the Roman law did not come up with equity. It's that they were probably one of the first ones to really recognize it and grasp a hold of it and incorporate it into their legal system. And the Constitution guarantees you an equitable court, but that is a limitation. It grants you a limitation on equity. Because our Declaration of Independence says you have all the unalienable rights given to you by God. If they're given to you by God, they've always been in God's mind since before the beginning of time, and He has always been and always will be. Anything that He has thought up, He has not thought it anew. There is nothing that God does not know. He knows everything, and He knows it exhaustively and extensively. And He is the one who knew about equity. And He gave that equity to all of us. The Romans did not discover it. They just acknowledged it. And the Constitution acknowledges that also. But only a portion of a limitation of granting you whatever they think is just by privilege. Which is, you have much, much, much more than that. They're only giving you a limited, they're guaranteeing you a minimal equity here. I don't want that stinking Constitution. That Constitution is not mine. It's theirs. In all systems derived from the Roman law, maxims are of special authority. Common law having been built upon the foundation of custom and precedent. The method of its evolution has been largely empirical. Equity, while not failing to avail itself of the method, also has in its growth owed more to the method a priori. It has been accustomed to assume certain postulates in the fundamental principles of natural justice are happily blended with an enlightened public policy. Enlightened public policy. I wonder how many people are enlightened about public policy. The union has been a fruitful one. From these postulates or maxims has been deduced a system of jurisdictional or juridical regulations for adjusting the relations of society in a more advanced stages of development than those of which the common law was originally adapted. Hence, the value of a thorough investigation of the maxims of equity, which are few in number and readily susceptible of philosophical division. They are supposed to be so well understood that the reference to them in decision is more often tacit than expressed. They will be found attractive because they clothe in the form of which is at the times precisely expressive and universally intelligent, imperishable truths that experience is every day confirming afresh. 183. Approximative. But equity, like war, like political economy, like law itself, cannot claim to be an exact science. Its maxims are not like the axioms of mathematics, inflexibly and universally true. The blended product of ethics and expediency, they cannot be expected to be more than approximations of or to the absolute truth. Approximations to the absolute truth. In other words, we have a limited grasp and understanding in expressing these absolute truths because we don't thoroughly understand them ourselves. And I'm sure there's much, much, much more to equity maxims than is we're just scratching here on the surface. There are many things undiscovered in equity, which is the God-conscious mind, the absolute truth, than what our approximations can explain. Continue on. There is no one of them which is not, in many cases, of doubtful application. When it seems further on how they are classified, it will be found that it is the business of one set of maxims to antagonize the other. In other words, they're really like a picture puzzle, all dovetailing, connecting together. One connects into the other. It's like the Ten Commandments. You can't break one without breaking them all. In the latest editions of a celebrated English work, we find it rather broadly claimed that equity is preeminently a science, and like geometry or any other science, starts with or assumes certain maxims which are supposed to embody and to express the fundamental notions of the science. Equity may be, in a general sense, called a science, but it is not preemptively a science, like geometry. The axiom, for instance, is that the whole is greater than any of its parts, is an absolute and unqualified truth, which will never yield to any change of physical circumstances or to any considerations of convenience or morality. As respects its application, there is never any room for doubt or difference of opinion. It is not a single maxim of equity of which so much can be said. Section 184, not self-evident. Self-evident. They also differ from the axioms of mathematics as well as from the more general speculative maxims as such. What is, and it is impossible for the same thing to be and not to be, in that they are, none of them, self-evident propositions, shining by their own light, carrying their own face, their own warrant of assent. Like moral principles, generally they require, in order to discover their truth, some intellectual exercise. In other words, you've got to sit there and ponder on these things a little bit. You've got to think upon these things. That's what we're all commanded to do as Christians. You've got to develop discernment so you know what the garbage is from the truth. Some process of reasoning and illustrations, some previous acquaintance with their subject matter. In a greater or lesser degree, they are refined, artificial, and in a sense technical. They are not an intuition, but an acquisition the ripe development of many ages of accumulation of experience, and their origin is as obscure as of the juridical equity itself? I don't think so. No, they come directly from the God-conscious mind. They're not obscure. If you know and read equity, you can go reread your Bible again. You'll find that equity is all through the Scriptures. Take the stoning of the adulterous woman. The law required that she be stoned. Well, what kind of law was Jesus using when he didn't stone her? And if he was a perfect God, why didn't he stone her? Because the law required that he did stone her. Why didn't he? What law was he using? He wasn't using any law at all. He was using equity, which was the source of the law, because he forgave her. So take them simply for what they are, generalizations of experience, grammatic condensations of the world's ripest judicial attainment, crisp phrases into which the whole cycles of litigation have been packed and made portable. Packed and made portable. You carry around these things in your mind and you don't even know you're carrying them. But no proverb taken literally by itself can ever be infallible guide, since its very conscience is a virtue purchased at the expense of qualifications and limitations necessary to be rounded conception of the whole truth. So you need to bend your mind to the truth and not bend the truth. You can't bend the truth. You got to bend your mind. You got to comport your understanding to what the truth says. Section 185, their practical use. If the question then be asked, what use are these so-called maxims? It may be candidly replied, if no practical use whatever, unless handled with judgment and experience. In other words, you got to have discernment to use these things. If you don't study them, you won't gain discernment. And continue on, always with reference to the special circumstances of the particular case. And if you want to understand what special circumstances really is, you need to read the prior sections to this, because it defines what special circumstances are. In the exclusive jurisdiction, the extraordinary jurisdiction of equity, read the prior section. The general principle that equity regards special circumstances is not formulated as a maxim, because it is rather a canon of constant application to all maxims. Maxims are useful as standards of weight and measure by which bearing and effect of circumstances and proof can be tested and estimated. Having performed this office, maxims then stand for the point of view from which a court will finally adjust its position to contemplate and adjudge the case. These are the rules it goes by in equity, not at law. At law is 63 million statutes and codes, and who can ever know all those? In equity, it's got 12 maxims, 12 main maxims. 186, classification. It is somewhat remarkable that no classification of the cardinal maxims of equity has yet been established in response to the general demand for a systematic arrangement of all scientific or quasi-scientific principles. No two authors are found independently presenting the same catalog of maxims. So there's a little bit of leeway here in how everybody thinks which one's the main one and how we break them down and that. But that's not the arguable fact. That still doesn't change the matter that they're all the principal source of the law. It depends how you are interpreting them, or presenting those in which all agree in the same order. So it depends on the author you're reading at the time. Section 187, enabling and restrictive. In natural division of maxims as suggested by the contemplation of equity as a force, equity is the force, not power. Power is choice. Force is inequity, and we are equity. Contemplation of equity as a force or system of forces its most familiar remedies, although ordinary enough in one sense, are commonly spoken of as extraordinary powers. And the courts have extraordinary powers. And you are equity. You have extraordinary powers. You have the extraordinary force. Extraordinary power, that is, extraordinary from a common law standpoint, such as our injunctions and mandate the appointment of receivers, the cancellation or reformation of contracts, and other specific enforcement. The handling of such powers by one man is felt by every judge to be a matter of extreme delicacy and responsibility. In all doubtful cases, there are many such. The court is called upon to weigh two sets of considerations. Two sets, public and private. One impelling or enabling it to act, the other opposing or restraining its actions. Looking at the maxims of equity from a natural point of view, they are found arranging themselves around opposite poles into two sets. One set consisting of affirmative, motive, or positive principles, and the other of negative, repellent, or passive principles. Those affirmative principles which excite or tend to set in motion the extraordinary powers of equity are the enabling maxims. The negative principles which restrain or tend to keep those energies at rest are the restrictive maxims. By very obvious analogy to the science of physical forces, the philosophy of the former may be called the dynamics, that of the latter the statics or of equity. Moreover, between certain maxims of each class will be found striking resemblances suggesting a further subdivision of each class into groups. So as thus classified and arranged, the leading maxims of equity are presented in the two following tables: enabling maxims and the restrictive maxims. And those broken down under the enabling maxims, the first one is in Latin, by just ibi remedium, which is probably that equity will provide you with a remedy always. And 2, equity regards substance rather than form. And 3, equity regards that as done which ought to be done. And 4, equity imputes an intention to fulfill an obligation. And 5, equity acts in personam. 6, equity acts specifically. 7, equity prevents multiplicity of suits. And 8, equality is equity. And now the restrictive maxims. Number 1, equity follows the law. And remember, when you read that, it's not literally what it says or what it means, what you think it means. Number 2, between equal equities, law prevails. And 3, between equal equities, priority of time prevails. And 4, excuse me. Well, I had a misprint in the book here. 4, who seeks to do equity must do equity. And 5, who seeks equity must come with clean hands. And 6, equity aids the vigilant. Okay, number 188, primary and remedial. The object of classification has to assist the learner and not to confuse him. While therefore no formal cross-division of maxims is deemed expedient, it may be worthwhile to note certain enabling maxims are sources of equitable rights, titles, and estates, or equities, and that one of the restrictive maxims operates when applicable to prevent their arising. They may be called primary maxims. Other enabling maxims, again, are sources of equitable remedies, which remedies under proper circumstances is the office of other restrictive maxims to defeat. Primary maxims, therefore, are those which especially relate to rights, and remedial maxims are those especially related to remedies. A few partake of both characters. 189, their combined operation. Cases often occur with the several maxims are found as cooperating or overlapping. Take, for instance, the doctrine of advancement as connected with the redemption or satisfaction of legacies. The general rule is that a gift by a parent to a child is presumptively an advancement and the satisfaction or redemption pro potential of a legacy previously given. Here, equity imputes an intention on the part of the parent to fulfill an obligation, the obligation being the dictate of the natural justice to give each child the amount it ought to have in view of the claims of all. At the same time, another maxim is so gratified which regards as done which ought to be done. But the effect of the rule is so to prevent any child from getting a double portion, in other words, to enforce the maxim of equality. It is, however, the common law right of every man to dispose of his own property, even to prefer one child at the expense of another. The restrictive maxim that allows equity to follow the law here comes in and prevents a court of equity from denying his common law right, even to gratify its favorite principle of equity. The whole question, therefore, ultimately resolves itself into one of intention, and in other words, the maxim equity regards to the intent, enables the admission of parole evidence to show either by the parent's declarations at the time or by any circumstance from which the legitimate inference may be raised that the donation was in fact a substance, not an advancement, but an actual gift in addition to the legacy. Many similar instances will suggest themselves as we proceed. 190 application. In an application of maxims, it must be borne in mind that most of them have primarily in view typical average situations of fact struck like composite photograph from a wide experience of human affairs and a vast multitude of instances. From these types, the particular situation encountered in practice are naturally found to vary, either on one side or the other, and in a greater or lesser degree. A slight variance from the typical form does not, a wide variance does prevent the application of the maxim. Thus, in closed cases, the controversy often resolves itself to a question of degree, or in other words, a question of fact. So the maxims are actually like models that apply to everything. And they're not, in a specific sense, applying to anything. But they're models, generally, applying to everything. 191, importance. Whoever has possessed himself of the philosophy of these maxims by careful study of the cases cited to illustrate them will find it to master the practical details of equity jurisprudence under whatever head of doctrine they may be found. He will at the same time have learned much of the application of the principle to doctrine, much of the doctrines themselves, and much of equity procedure as the instrument of their utility. On the other hand, the lawyer who ventures to practice in equity without some preliminary drill in its distinctive and familiar principles, or fundamental principles, like any army attempting field maneuvers before being set up in a school of a soldier, can expect nothing but blunder and disaster. In other words, you will lose. It's not worth your time entering into this unless you're willing to commit the time necessary to make fine wine. Juridical Equity, abridged for the use of students. We left off on section, I think it was 193. Actually, 192, I guess we could start, which is chapter 12 on page 314 in the PDF, or 274 in the book. And it's getting into the enabling maxims. And right off the bat, it talks about the enabling maxims in number 1, and it goes through a column of how they're split up. And 192 is in general, and 193 is no right without a remedy, which is the first maxim we'll be covering tonight. So 192. In general, the enabling maxims are dynamics of equity. They are positive, aggressive, and generally of use to the plaintiff. It is to be noted here that in some cases, as an account, both parties are actors. Both parties are actors. So we're not doing anything more than just acting on stages. We're actors in a gigantic play called real life, and we're putting on these face masks to interact, just like the Roman plays. So both parties are actors. So that's on the legal stage, really. Both parties are actors, wearing these face masks called straw men, legal entities, fictions. And in many cases, a nominal defendant may, for all purposes of the maxims, occupy the position of actual plaintiff towards some other defendant, or even towards a nominal plaintiff. Makes reference to number 1 there, which is Pomeroy Remedies, section 60. So continuing on, it is also to be stated here once and for all, and be kept in view throughout, that the equities raised by these enabling maxims are subject to the defenses interposed by proper cases through the operation of the restrictive maxims. So one balances the other. The enabling maxim enables the equity to take jurisdiction, but the restrictive maxims, on the other hand, restricts it or allows it not to take jurisdiction. Continuing on, as herein classified, the table of enabling maxims is as follows, the order being important. Now keep in mind that this is Phelps, the author here, and different authors break these down a little bit differently. But I like the way he breaks them down into 2 classifications of enabling and restrictive. So in the first class, in the enabling, number 1 comes out to be no right without a remedy. And the Latin equivalent, I'm not a Latin expert, so I'm not even going to go into that one. But anyway, number 2, equity regards substance rather than form. Number 3, equity regards that as done which ought to be done. 4, equity imputes an intention to fulfill an obligation. 5, equity acts in personam. And 6, equity acts specifically. And 7, equity prevents multiplicity, or multiplicity of suits. And 8, equity or equality is equity. So whatever is equal in rights or equal in anything, that's equity. Now, section 193, no right without a remedy, and that's footnote number 2. He makes reference to Bisfame, Principles of Equity, section 37. We'll be jumping to that next. So this maxim is both primary and remedial, and was most important, prolific of all of the enabling maxims of equity. I'm going to read that again. This maxim is both primary, and remedial. So remedial is different from primary. There's a different meaning there. And it was most important and prolific of all the enabling maxims of equity in the earlier stages of its growth. It is, in fact, the foundation of equity. So this maxim is the foundation of equity, which supposes the absence or inadequacy of legal remedy. For reasons which already anticipated, its importance at this day is historical and theoretical rather than practical. Question as to whether a remedy exists now in any particular case is determined rather by precedent and by considerations drawn from other general principles than by an existing force in this maxim. He lists a case, Express Company versus Siebert. It is held subordinate to positive institutions and cannot be applied to subvert established rules or give the courts a jurisdiction hitherto unknown. It is, in short, to be taken subject to the limitations already noticed in the definition of juridical equity. The principles of natural justice are applied only to the special circumstances of defined and limited classes of civil cases. So we've got to have special circumstances to get into court of equity. I think I mentioned last week that you need to go in, I think in the prior sections in this book, he specifically defines what special circumstances are, and you better know what they are. And that ties in with Gibson's book in section 25 under the exclusive jurisdiction. So special circumstances of defined and limited classes of civil cases And moreover, that application is to be controlled in a measure as well as by consideration of public policy, as by established precedent and by positive provisions of law. Now keep in mind, public policy in those days, when this was written in 1905, I believe, or 1907, is not the same as public policy today. We have statutes and codes, which is public policy. That's not actual law. That's not real public policy as it was back then. There was a flip-flop. 180 degrees, looking through a mirror, diametrically opposed, antithesis of one another, opposites, direct opposites. Law is no longer law today. It's called statutes and codes. Public policy of that day is not public policy today. It's Oz, fiction. That's it. But you still come in with your ties in with the main thinking back then, and you bring your thinking in today, and you try to shove the laws of this country, like going into a foreign country, France, and shoving it down their throats and saying, hey, you French people got to act like us Americans and go by our laws. They look at you and say, hey, you're crazy. Get out of here. Can't do that. That's public and private. You're taking the publicness of today and trying to bring in your privateness of yesterday. And you breached and commingled because you breached the trust. And you get hit with a statutes and code, which is a barrier, actually a protective barrier to keep you from breaching and commingling. So continuing on, notwithstanding all this, the maxim survives with vitality, even to turn the scale in favor of intervention of equity in any fair case of a doubt of a civil right without other adequate means of enforcement. Separate use of a married woman, the restraint on alienation, the rules against perpetuities, and the rules of equitable waste are among the modern interventions of chancellors upon the line of this maxim. Still more recent innovations may be cited, one of English and two of American introduction. The former has been already described as a negative specific enforcement by injunction of a contract for special personal services. One of the American interventions has also been referred to as a receiver's certificate, with its preference over all prior liens. And the other is in the doctrine of capital stock, especially the unpaid subscription, is a trust fund for corporation creditors. The doctrine has been criticized and manifested to retrench it. Next paragraph. To this maxim may be generally referred all the enabling doctrines of equity, and especially those not referable to any other particular maxim. Its earliest and boldest application was in the foundation of the great system of trust, and that's in italics, trust, and that's really the first subdivision and the head of exclusive jurisdiction and equity, of which there are three heads. Then the first head, exclusive jurisdiction, is broken down into three divisions. Those divisions are, number one, trust. Second division in exclusive jurisdiction head is fraud, mistake, and omissions. The third division is specific performance. But trust is in a division all by itself, and it's in italics in this book. The great system of trust. Why are we not treating everything as trust, which constitutes a large portion of equity jurisdiction? A large portion of equity jurisdiction is consumed by trust. So now 194 goes into the next maxim, but we won't go there just yet. Now we want to go to the Corpus Juris, the 1920 edition, page 225 in the PDF. We're going to go to section 188, and that's on page 198. 198 in the book, but 225 in the PDF. Corpus Juris. Now notice it's not called Corpus Juris Secundum. This is the older version, 1920. The later version is called Corpus Juris Secundum. Section 188. Picking up where Phelps left off, and now we're in Corpus Juris explaining this one maxim. I. Equity will not suffer a wrong to be without a remedy. In general, equity will not suffer a wrong to be without a remedy. This maxim includes the whole theory of equity jurisdiction and affords relief whenever the right exists and no adequate remedy at law is available, subject to the rules already stated in respect to the scope and limits of equity jurisdiction. It is the application to equity of the broader legal maxim, Iubendi jus ibi remedium. In accordance with the maxim, where a statute creates a new right which cannot be adequately enforced at law, equity will contrive remedies and orders to enforce it, unless the statutory remedy is exclusive, as determined by the usual rule. The fact that there has been no precedence will not deter the court of equity from awarding relief in a proper case. The maxim is sometimes vindicated by denying that the wrong exists when no remedy can be afforded. Number 2, limitations of the rule. The application of this maxim is far from universal, and it has been denied that the maxim is binding upon equity courts at all. Let me read that again. The application of this maxim is far from universal. It has been denied that the maxim is binding upon equity at all. It is only in general and not in literal sense that the maxim has force. The term wrong in the maxim does not include violations of moral rights, nor conduct which the law for any reason has made not actionable. There are numerous classes of cases where equity will afford no relief, although the party has no other adequate remedy. Even where the suitor is clearly without relief at law, he will not be aided by chancery unless he belongs to the class recognized by it as entitled to relief. So you've got to have some kind of cognizable right that equity will recognize. The right to relief may be lost by laches. The maxim does not apply unless the court has jurisdiction to hear and determine the subject matter submitted to it. So you walk in there with your pleading, you don't have any equitable rights in there, and you say, hey, this is invoking equity. No, it doesn't. And the judge will probably say, well, I don't see any equities here. Well, he's either telling you don't have any, or else he may be testing you. Section 190. J. Equity regards that which is done or ought to be done. That's the next maxim. So now we're going to jump to another book. We're going to jump to Pomeroy's Equity Jurisprudence, 1905 edition. We're going to go to page 768 in the PDF, and that's section 423, and that's page 701 in the book. So page 768 in the PDF in Pomeroy's. PDF is 768, and that's page 701 in the book. Section 423. Equity will not suffer a wrong without a remedy. The analysis is in section 423, its general meaning and its effects, and 424, the limitations upon it in 424. So now 423, its general meaning. This principle, which is somewhat restricted application to equity jurisprudence of the more comprehensive legal maxim, and again, there's that Latin, Iubendi, that takes some Latin, I think. Ubi jus ibi remedium. Whenever a legal right has been infringed, a remedy will be given. Is the source of the entire equitable jurisdiction exclusive, concurrent, and auxiliary? There's your three heads. exclusive, concurrent, and auxiliary. Today, since the merger of the procedures, the concurrent and auxiliary are moot. The point is moot. Continuing on, a full treatment of it, including an expansion of its scope and meaning with its various applications and illustrations, will simply be a restatement of all the doctrines and rules concerning jurisdiction which have already been discussed in the first part of this work. No such unnecessary repetition will be attempted. It is enough that the principle finds its development in the whole of doctrines and rules which define and regulate the equitable jurisdiction as distinguished from the jurisdiction at law. Distinguished from the jurisdiction at law. And nothing has changed. Today, there are still two rivers, two jurisdictions, or however you want to look at it, two separate courts functioning in one court. Or the judges wearing two hats, maybe simultaneously or one upon the other. Who knows? But you can know. So, Section 124, its limitations. There are, however, certain important limitations upon the generality of the maxim which may properly be stated here, although they have been referred to in the introductory chapter where the nature of equity is described, or in the chapters of the part first, where the doctrines concerning the exclusive and concurrent jurisdiction are explained. First of these limitations is that equity cannot interfere to give any remedy unless the right in question, the invasion of which constitutes the wrong complained of, is one which comes within the scope of juridical action, of juridical events, rights, and duties. The right must belong to the purview of the municipal law, must be one which the municipal law, through some of its departments, recognizes, maintains, and protects. Equity does not attempt, any more than the law, to deal with obligations and corresponding rights which are purely moral, which properly and exclusively belong to the tribunal of conscience. The second limitation is that equity does not interfere to remedy any wrong where the right and the remedy, assuming that the right falls within the purview of the municipal law, both completely belonging to the domain of the law, or at law. In order that the principle may apply, one of three facts must exist, viz., either, number one, the right itself must be one not recognized as existing by the law, or two, the right existing at law, the remedy must be one in which the law cannot or does not administer at all, or three, the right existing at the law, the remedy being one in which the law gives, the remedy as administered by the laws must be inadequate, incomplete, or uncertain. And if these three alternatives, the first and second denote the exclusive jurisdiction of equity. The exclusive jurisdiction of equity. The third, the concurrent jurisdiction. So the first and second denote the exclusive jurisdiction of equity. The third, the concurrent jurisdiction. Now those are the three heads again. The third limitation upon the principle is that it does not apply where a party whose case would otherwise come within one of the three alternatives above mentioned has destroyed or lost or waived his right to an adequate remedy by his own act, and remember, silence is an act, or laches. With these limitations upon its operation, the principle has been developed into the vast range of equitable jurisdiction, which, considered in its entirety, gives, number one, legal remedies for the violation of legal rights in a more certain, complete, and adequate manner than the law can give, and two, equitable remedies for the violation of legal rights, which the law has no power to give with its means of procedure, and three, remedies either equitable or legal in their nature or form for the violation of rights in which the law takes no cognizance and rights in which the law does not recognize as existing and which it either cannot or does not protect and maintain. Now that was Pomeroy. Now we're going to jump to Snell. Principles of Equity, 1885. Page 45 in the PDF, Section 1, page 16. All right, this is Snell, Principles of Equity, 1885, page 45 in the PDF, section 1, page 16. It says, equity will not, by reason of merely technical defect, suffer a wrong to be without a remedy. Equity will not, by reason of a merely technical defect, suffer a wrong to be without a remedy. A technical defect. It will be evident that this maxim is at the foundation of the large proportion of equity jurisprudence, so far as the jurisprudence aims at supplying the defects in which at one time existed in the common law. There were defects in the common law. For example, in the case of an outstanding dry legal term, prior in date to the plaintiff's title to an estate, and which term, although a merely technical objection, would at law have prevented the plaintiff from recovering in an ejectment, the Court of Equity interposed to put the term out of the plaintiff's way, and even permitted him, by means of an ejectment bill, as it was called, to recover the very possession of the land itself without regard to the term. So it went over the technicality of the common law, where common law would have never allowed it, but equity granted it and went through. Because equity is not going to look through the, it's going to look through the form, and that form at that time, where they were context, is it was the defect in the seal. It looks through the defect in the seal, the technicality, which would have immediately stopped it at common law. But equity looked through that and went to the intent of the parties. It looked at the intent of the parties. What did the parties intend to do? Because equity always looks at it as already being done, which is one of the other maxims. So equity looks through the form and into the substance, and the substance is the intent. What did the parties intend? Just because the technicality of a no oath that the judges have, or the technicality because there's no seal properly done upon the thing, what was the intent? Was this intended for this man to be a judge? And equity says, absolutely. So that shoots a hole in your common law, folks, of your, all these judges in all these states don't have proper authority and they're acting illegally. No, they are not. You're in Alaska someplace with your head in the snow. So similarly, in the case of a mortgagor seeking to recover an estate or rent, the defect of the legal estate being in the mortgagee was no impediment in equity, because it's looking at the intent. The maxim must, however, be understood with the following limitations. It must be understood as referring to rights which come within a class enforceable at law or capable of being juridically enforced, and the enforcement of which could not occasion a greater deterrent or inconvenience to the public than would result from leaving them to be disposed of in foro conscientis. And it must be understood as referring to cases where there is no equity or superior adverse right or adverse equity in the private individual who is made defendant, and to cases where the plaintiff, who is remediless at law, has not lost his remedy thereby by his conduct, his own conduct, or default. I believe it's section 70 and 71 in Gibson's book, which goes over the waiver of how we waive our rights. Very easy to do. Just don't answer when the judge says something or the opposing party says something, and you waive the right if you don't object. Continuing on, and it must also be remembered that many real wrongs are not remediable at all, either at law or in equity. But the nice thing about equity is equity will morph into something to give you a relief, always. It will always come up to the situation, meet the situation, even if the relief doesn't exist at the time. continuing on, and that a still larger class of apparent wrongs are not wrongs at all, accepting in the imagination of the suitor, of course the maxim does not apply to such. And there's a lot of cases where you're just dissatisfied with the judgment, and you want to go against it in any technicality that you can find. And you get teed off because the judge wouldn't tell you why you lost. But you better read Gibson's, because he doesn't have to tell you, because you're just a sore loser. You think your rights are being trampled all over, and you don't really know what your rights really are. I hate to burst people's bubbles. Number 2, equity follows the law. That's the next maxim. So now we're going to jump to Gibson's book. Page 53 in the PDF, section 33, page 27 in the book. That's Gibson's Suits and Chancery. That's 53 in the PDF at section 33, and that's page 27 in the book. Section 33. Equity will not suffer a wrong without a remedy. This maxim and the maxim that equity operates upon the person are two of the principles most active in originating and molding the Chancery jurisprudence. The king, as the fountain of justice, with an oath resting upon his conscience to see that right was done to all his subjects, and believing that he had the prerogative power as the supreme judge of England to do whatsoever he deemed as right and just between man and man, without reference to laws, customs, statutes, precedents, or courts. Without reference to laws, customs, statutes, precedents, or courts. So if equity was the consciousness of that time to be the prerogative power, and the king was the fountain of justice, and he was supposed to represent God on earth in his consciousness and do what was fair, right, and just, then that was outside the law, outside the customs, outside the statutes, outside the precedents or the courts. It was ex lex. But if you have a God that is perfect and he has a will that everything be just, right, and fair, or equities, then you have perfect justice. Without laws, without customs, without statutes, without precedents or courts. And if we would all learn to think about the consciousness of the will of God in his perfect thinking by the way of the interface of understanding that by the maxims, I'm more excited about NTT being a understanding of the God consciousness through the maxims of equity, so that fairness, justice, and righteousness can be done amongst men. And you will be in the will of God. I'm more excited about that than any remedy or relief on the face of the planet under NTT or trust or whatever. That I'm getting to know and understand the thinking of God, how he thinks. So without the reference to the laws, custom statutes, or precedents, or the courts, as Bouvier pointed out, equity is the source of the law. Even without the law, it's everything. And continuing on, and prompted, no doubt, by his ecclesiastical chancellors, was not willing to see a wrong done to a subject, and to be told that there was no power in his kingdom to right that wrong, and that the common law furnished no remedy, therefore, and that, as a consequence, the wrongdoer in that particular was superior to law and mightier than the king. Hence it was that the king deemed such a state of facts derogatory to himself, disparaging to his prerogative, disgraceful to his kingdom, and his dereliction of duty under his oath, took personal cognizance of such matters when petitioned to do so. When the petitions came too numerous for his personal attention, he referred them to his chancellors, who were the keepers of his conscience, with authority to do whatever good conscience and good reason required in the premises. So judges today are not discretionary to do anything that they want. They can at law, but not under equity, because they're guided by good conscience and good reason, which, if you know the maxims that they are ruling by, you'll know whether they're not ruling right. Continuing on, the common law had a maxim, ubi jus ibi remedium, where there is a right, there is a remedy for the violation of that right, but the maxim was too general to be true. It had to be true. There would have been no need for the chancery court. To support this maxim, it was held that if there was no remedy, then there was no right. No remedy, then there's no right. Which was the same as saying that the right depended on the remedy. And unfortunately for the common law, this was true. For under the common law, every cause of action had to be adapted to some one of its technical and arbitrary forms of suit. And if this could be done, then the suit could be brought, or could not be brought, so that at common law, the right had to be adapted to the remedy, thus violating at the same time both reason and justice. In the Chancery Court, the opposite rule was adopted and enforced, and the remedy was adapted to the right. The remedy was adopted to the right, and thus made to assume any form the right required. Thus made to assume any form the right required. In other words, any situation, equity will form to what is required. This maxim, or as it's sometimes expressed, equity will not suffer a right to be without a remedy, is the original source of the entire equitable jurisdiction of the Court of Chancery. Exclusive, concurrent, and auxiliary, and the full explanation of the scope and the meaning of this maxim would require a discussion of the whole system of equity. And there's a footnote there, footnote 18, and that's Pomeroy Equity Jurisprudence, section 423. And now that the jurisdiction of the Chancery Courts has been so greatly enlarged by the statutes in Tennessee, and not by just Tennessee, but everywhere else, equity rules the courts today. The force of the maxims and its beneficence has been proportionately enlarged. The wrong that equity will not suffer to be without a remedy must be a civil injury to the complainant's rights or interests, legal or equitable. And there are some duties equity does not attempt juridically to enforce, such as charity, gratitude, and kindness, and some wrongs in which equity does not interfere, such as violations of honor or of truth or of morals, involving no question of property. No question of property. In other words, there's where your rights coming in. And no question of pecuniary liability, money liability. But by any wrong done to a legal or equitable right will be redressed in equity. But any wrong done to a legal or equitable right will be redressed in equity, unless some other court has exclusive jurisdiction. People, I don't know if you see it, but we have uncovered something that's been trying to be hidden for probably the last 100 years. They've been covering this up. Now, I don't really want to say they. Really, it's us, because we're supposed to know our rights, but we don't know our rights. Now, we could blame them that they're dumbing us down by what they're teaching in schools, but who in the heck's responsible for saying no to what's being taught in school? There's not enough people, we the people involved in government, that know anything about government, to say no to what the servants of government are doing for us. And then we complain like sniveling little brats in playpens with dirty diapers when they don't change our diapers, when we think they should be changed. And it's all in our control. We are the government, and they know that. But through your silence, you have given it all away. And I don't like blaming these people that are the servants of government for what they're doing, because we're the one who put the final stamp of approval on it. So if you don't like the way the schools are being taught today, you don't like what's going on in the public today, you need to start doing something about it. Instead of writing letters to your congressman, you need to get involved in government. You need to know what the maxims are. You need to go in court, face a judge, and stand up for your rights, because you're the only one who can. Attorneys don't know one thing about rights. They know about statutes and codes. And you want to follow an attorney, you're going to follow an attorney to the guillotine. Now, attorneys are human also. But as an office licensed to have the at-law side and represent it, they can't represent your rights. They can only represent statutory lookalikes. So this maxim was originally intended to mean that in all civil cases within the scope of juridical action, where a wrong had been done or was threatened to be done, and a full, complete, adequate, and certain remedy could not be had in the common law, the remedy would be provided and enforced in the court of chancery, and all jurisdiction assumed necessary for that purpose. And in order to enable a court to adequately exercise this jurisdiction and to make its remedies effective without coming into conflict with the powers or processes of the common law courts, the plan was devised of compelling the defendant himself to execute the decree of the Court of Chancery. The plan was devised of compelling the defendant himself to execute the decree of the Court of Chancery by imprisoning him, if necessary, until he did so. Hence the maxims, equity acts upon the person. It might be said that on these two maxims hang all equity. In pursuance of these two maxims, the Court of Chancery has devised or adopted from the Roman. Now, I've kind of explained it's not really the Romans that came up with equity. Equity's been in the consciousness of God before the foundations of the world have been laid. Equity came from God, not the Romans. The Romans recognized it and utilized it. So from the Romans, or civil law, the following remedies, none of which existed at common law. Number one, specific performance of contracts. 2, injunctions to restrain the violation of rights, to stay unjust proceedings at law, to quiet title and prevent wrongs. 3, the re-execution of instruments lost or destroyed. 4, the reformation of deeds, contracts, or erroneously drawn by accident or mistake. And 5, the rescission and cancellation of agreements and conveyances obtained under circumstances of surprise, fraud, or mistake. And 6, the reopening of settlements and adjudication of complicated accounts. 7, the method of winding up all affairs of a partnership. And 8, marshaling of securities. And 9, the redemption and foreclosure of mortgages. The redemption and foreclosure of mortgages. Foreclosure of mortgages. 10, the partition of land between tenants in common. 11, the enforcement of trusts. The enforcement of trusts and fiduciary obligations. 12, the exoneration, contribution, and subrogation of securities. 13, the administration of estates. 14, the winding up of the estate of an insolvent debtors and insolvent corporations. 15, the enforcement of liens. 16, protection of persons and estates of infants. And we're all infants, and they're rewards of the court. Because we don't know the power, we don't know about the choices we can make, which gives us the power, really, because we're ignorant of our rights. 17, the establishment of a wife's equity. 18, the remedy by interpleader. 19, the perpetuation of testimony. And 20, the discovery and aid of legal proceedings. So thus, upon these two maxims, equity will not suffer a wrong without a remedy, and equity operates upon the person, was built that grand structure of jurisprudence called equity. And although by means of the improvements of the process of the courts, which is probably talking in reference to the 1848 merger of the procedures and the new reform procedures, so aided largely by the wise legislation, remedies for every civil wrong known to the courts have been devised and enforced. Yet if in the progress of civilization, if in the complicated network of mercantile business, if through the ingenuity and subtlety of the human mind bent upon schemes of personal and pecuniary advantages, or intent on devices for aggrandizement, and new remedies should be required to circumvent circumvention and to overcome the insidious and sort of Machiavellianism, the Court of Chancery, operating in obedience to this maxim, will devise a remedy adequate to the emergency and vindicate the beneficence of the capacity of its inherent powers to do justice in any case, and to right every wrong, however intricate the case, however great the wrong, or however powerful the wrongdoer. In other words, all you servants that think you're the running the whole show, and you're doing stuff rogues, and you're not doing justice. Don't think that justice won't, you're above the law, or you're above equity. No, you're not. Or however powerful the wrongdoer, even the king himself, because he's in by his cheat, which is wrong. The powers that lie dormant in this potent maxim will awaken as the necessities for their action arise, and they will be found commensurate with every necessity. It must not be forgotten, however, that this remedy may be fortified or lost by the party wronged, forfeited, 1, by some fraudulent, illegal, or unconscientious conduct in connection with the wrong he complains of, whereby his hands have become stained with iniquity, or 2, by having, through his fault or negligence, occasioned or contributed to the loss complained of. For when one of two persons must suffer, the loss must be borne by him whose act caused it. Or the remedy may be lost, 1, by the fact that the adverse party has an equal or superior equity, or 2, by laches or acquiescence, or 3, by subsequent contract or estoppel. Now that comes to 34 on the next maxim, and we're going to stop there. We're picking up on the Phelps book, which was the first one I read out of last week. And I'm going to pick up on that book on page 318 in the PDF, section 194, and that's page 278 in the book. So in the PDF, it's 318, starting off in section 194. That's section 194, page 318 in the PDF, or page 278 in the book. Section 194, and the maxim is, equity regards substance rather than form. I'm going to talk about that maxim tonight. Equity regards substance rather than form. This is a strong and leading maxim pervading the entire system of the consent practical application, practical application. To read that over again. This is a strong and leading maxim pervading the entire system of constant practical application. It is expressed in a variety of modes. quote, equity regards the substance or spirit and not the mere letter, or letter merely. Quote, equity looks through form into substance, unquote, and that's giving reference to number 2, footnote, and number 2 is a case. Quote, equity looks into the intent rather than to the form. That's footnote 3, and that's Pomeroy's equity jurisprudence, which we'll be going to later on in section 378. So it is the germ of the two enabling maxims, the enabling maxims. So Phillips breaks it down into two groups, the enabling maxims and the restrictive maxims. So two classes of maxims, and we're still going over the enabling maxims, and this is the second one in the enabling maxims. So it is the germ of the two enabling maxims which will be next presented in their order. Viz. Equity regards that as done which ought to be done, and imputes an intention to fulfill an obligation. Taken together, the three belong to the same group of primary maxims, all relating to rights. All relating to rights. Unless you're talking about rights, you've got nothing to talk about in equity. That's the differentiation between at law and equity. So all relating to rights and often combining to affect the same result. That's it for section 194 in Phelps. Now we're going to corpus juris. Corpus juris is the forerunner to corpus juris secundum. It's the older version, corpus juris, before they came out with corpus juris secundum, the later one. We're going to corpus juris on page 231 in the PDF in section 199. That's page 204 in the book. So page 231 in the PDF, section 199, or page 204 in the book. Section 199 starts out at section K. Equity regards substance rather than form. And number 1, in general. Another maxim of equity is that equity regards the substance rather than the form, or that equity regards the substance and intent, not the form. So there's an implication here that substance is intent. So there's no common between the two of those. It's substance and intent. This principle is well established and is expressed in more or less similar language in many cases. It's closely connected with and has been deemed a basis of that other maxim that equity regards as done that which ought to have been done. Section 200 now. Number 2, applications. A, in general. This maxim is as applicable at the present time as it was when it was first formulated. And these are all footnoted, and I would check these footnotes out. These would give you case citings that would support what they're talking about. But remember, we don't need the case citings because the case citings are not the source, it's the actual maxim itself. The maxims need no proving, they are the proof. So by force of its principle, equity goes behind the form of the transaction. Behind the form. So in other words, if there was a mistake in the form, talking about, say, the seal, equity is going to look behind the mistake, the technicality of the form. So by force of its principle, equity goes behind the form of the transaction in order to give effect to the intention of the parties. So equity is going to look through the form, or the technicality in the form, or the mistake in the form, and it's going to go to the intention of the parties, either to aid in act abortive at law, because formally defective. So the technicality of the seal, or the mistake in the seal, say for example, or say the oath, or whatever it was, that may be a defect. Equity is going to look through that and into the intent. So either to aid an act abortive at law because formally defective, or to impose a liability as against an evasion of a formal concealment of its true character. So it's going to aid against an evasion by a formal concealment of its true character. So if these debtor-creditor contracts are in a reality nothing more than concealment documents of the truth, and the truth being that these are all trust documents, equity is going to look through that technicality. Continuing on, in the construction of a written instrument, equity always attempts to get at its substance and to ascertain, uphold, and enforce the rights and duties, that's the equities, the rights and duties that spring from the real intention of the parties. In other words, it's specific talking about the relation. But that's what equity goes to, the first thing. It has to deem the nature and character of the relation first, because it wants to define what type of relation it is first. Is this debtor-creditor relation, or is this trust relation? Because it wants to establish the rights and the duties. So do we have a debtor-creditor contract, or do we have a trust relation? Continuing on, in doing so, while it is, of course, not charged with the words of the instrument, the court of equity will look into all the characteristics or circumstances under which it was made in order to determine the proper meaning of the transaction. Proper meaning of the transaction. It will do this not only to sustain a just claim, but to defeat an unlawful demand. To sustain a just claim, but to defeat an unlawful demand. So if you had a debtor-creditor contract demanding payment, that could be defeated if you had a just claim. So 201, Section 201B, mortgages. Common application of the maxim is in the cases of mortgages. Well, courts of law determine whether or not an instrument is a mortgage by considering its form and the closeness in which it conforms to prescribed standards. Equity often disregards these tests. Settles the question according to the nature of the transaction and intent of the parties. It is on the principle that a conveyance absolute on its face, but intended as security, is treated as a mortgage. Intended as a security. Intent. The whole equitable theory of mortgages, which considers them as creating merely a lien instead of a conveyance on condition, rests on this principle. Mortgage intended to cover property not in existence or after acquired is regarded in equity as an executory agreement or executory contract, which in effect per se is to transfer the present legal title, operates to impress a lien according to the agreement of the parties when the property is eventually brought into existence. So it's in the future. Executory contracts or executory agreements are executed in the future. They're not in existence yet. Conveyance hasn't happened. Then again, equity looks as what ought to be done as being done. Section 202, C, penalties. Through this maxim has been developed the jurisdiction of equity to relieve against penalties and forfeitures, and through its application, damages agreed upon as a result of a breach of contract may be viewed as a penalty and enforced only to the intent of actual injury. Actual injury. Must sustain an actual injury. That's footnoted for 79 if you wanted to check out. 79 is case citing where an injunction was granted against enforcing the penalty of a bond, the court saying the rule that where a penalty is inserted merely to secure an enjoyment of the collateral object, the enjoyment of the object is considered as the principal intent of the deed, and the penalty only as an occasional, and therefore only to secure the damage really incurred is too strongly established in equity to be shaken. So Section 203D, fraud. By application of this maxim, no matter what formal and proper proceedings surround a fraud, equity will disregard them all, if necessary, in order that justice and equity may prevail. Section 204, technicalities now. By applying this maxim, equity disregards mere technicalities. It will not lead its aid to one whose sole ground for seeking such aid is based upon a technicality. Technicalities in equity may be resorted to only when in no other way can the just rights of the parties be protected and preserved. Equity always wants to protect and preserve the rights or the equities between the parties. F, Section 205, F, other applications. In addition to these cases already mentioned, the maxim has been applied to work out equity in a great variety of other cases. And Section 206 starts the next maxim, another one we will discuss later on. I'm going to jump to the principles of equity, and I believe this is the let's jump to Gibson's. Big Gibson's on this screen here. All right, Gibson's, we want to start at Section 43, and that's page 63 in the PDF, or page 36 in the book. That's page 63 in the PDF in Gibson's, and picking up at Section 43 on page 36. Section 43, equity looks to the intent rather than to the form. Equity looks to the intent rather than to the form. This maxim is connected with the one that says equity regards that as done which in good conscience ought to have been done. For it is only by looking at the intent rather than at the form of the transaction that equity can treat as done which ought to have been done. Two maxims act together and aid each other, and with the further help of the maxim that equity imputes an intention to fulfill an obligation, a court of equity or a court of chancery will not only hold a resulting trustee or a constructive trustee liable as such, but will impute to him an intention to act as such. It will impute to him an intention to act as such, regardless of the form of the transfer or conveyance. The Court of Chancery will impute to him an intention to act as such regardless of the form of the transfer or conveyance. Regardless of the form or the technicality of the form or the sake of the form, it will impute an intention. Equity heeds not forms, but strives to reach the substance of things and to ascertain, uphold, and enforce rights and duties which spring from the real relations and the actual transactions of the parties. So, continuing on, looking to the intent rather than to the form, whenever a penalty is designed merely to secure the payment of a given sum of money or the performance of some act, equity will relieve the obligor from the penalty upon his paying the debt or the actual damages resulting from his default. So if a lease has been forfeited for non-payment of a rent and for the breach of some, but not all of the covenants contained in the lease, if the leaser can adequately compensated for the breach of the contract, equity will regard the forfeiture clause as merely a means of securing observance of the contract. And a court of chancery will relieve from the forfeiture. Also, looking at the intent rather than the form of the contract, equity will consider the forfeiture clause in mortgages and trust deeds as merely means of enforcing the payment of money contracted to be paid, and will relieve from forfeitures incurred upon the payment of the debt. Equity will also, upon parole evidence, which is verbal evidence, convert an absolute deed into a mortgage, and will in general, unless prohibited by some statute, set up and enforce the real contract of the parties, regardless of the form or of the want of form. Equity looks not at the outward form. Equity looks not at the outward form, but to the inward substance of every transaction, recurring to principles and disregarding ceremonies. So the ceremonies of the seal are not necessary. So that's why your judge's oath, ceremony of the oath, is not really necessary, even if it's defective. Maybe at common law it is, but not in equity. So I ask, how do you think the courts are operating when they take their common laws and just poo-poo them? And I ask you, which law or which form of venue is superior? The answer to that is equity. And if you have equity eyes, you will see why they don't honor the forms or the ceremonies or the technical mistakes in the seal, say, for example. Now you know why they operate the way they're operating, because they're not operating under common law. There is no common law. There's no money. Common law requires damages. Damages have to be paid in lawful money. There is no lawful money. You can't get damages. Therefore, you cannot get common law. So something had to fill the void. What was it? Trust. Trust required no consideration in exchange to be a trust. It's just a sole gift. Continuing on. Where there is substance for the court to act on and want a form will be disregarded, for equity regards substance and not ceremonies. This is true not only in adjudicating the equities of the parties, but it is true in matters of pleading also. Thus, if the bill makes out a case for relief and a want of formality, or for any misnomer of the bill, or any eccentricity or phraseology, will not defeat the complainant's right to relief on facts alleged and proved. I'll read that again. This is true not only in adjudicating the equities of the party, but it is true in matters of pleading also. Thus, if a bill makes out a case for a relief, any want of formality or any misnomer of the bill or any eccentricity or phraseology that is, let's say, lacking, will not defeat the complainant's right to relief on the facts alleged and proved. Now, note it's facts alleged, and then you must prove them, which comes up to the legal maxim says, he who makes the claim must prove the claim. If you don't prove the claim, you don't have any claim. So any facts alleged have to be proved. If you prove the facts, then the eccentricities or the phraseology and any defects in the complaint, equity is going to look right through to the intent, to your right to relief. Continuing on. So if the necessary parties are before the court, and a case for a relief is alleged and proved, the fact that the parties are made complainants who should have been made defendants, or vice versa, will not prevent the court from decreeing according to the equities of the parties. And this is so even when persons under disability are to be affected by the decrees. The fact that the proper facts are alleged and the proper parties before the court is substance. The manner of alleging the facts and the position of the parties in a suit is ceremony. Substance and ceremony, which is what equity is going to look through. Next paragraph. No one is presumed to give something for nothing. That's the presumption. Nobody gives something for nothing. Although that could be. It could be a sole transaction under a relation for trust. So no one can, in reason and conscience, expect to receive something for nothing. So that's a presumption that has to be met. Trusts operate in a different realm. Even equity is going to enforce that realm. And remember, under the exclusive head of equity, that first division of the three heads, that first division in the first head of equity, the exclusive jurisdiction, that division is solely trust. All by itself. It has its own little special division under the first head of exclusive jurisdiction in equity. The second one would be mistake, fraud, omission, and the third one would be specific performance. So actually, specific performance would be on a contract, but if you don't have contracts today, then actually that one's moot. So continue on. Whenever a person parts with a consideration, he is presumed to intend to acquire whatever that consideration pays for. That's if it was a payment. If it was for the purchase of something. But again, I say trusts are solely different. Continuing on. And he who acquires the legal title to property for which another's money has paid is bound in reason and conscience to hold it subject to the orders of the person whose money went into it. Was this a payment under debtor creditor or for a purchase? Or was this a gift under a special deposit order, which pertains to trust? So the duties between the parties would be solely different because the relation is different. But what was the intent of the parties? Since in a trust, there is only one party that sets everything up, that's grantor. In a debtor-creditor relation, it's two parties, debtor and creditor. Under trust, there's only one intent, the intent of the grantor. Under debtor-creditor, there's the intent of both parties, the debtor and the creditor, the intent of both of them. Continuing on, reduced to that last analysis, the property acquired by another's money is only that money in another form, and property conveyed without receiving another's money therefore continues, in equity, the property of the conveyor. See how they look at it? Reduced to the last analysis, the property acquired by another's money is only that money in another form. Money in another form. How can that be? There must be a conversion here that equity looks at right before your eyes. And property conveyed without receiving another's money therefore continues in equity the property of the conveyor. Hence it is the passing of the consideration and not the form of the contract that in equity passes title. And whatever the form of the transaction, if no consideration passes, in equity, no title passes. So you'd have to prove that there was consideration. But they do have consideration in the at-law side, the public side today, because they deem debt to be the consideration. We're using debt as money. So in that realm, it's just as real. But we can't cross and commingle because the actual at-law money is held in trust, and if we crossed it from the private side and the public side, that would be a breach, and you'd get hammered. So you can't bring in the private-sidedness in the public because you've heard it before. That would be too much truth. That would be breach. That would be commingling of the trust. And the statutes and codes are in place as a wall, keeping the two separate. Public and private, separate. Separated by statutes and codes. So it's a tutor going to beat you up if you try to commingle and breach the trust. It has to remain segregated. You can't commingle them. So you can't argue the fact that there is no lawful money on the at-law side because they won't hear that because that's private-sidedness. You'll get put up for a psychological evaluation. So that to prove it at law is practically impossible, I would say. But I wouldn't even go in at law and argue that. I'd come into equity and argue the trust. I'm not going to acknowledge the debt on the at-law side. In fact, let them win at the at-law side. If equity is going to look at that, the law, let them grant that at law, but yet let's argue in equity, and equity is going to say, okay, you got all the property, but you still got to pay your brother's bills. It wouldn't be fair if you left him penniless and took everything. We may get to that later on in another maxim, but we talked about that briefly last week and some previous shows prior to that. That came out of Snell's book also, where the example of the elder had the right per the will on a death of a decedent to inherit the total property because it was by will. And the younger brother got nothing. Now that was at law, and that was perfectly legal. But then equity said, all right, we're not going to go in there and touch the decision at law, but we're going to do something because we don't think it's fair and just and right that you leave the younger brother penniless. You must pay his debts. And the model is that in reality it's the United States being the elder brother and the younger brother being we the people. So, hence, it is in the passing of the consideration, not the form of the contract, that in equity passes title, and whatever the form of the transaction, if no consideration passes in equity, no title passes. Section 44 talks about another maxim. Let's see if I can find Pomeroy's here. Okay, Pomeroy's, it should be sometime, because we did last week, we did the PDF page was 768, where we started last week, so it's got to be the one after that. Yes, because we started at that one. That was the equity will not suffer a wrong without a remedy. Okay, we found it. It's on page 693 in Pomeroy's in the PDF. Page 693 in the PDF. Page 626 in the book. And it's section 378. Section 378, which is in the PDF, it's 693. Page 626 in the book. Maximum equity looks to the intent rather than to the form, beginning in section 378. Section 378, its meaning and effect. The principle involved in this maxim, which is one of the great practical importance, pervades and affects to the greater or lesser degree the entire system of equity jurisprudence, and is inseparably connected with that which forms the subject of the preceding section, which was the other maxim that we went over last week. In fact, it is only by looking at the intent rather than at the form that equity is able to treat that as done which in good conscience ought to be done. You see how all these maxims really interconnect, and they all are formed one. They all are like one. They're all connected together. They all interrelate and work. They're all working as one. Continuing on, in explaining the meaning and operation of the one maxim and the effects produced by it, I have necessarily described the significance and workings of the other. The two principles act together. They all act as one and aid each other. It is by their universality and truth that much of equity jurisprudence is particular and distinctive, in contrast with the law as it's been developed. Equity always attempts to get at the substance of things, or really to the truth of the matter or the heart of the matter, and avoid all the technicalities and frivolousness. It wants to get to the source of the thing. Equity always attempts to get at the substance of things and to ascertain, uphold, and enforce the rights and duties which spring from the real relations of the parties. So let's get to through the fraudulent concealment documents, and let's get to the real truth of the matter, because there really is no money that we're using that's lawful. So it should go through that real, or through the form and the substance into the real, determine the real relations of the parties, that it's really all trust. It will never suffer the mere appearance and external form to conceal the true purposes, objects, and consequences of the transaction. This principle, looking after the intent and giving it effect, was fully recognized and distinctly formulated at an early day. In one leading case, Lord Chancellor Macclesfield said, quote, "The true ground for relief against penalties is from the original intent of the case, where the penalty is designed only to secure money and the court gives the party all that he expects or desires," unquote. In another case, Lord Thurlow said, quote, "And the rule is where the penalty is inserted merely to secure the enjoyment of a collateral object, the enjoyment of that object is considered as the principal intent of the deed, and the penalty only as occasional." Quote. It is true that in both of these cases, the courts are dealing with penalties, and the principle stated in them is of universal application, that equity always seeks for the real intent under the cover of whatever forms and appearances, and will give effect to such intent unless prevented by some positive and mandatory rule of the law. Now, that's a good question. Do we really have actual law today? No, we don't. We have statutes and codes. The statutes and codes do not apply to equity. Only law does. Section 379, legal requirement of the form. Now, here's where we're going to come into where it is going to blow away some of you common law people out there. Section 379, the legal requirements of form. The ancient common law paid great differences to matters of pure form, as for example in the symbolical process called livery of season, by which alone a free estate in land could be transferred. Although such observances have long been abandoned, and still the present rules of law permit the property in land or chattels to be created, transferred, or acquired only in certain defined modes, by means of certain specified acts or events which constitute all the possible legal titles. There was also one characteristic feature of the ancient law, that it held contracting parties to a most rigid observance of all the stipulations of their valid agreements. Performance to the very letter of the very covenant or promise was the inflexible rule. Still another purely formal element of the law considered to the extreme importance which it attached to the seal. The monumentous and often most arbitrary result which followed from the presence or absence of the seal and its effect upon private rights of property and of contract rendered many of the rules of the early law particularly rigid and almost barbarous. The equity jurisprudence in all these respects differed widely from the common law, and from the very beginning it was distinguished as the entire absence of the arbitrary and purely formal incidents. And what they have now in such great degree disappeared from the law itself, which has in consequence become more enlightened and more just and more wholly due to the gradual adoption of equitable principles, to its acceptance of doctrine originating in the Court of Chancery. Next section, 380, is the source of equitable doctrines of property. I shall now state by way of illustration some of the most important instances in which the principle has been applied and the settled doctrines of equity jurisprudence which are immediate results. First, by far the most important consequence of the principle reaching through the large part of the equity jurisprudence is found in every species of equitable property, estate, or interest, and of equitable lien, so far as it exists from the doctrines of equity, but not by those of the law. Well, as shown in the last section, all these purely equitable property interests and liens arise from the direct operation of the grand principle. Equity treats that is done which in good conscience ought to be done. Still, a maxim could only produce such effects in consequence of other principle, that equity looks at the intent rather than at the form. Every kind of equitable property or interest analogous to the property and external acts or events preemptorily required by the law in order to the existence of any property are wholly wanting, so that if the external form of the transaction has been regarded, no property, no right resembling property could possibly exist. It is by disregarding these forms and looking at the real relations involved in the actions of the parties, at the real substance and intent of the transaction, that courts of chancery has built up its magnificent structure of equity property, estates, and proprietary interests. The same is true of a large part of equitable liens. The external form is either an assignment, which at the law is wholly nugatory, or an executory agreement, which at law only creates a mere personal right of action. At most, a claim for damages. But equity, going below this mere appearance and seeing the real intent, gives effect thereto by treating the assignment or the agreement and creating a definite lien upon specified lands or chattels or securities or other kinds of funds, as the case may be. The discussion of the last preceding section fully illustrate and demonstrate the correctness of this conclusion. To the next one, 381, penalties and forfeitures. An inflexible doctrine of the ancient common law that penalties must be held to strict performance of all stipulations of their valid agreements, and that is unless the agreement was wholly void from it being illegally or an illegality. Whenever, therefore, a contract provided for a penalty or a forfeiture, the full penalty or forfeiture would be enforced by court of law without the slightest regard to the amount of damages actually sustained by the obligee or promisee from the default. The action of equity in such cases affords a most striking illustration of the principle which we are discussing. It was at the first confined to contracts for payment of some definite sum of money in which the debtor also bound himself, and in case of his default, to pay a larger sum by way of penalty, or that the creditor might become absolute owner of a specific property of a larger value by way of a forfeiture, where the intent was plain that the penalty or forfeiture was added simply as a security for the payment of the real indebtedness. Now let's take a minute and explain this a little bit better. That today in a mortgage foreclosure, there's always the clause in there that says that they have the right to the default deficiency judgment, So if they sold the house, the courthouse steps for $100, and this house was worth $100,000, say, it would be $100 less the $100,000 that the defendant would owe still. That would be the deficiency, and it would come back in as a penalty for this forfeiture of the contract. Now, equity is going to look through that and say, no, that's not right. You took the house, and equality says that's equity. You can't take the house, which the whole deal was premised on, and then turn around and say, sell it for such a small pittance, and then turn around and get me for the deficiency of it. At law you can, but not in equity. To continue on, this action of equity with reference to pure money contracts was soon extended to other agreements in which a party undertook to perform some act, to render some service, to transfer some property, to surrender some right, and a penalty or forfeiture was added. But remember, the penalty or forfeiture was added only as a mere security to push you into doing what was supposed to be. The general doctrine was finally settled that whenever a penalty or forfeiture is instituted merely to secure the payment of money or the performance of some act or the enjoyment of some right or benefit, equity regards such payment, performance, or enjoyment as the real and principal intent of the instrument, and the penalty or forfeiture is merely an accessory, and will therefore relieve the debtor party from such penalty or forfeiture whenever the actual damage is sustained by the creditor party can be adequately compensated. Or let's put it this way, proved. Proved that they had actual damages sustained. Not just presumed. Continuing on, the application of the principle in such cases and the relief against penalties or forfeitures must always depend upon the question of whether the compensation can or cannot be made. If the principal contract is merely for the payment of money, there can be no difficulty. The debtor party will always be relieved from the penalty or forfeiture upon paying the amount due and interest. So that is fair. If you pay what is due and any interest that was caused, then the penalties and the forfeitures are wiped out. They don't apply. If the principal contract is for performance of some act or undertaking and its non-performance can be peculiarly compensated, the amount of such damages will be ascertained and the debtor will be relieved upon their payment. But the principal in this scope of its operation is not confined to agreements. It has been extended also to prevent the forfeiture of tenants' estates under a clause of re-entry for the non-payment of rent or for a breach of some, though not of all, covenants contained in the lease, and to prevent the enforcement of a forfeiture for non-performance of conditions subsequent. As equity will often interfere with this manner to relieve against a penalty or forfeiture which perhaps should be entirely valid at law, it follows as a matter of course that the Court of Equity will never, by its affirmative action or by affirmative provisions of its decree, enforce a penalty or forfeiture, or any stipulation of that nature, but always leave the party entitled to prosecute his claim in a court of law according to legal rules. That's what they're doing. Coming at you under the legal rules and getting you for the deficiency on it. but you're not bringing up any counter-equitable claim, which is superior. Talk about next one, 382, the mortgages. Another most remarkable application of the principle from which arose an entire department of equity jurisprudence was the equity of redemption, the equitable right in the state of a mortgagor after legal title of the mortgagee had become absolute by non-performance of the condition. Looking at the real intent of the parties, considering the debt as the substantial feature, the conveyance as a security only for its payment, the Court of Chancery declared that a breach of condition was in the nature of a penalty, which ought to be relieved against, and that the mortgagee had an equity to redeem on payment of the debt and interest, notwithstanding the forfeiture at law. And furthermore, it is the right of redemption that could not be given up, waived, or departed or parted with by any stipulation or covenant in the deed. The whole system of equity jurisprudence prevents no finer example of the triumph of equity principles over the arbitrary and unjust dogmas of the common law than this. So the nature of the penalty, which boils down to all of at law in its nature and its character is inferior to equity in its character and its nature. Equity is the source of the at law. It's like, how can the grantor, who is the creator, how can the at law side talk back to the creator who makes the law per the trust? That is the law. The indenture or the will of the intent of the grantor. Well, if you got a debtor credit contract, it's enforceable solely at law, and you will lose because you don't have any claim because you're in a breach of contract. And the only thing the Court of Equity wants to know and see is when you're going to make the payment. If you can't make the payment, there's a foreclosure. Because the payment required under the debtor credit contract was by credit or FRNs, which is debt. So next section, 383, defect of the seal. Here's the big one that blows the bottom of the common law boat out. Glug, 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 glug. The important part played by the seal in the early common law and the intensely technical and arbitrary effects produced by it according to the legal rules are too well known to require any statement. Equity has applied its principle of looking at the intent rather than the form in some instances by treating the presence of the seal as a matter of no consequence. Let me read that again. Equity is applied to the principle of looking at the intent rather than the form in some instances by treating the presence of the seal as a matter of no consequence, as producing no effect upon the rights and duties of the parties. It has no effect. So any technicalities in the defect of the seal has no effect upon the rights and duties of the party or the intent. In other instances, by disregarding its absence, where such absence would be fatal at law. So all you common law people that base your justification of your actions based on, or their actions, based on the fatality of the defect of the seal at law, and you wonder why, and you claim and blame the judges and the courts that they are railroading you and they're ignoring and they're breaking the law. No, they're not. They're not on the at-law side. They're in equity. You get it? Open your eyes to equity and look at it as being with equitable eyes, and you'll see why they don't honor that. Although the common law in theory required a valuable consideration in order to render any agreement valid and binding, yet it declared that a seal was conclusive evidence of such a consideration, and under no circumstances would it permit this arbitrary effect to be removed by evidence showing, no matter how clearly, the absence of any consideration due to the ineffect of the seal. Continue on. Equity disregarding such form and looking to the realty always requires an actual consideration and permits the want of it to be shown, notwithstanding the seal. Notwithstanding the seal. Notwithstanding the seal. And applies this doctrine to covenants, settlements, and executory agreements of every description. Another application of this principle is still more striking and just. The early common law attributed such an efficacy to the seal that a written obligation under seal could only be discharged by an instrument of the same high character, that is, by a writing under seal. A subsequent written but not sealed agreement revoking or modifying the terms of a prior specialty or a parole accord or even payment in full unaccompanied by technical release or any other matter in passe could not alter the rights and liabilities arising from the sealed instrument. It could still be enforced against the obligor by an action at law, and as such acts furnished to him no legal defense whatever. Such a doctrine was abhorrent to the spirit of equity, paying no attention to the form of the transaction as if the act done was, in substance, a discharge. The court of equity treated it as equivalent in its effect to the technical release and would relieve the obligor in any manner required by the circumstances of the case, even by a decree for a delivery up or cancellation of the sealed undertaking. One most important consequence of the principle has been the seen in the legal and equitable liabilities of securities or sureties, where the surety's contract is under seal. He is not, by the strict common law rules, discharged by any conduct of the creditor towards the principal debtor, by an alteration of the principal debtor's undertaking, or by an agreement with the principal debtors extending his time of payment, since the surety's liability could only be discharged by an instrument under seal. Equity was therefore compelled to interfere under these circumstances and relieve the surety by restraining the creditor from suing at law and compelling him to surrender and cancel the guarantee. There are other instances of the disregard shown by equity to the presence or absence of the seal in determining the rights of parties. If, for example, an instrument from its imperfect execution in wanting a seal, in other words, it would lack a seal, is inoperative at law as a conveyance or as a mortgage of land, equity may treat it as an agreement to convey or to give a mortgage, and is therefore creating an equitable interest or interest in or lien upon the land. Next, 384, other special instances. Other doctrines of equity which, at the strict terms of contracts and somewhat arbitrary rules of law relating thereto, are disregarded in order to promote the ends of justice, and may also be referred, at least partly, to this principle of looking at the real intent rather than at the form. It is a mere illustration. I mentioned the doctrine which generally treats as joint and several of the rights and liabilities arising from the contracts which are regarded by the law as strictly joint, and the many important consequences which flow from this difference. Enough has been said, however, to show that the principle is one of a very extensive application, and from it, either alone or in conjunction with others, are derived large portions of equity jurisprudence. We're going to stop there and pick up finishing this maxim. We've been going over the maxims, and we went over the last maxim last week. That equity regards that as done, which ought to be done. So this is the, let's see, which book is this one? The Phelps book, I believe. Section 205, where number 3, it said that the Equity regards as which is done which ought to be done. As otherwise expressed, equity considers that as done which was agreed to be done. In either mode, this maxim is an expansion or development of the maxim just considered that equity regards substance rather than form, and we've gone over that one. To a certain extent, both maxims cover the same ground. The doctrine of equitable mortgages, as already suggested, may be ascribed to the combined operation, and indeed is frequently attributed exclusively to the maxim now under consideration. The same may be said of the equity of redemption. The doctrine of conversion is another instance in point. Number 206, conversion. Conversion is an assumed change in the nature of property by which, for certain purposes, real estate is considered as personal and personal estate as real, and is transmittable and descendable as such. In such cases, the first step is to find in the will or other instrument of trust an expression of an intention, and that's italicized there, intention, that the money shall be invested in land, or that the land shall be sold and turned into money. When once that intention is sufficiently expressed, read that again, once that intention is sufficiently expressed, the accidental circumstances that the money has in fact not been laid out in land, or land in fact not sold, can have no effect in equity, which regards that as actually done which ought to be done. Now section 207, executory contracts. On the same principle, an executory contract for the sale of land will be regarded in equity as if actually executed. Let me state that again. Upon the same principle, an executory contract for sale of land will be regarded in equity as if actually executed. In other words, if you have an executory contract that's sometimes supposed to be completed in the future, but yet it hasn't been done, once the contract signatures are on the contract, equity looks at it as done, it's completed, it's tetelestai, finished. It's been actually executed under equity. Continuing on, and as an operation to transfer the estate from a vendor to vest it in a vendee. By the terms of the contract, the land ought to be conveyed to the vendee, and the money ought to be paid to the vendor. And equity looks at that as being done. On the principle which considers that as done which the parties have contracted to do, the vendor will be treated as a trustee for the purchaser of the estate sold, and a vendee as a trustee for the vendor of the purchase money to be paid. The vendee is in fact considered as the owner of the land, and although the legal title may still remain in the vendor, he holds it merely as trustee for the purchaser, with a lien on the estate as security for the unpaid portion of the purchase money. Practical results of this doctrine are important to both parties. In the individual between the contract and the deed, the vendee, even although none of the purchase money has been paid, must bear any loss, such as by fire, his interest being an insurable one, which may happen to the property, and is entitled to any benefit which may accrue to the estate. Next, section 208, assignment. Assignments of truces in action, originally void at law, were always recognized and enforceable in equity. And assignments of property, not in esse, but to be acquired in futuro, void at law now, are held valid and binding in equity. An assignment for value for the future property operates in equity by way of agreement, binding the conscience of the assignee, and so binding the property from the moment when the contract becomes capable of being performed upon the principle that equity considers as done that which ought to be done. Modern tendency of the courts of law is towards adopting this equitable doctrine. So slowly the courts have evolved into that and comported themselves to equity, which a court of equity was doing all along. Now, the same principle applies to the case of deed made before the grantor has acquired title. Though the conveyance of an expectancy as such is impossible at law, the operation of this maxim enables it to be enforced in equity as an executory agreement to convey if sustained by sufficient consideration. Assignment for value of a fund to be created as from a claim in litigation stands upon the same footing. An assignment and delivery as collateral of certificates of stock not perfected by transfer on the books of a corporation passes the equitable title. But a married woman's assignment does not bind her after acquired separate estate. The specific performance cannot be decreed of an agreement to convey property which has no existence or to which the defendant has no title. An order drawn from the whole of the particular fund amounts to an equitable assignment, but the partial order does not, in absence of an express or implied acceptance. These are all footnoted too with case cites. Footnote say 6, Gibson versus Finley. Next section, 209, fraud. Foregoing examples deal mainly with things agreed or directed to be done, and they are very far from exhausting the enabling power of this maxim, which also deals with things which ought to be done. It has already been suggested that this and the next maxim, equity imputes an intent to fulfill an obligation, are both offspring of the maxim substance rather than form. They overlap the parent maxim to the certain extent, but they go further. They dig below the crust of form, below the subsoil of intent, and strike the bedrock of conscience. They inquire that intent an honest person should have formed and demand adjudication upon that basis. They treat the fraudulent intent as if void and non-existent, and by enabling judicial control of the act, make the party behave as if he were honest. The principle is that a person is not allowed to derive any advantage from his own wrongdoing, and that in order to prevent this, the Court of Equity will treat him as having done that which ought to have been done. Equity will not only interfere in cases of fraud to set aside acts done, but will also, if acts have been, by fraud, been prevented from being done, interfere with it and treat the case exactly as if the acts had been done. The resources of the maxim referred to in the promotion of justice by counteracting fraud are particularly unlimited, practically unlimited. Next section, 210, constructive trust. Constructive trust may arise under contract and, in an instance, have already been given under the head of executory contracts and assignments. It may also be raised independently of an intention of the parties by actual or constructive fraud, including acts in violation of fiduciary obligations. In all these cases, a trust, ex malefactio, where the party holds the legal title to the property under such circumstances that in conscience he ought to convey it to restore it to the real owner, he'll be treated in equity as if the conveyance had been made, so far as the power of the court can reach. That is, to the extent of holding him a trustee for the person beneficially entitled. Next section, 211, relation. Doctrine of relation, and we're going to maybe talk about that after we finish these maxims. Doctrine of relation also proceeds from this maxim, which the thing considered as done shall relate back to the time when it ought to have been done originally. The issue of a land patent relates back to the inception of the patentee's right. The title of administrator relates back to the death of the intestate, and the title of an insolvent trustee or assignee in bankruptcy to the commencement of the proceedings. Similarly, by statute, mechanic's lien relates back to the commencement of the building and a condemnation to the time of the forfeiture. A creditor who comes in and establishes his claim under a creditor's bill becomes plaintiff by relation to the time of the filing of the bill, and when the statute of limitation is set up, the intervening time will not be counted against him. Some of the instances cited also illustrate the reaction of equity upon law, or the impression made by equitable principles upon the march of judicial and statutory legislation. So long ago as 1806, in an action of ejectment, it was said by the court, Chase C.J., quote, the relation of the patent to the certificate so as to overreach mesne grants is founded on the principle of equity and is a fiction of law introduced for the attainment of justice and to prevent circuitry of action, the court doing that which the court of equity would effect. Next, section 112, capacities. In the case of several capacities of the same person, such as a trustee or executor or guardian and administrator or the like, the respective capacities will be regarded as if distinct individuals, and possession will be attached to that capacity in which of right the subject ought to be held or the act performed. Of this doctrine, analogous to retainer or transfer by operation of law, the most interesting practical result to sureties on the official bonds of the defaulter holding these double capacities is the release of one set of sureties at the expense of the other, or at the expense of the city key trust if unsecured. The origin of the doctrine, which is well settled at law as well as in equity, is distinctly attributed to the maxim that equity regards that as done which of ought to be done. A trustee holding a double capacity cannot act ambiguously and afterwards take advantage of the doubt and claim he acted not as trustee but in some other circumstance or character. Next, section 213, other instances. From the same maxim obviously follows the rule which regard as done at the time in which it ought to have been done. Thus, trustees will be charged with interest from the time at which it was their duty to invest, although no interest may have been actually received. The property will be considered as converted from the time at which it ought to have been converted. So it like reaches back in time and pulls it forward into present time. One way of looking at it. A mortgaged railroad company is liable to account for its trustees for the earnings from the time a surrender of possession ought to have been made upon proper demand. An amendment which ought to have been made to conform to the pleadings of the evidence may be treated as having been made. Reference has already been made to the rule that a court of equity will ratify that when done, which it would have ordered to be done. An implied promise is a fiction which the law raises to express the equity of the situation, is a promise which, though not made, ought to have been made. 214, next section, qualification. This maxim is not universally true. In cases depending on contract, it applies only in favor of parties entitled to enforce a contract or those in privity with them, and not to mere volunteers or strangers. It is never applied to the prejudice of innocent parties who have acquired intervening rights, and operates only in favor of one who holds the equitable right to have the thing done as against the one upon whom the duty of doing the thing has devolved. And that brings in the doctrine of relations, where it's the primary or the original rights that can be enforced. If there's no nexus with the primary or original rights, then there is no privity. Next section, 215, probable origin. Reference has been made to the obscure origin of maxims. Most of them doubtless have generally expanded from the slender beginnings. The exigencies of some special case may have suggested a solution of the difficulty which happens to fit other difficulties occurring under widely different circumstances. We may very probably, an example of this before us, in the Institutes of Justinian, we find laid down a special rule applicable in terms only to the particular case of the suretyship. And there's the next Roman word here, Greek, Latin word, if I can get that one. Forticu scriptum sit quasi actum viditur extium actum. Quote, is a general rule that all the cited juridical stipulations, contracts of suretyship, that whatever is alleged in writing is to have been done, is presumed to have been actually done. Therefore, if a man in writing confesses that he has become a fide juicer, it is presumed that the necessary forms were observed. Without having at hand the means of tracing the successive stages of development, it is easy to find that the narrow rule applicable in terms only to the special case of suretyship, the embryo of the broad principle referred to. Next section, 216. Equity imputes an intention to fulfill an obligation. Leave this book now, pick up in another book. We are going to leaving the Phelps book, and we're going to go to Corpus Juris. Go to the page 227 in the PDF. That's section 190. That's page 200 in the book. CJ next. Not Corpus Juris Secundum, CJS, that's CJ. Okay, page 227 in the PDF, section 190, and it's page 200 in the book. J, equity regards as done which ought to be done. Number one, in general. Maxim that equity regards as done which ought to be done has been said to be equity's favorite maxim. The principle of this is the basis for many forms of equitable relief. It has been said to be the foundation of all distinctively equitable property rights, estate, and interests. Very interesting. It is said to be the foundation of all distinctively equitable property rights, estates, and interests. It has no application in action at law. Let me repeat that one again. It has no application in actions at law. Equity does not appear at law. And you wonder why you're getting beat up over there. The broad meaning of this maxim is that where an obligation rests upon a person to perform an act, equity will treat the person in whose favor the act should be performed as clothed with the same interest and entitled to the same rights as if the act were actually performed. Is closely connected with the properly derived from the principle that equity regards intent and substance rather than form, which is also an established maxim of equity. And it's making footnotes to number 12 and 13. 12, probably cases. Yes. Anything under there other than the cases. 13C Infra, section 199. So continuing on, and regarding as done which ought to be done, the rights of all the parties will be preserved and enforced in strict accordance with their original intention and agreement, always regarding the substance and not the form of the transaction. Always regarding the substance and not the form of the transaction. Section 191, number 2, applications and limitations of Rule A in general. The maxim that equity regards as done which ought to have been done is applied only for the purpose of doing equity between the parties. In order to establish equities between the parties, number one, the first thing you have to do is establish the relation. Relation is the key to the whole thing. If you don't establish relation first, you can't have the proper equities between the parties. And that's what's happening today. The proper equities between the party have not been established because the proper relationship has not been expressed. What's been expressed is a debtor-creditor relationship by all the evidence and your signatures on the documents, making them valid, making them, and you're doing acknowledgement of them by implementing them, and you're never expressing any kind of trust. and you have no records to support a trust. So when you come into the at-law court where that's going to be heard, because all debtor-creditor contracts are heard under at-law, and there's no equity there, so how can you talk about your substantive rights? You don't have any rights over there. All you have is statutes and codes, the obligations for those. Starting again, the maximum that equity regards as done which ought to have been done is applied only for the purpose of doing equity between the parties. It will not be employed to confer upon them an advantage greater than that it would have received had the obligation been performed. It cannot be invoked to create a right contrary to the agreement of the parties, or in disregard of the essential conditions for which the parties have stipulated. The word ought in the maxim imports an equitable obligation, not one purely moral or something merely advantageous or desirable. Equitable regard as done only such things as rest upon the obligation which equity would directly enforce. The thing which is looked upon as done, which ought to be done, not that which might be done. The maximum affords no ground for enforcement in equity of an invalid contract. In order to prevent a party from profiting from his own wrong, he will be deemed to have done that which he is bound to do. Equity will not regard as done an essential thing that is beyond the power of anyone to do. The maximum operates in favor of such person only as being parties or privies having a right to demand performance, and it being not be enforced in injury of innocent third parties. In actions involving contracts as available to parties thereto, and may be waived by them, it will bind a purchaser, transferee, or assignee with notice. Under the express provisions of some statutes, and the maxims have been indulged only in favor of him who, and against him whom performance is due. To avail oneself of the benefit of a maxim, the right must be asserted in apt time and diligently prosecuted. Next section, 192. B, equitable conversion. One of the oldest and most familiar applications of this maxim is the doctrine of equitable conversion. You want to convert something, equity is the one that does it. So, where a will, deed, or contract directs lands to be converted into money, or money extended for land, the courts, in pursuance of the maxim, will treat the property as having that character which, by the terms of the instrument, it was directed to have. Next section, 193. C, equitable mortgages. The doctrine that equity regards as done that which ought to have been done is often advanced as the basis for the equitable mortgages. Next section, 194. Contracts to convey, under D. The maxim finds a most important application in respect to contracts for the conveyance of real property. Chance reviewing such agreements as though the obligations imposed upon them had been met treats the purchaser or contractee as the owner of the land from the time of making the contract and as trustee of the purchase money for the vendor, while the vendor in regard as holding the land in trust for the purchaser until time when the conveyance is finally and formally made and a security for the purchase money. So really all along, here we are thinking we're doing contracts, we're doing trusts. It's all about trust. There are no contracts. They're all executory contracts done on trust, where we got two trusts happening at the same time zone per the contract. One owes a duty to the other one, and vice versa. In accordance with this principle, such a contract passes to the heir or devisee or of the purchaser or contractee, since the contemplation of equity is an interest in real estate. As owner, the purchaser will be protected against subsequent purchasers and encumbrances, except bona fide purchasers for value without notice. As a general rule, he is entitled to any benefit or increase in value of the property which may accrue, and must bear any loss, injury, or depreciation which may occur. Next section, 195, E, defective acts, instruments, and records. By force of the maxims, defective instruments are supplied. Thus, conveyance is defectively executed or enforced, though the maxim has been held to have no application to errors and omissions in the records of judicial proceedings. By virtue of an act requiring for the validity of an order of the court has been held valid where the order had not been made, but might have been, of course. Next section, 196, F, time of perfection, or time of performance. By application of this principle, act agreed to be done or directed to be done or considered as done as time agreed or directed to be done. The principle leads its force to working out justice by fixing rights as of the time when the obligation first accrued rather than according to circumstances subsequently arising. Thus, a chattel mortgage on after acquired property has been held to attach the property in equity as soon as it is acquired, and hence is superior to the subsequent attachment. Next section, 197, G, fraud. Equity will apply the maxim in order to defeat that which would otherwise operate as fraud, and trust will arise in vindication of right. The maxim is applied to protect the wife from a violation of fiduciary duty owing by the husband to her, and to prevent a statute designed to prevent fraud from being used as an instrument for the accomplishment of fraud. 198, H, other applications. The maxim also has been applied to in a variety of other cases where some act necessary to the rights of the parties have been omitted. The principle leads its force to the establishment of liens and charges which could not have been sustained at law, and accomplish the discharge of indebtedness. In the case of subrogation, to protect the rights procured by a diligent creditor, to establish equitable assignments, and to aid the doctrine of contribution, to create the presumption of parties to ancient deeds, which deeds did what the deed contemplated. The maxim has also been applied to the court considered that as not having been done which ought to have been done. The maxim does not authorize a court to assume without evidence that a penalty for any kind of delinquency or wrong has been inflicted by any tribune. The next one, 199, is one we went over last week. Equity regards substance rather than form. Now, let's jump to Pomeroy. Or let's leave him for maybe last. Let's do Gibson. Gibson, page 65 in the PDF, and that's section 45, and that's also page 38 in the book. Let's do Gibson. My friend Gibson. Treatise on Suits and Chancery. Everybody better have that book and read it cover to cover, every word. That's page 65 in the PDF, section 45 on page 38 in the book. The short one. Section 45. Equity regards that as done which ought to be done. A court of chancery ought to be because is, becomes is. So I'll start it again. In a court of chancery, ought to be becomes is. Who argued the word is a while back? Anybody remember? Wasn't that some president argued the word is? Maybe he knew something maybe everybody else didn't. Is means ought to be. And whatever the party ought to do or ought to have done in reference to the property of another will ordinarily be regarded as done, and the rules of the parties will be adjudicated as though, in fact, it had been done. This maxim is far-reaching in its operation, and full of benefit consequences. The doctrine and rules creating and defining equitable states or interests being, in a great measure, derived from it, is between the party by whom, the party for whom, an act ought in good conscience to be done, or to have been done, equity will consider it as done. For the purpose of reaching exact justice, equity will frequently consider that property as assumed certain forms which it ought in justice to be stamped, or the parties have performed certain duties which they in justice ought to fulfill, and will regulate the ownership of estates and interests accordingly. In such matters, another maxim is sometimes invoked. Equity regards the substance, not the form of things. So they work in conjunction. The last maxim we did 2 weeks ago. So this maxim and the other maxim is sometimes invoked. Equity regards the substance, not the form of things. Thus, number one, the vendor of land is regarded in equity as the owner of the purchase money, and the vendee is looked upon as the owner of the land. Two, the purchaser of the possible interest in land becomes the equitable owner of the interest. Three, the sale of the chattel, not yet in existence, or not yet the property of the seller, becomes effective in equity as soon as the thing becomes into existence or becomes the property of the seller. 4, the assignment of the thing in action gives the assignee all the rights of the assignor. And 5, in general, whenever a party for the valuable consideration transfers or contracts to transfer any interest in any property or in any rights of property, a court of chancery places the assignee or vendee in the shoes of the vendor as to all the interest and rights transferred or agreed to be transferred. So number 1, when an agent invests in his principal money in land and then takes title in his own name, or 2, a partner uses partnership funds to buy land in his own name, or 3, when a guardian uses his ward's funds in the purchase of property in his own name. Let me read that one again. When a guardian uses his ward's funds in a purchase of property in his own name, or 4, an executor, administrator, or any other trustee uses trust money to buy property in his own name. In all such cases, equity regards that as done which the purchaser ought to have done, that is, will regard the purchaser as holding the legal title for the benefit of the party who is entitled to the purchase money, and will decree accordingly. So when a party acquires the legal title to property by fraud, he will be decreed to hold it as trustee for his vendor. And where an act is prevented from being done by fraud, equity will consider the act as done in order to avoid the effects of the fraud. Thus, a widow prevented by fraud from descending to a will in equity will be given all the rights she would have acquired by the descendant in due time. And if a son pretend to destroy deeds to enable his father to devise the lands but destroys only copies, equity will treat the deed as destroyed. Equity treating as done which ought to have been done will consider land as redeemed when the redeemer has done all that is required of him and the purchaser refuses to reconvey and to take the redemption money. This maxim is greatly allied in another maxim: no one can take advantage of his own wrong. So all these maxims fold back upon themselves, and they all act as really as one. To prevent a party from deriving advantage from his own wrong, equity regards as done which, in good reason and good conscience, ought to have been done. Hence, agreements based on valuable consideration are in equity considered in the interest of the person entitled to their performance as performed, and performed at the time when, and in the manner which they ought to have been performed. And the same consequences attached to the agreement as though it actually had been performed, so that the party in default shall not benefit by his wrong, nor the other party suffer thereby. So where the land is ordered to be sold at will and is considered as personally, and where the land devised by a will is afterwards contracted to be sold, it is deemed converted, and the devisee gets nothing but the naked legal title without any beneficial interest in the property. In other words, legal title means no beneficial interest has been attached. It's just the naked legal without the beneficial interest in there. Money decreed by a will to be invested in land is considered as land and descends to the heirs and original beneficiary and not to his personal representatives. And on the other hand, the land directed by will to be converted into money goes to the personal representatives of the original beneficiary or is included in the general term personal property. But an administrator has no power to make a conversion, and if he does, the money put into the land will be deemed personally, and the election of those entitled to the money. In reference to agreements, the maxim is sometimes stated that what is agreed to be done is considered as done, and sometimes thus equity treats that as done which agreed to be done upon sufficient considerations. But it must be borne in mind that the maxim seeks no more than to enforce an equitable obligation. There must be a right on one side and a corresponding duty on the other. That's the determination of the relation. Which way the corresponding duties are and the duties compared to the rights. Who's got which one? That's determined by the relation. Because under a debtor-creditor relation, it's one way, but under a trust, it's opposite. So equity does not regard as done which might have been done, or what could have been done, but what ought to, in good reason and good conscience, to have been done. Nor does this rule operate in favor of any one except him who has the equitable right to have the act performed and those standing in his shoes. Nor does it operate against any one except him upon whom the duty is devolved and upon those who stand in his place. Next 46 is another one, maxim, and we'll not jump to another book. Let's go to Snell, Principles of Equity, 1885. That's page 74 in the PDF, section 10, page 45 in the book. Snell's Principle of Equity, 1885. Page 74 of the PDF, section 10. And that's page 45 in the book. Let's jump back up to 9. It's on the same page. And 9 rehashes the maxim we went over last 2 weeks ago there, where equity looks to the intent rather than to the form. Since both these maxims act pretty well hand in hand, let's pick up there before we jump to 10. So although this principle, even before the recent fusion of law and equity, was fully recognized in the common law, yet it was in equity that it received its complete exemplification. Equity would have no case permit the veil for mere form to hide the true bearings of a transaction. It is a well-known rule that equity will relieve against a penalty or forfeiture unless in exceptional cases, example, the case for landlord and tenant. If, therefore, it is satisfied that the sum of money specified in the bond is penal, it will refuse to enforce payment thereof in full, even though the parties may state in the bond to express words that the specified sum is not by way of penalty, but is to be held as ascertained or liquidated damages for breach of condition of bond. In Gibson, he goes over quite in detail, I think, over the unliquidated damages, how it applies. So continuing on, to this maxim may be referred also the equitable doctrines that governs mortgages, and nowhere, perhaps more than in these, was the ancient divergence of equity from common law so strongly and clearly exhibited. So now 10, back to the maxim we're on now. Equity looks at that as done which ought to be done. The true meaning of this maxim is that equity will treat the subject matter of the contract as to its consequences and incidents in the same manner as if it had acted contemplated by the parties had been completely executed. But the equity will not thus act in favor of all persons, but only in favor of a limited class of persons. Class of persons. I wonder what the class of persons is. Chiefly purchasers for value, whom equity regards as considerable affection, with considerable affection. Oh, it likes those commercial people. I don't like that, but anyway. Thus all agreements are considered as performed which are made for the valuable consideration in favor of persons entitled to insist upon their performance, and they are considered as done as the time when, according to the tenure thereof, they ought to have been done. They are also deemed to have the consequence attached to them, so that no party in the agreement or his privity shall derive benefit from his own laches or neglect to complete the same, and the other parties or his privity shall not suffer thereby. Thus money by a deed covenanted or by will directed will be laid out in land is treated as already land in equity from the amount that the deed and the will respectively take effect. On the other hand, where the land is by agreement contracted or by will directed to be sold, it is considered and treated as money. This maxim will fully exemplified under the head of equitable conversion hereinafter considered. Now, let's apply this also to the extinguishment of the debt under trust. According to equity, once you say it's so, even though it might not be done, because they haven't ledgered on the books properly, or they're holding and waiting, haven't done it, equity looks as it's already been done. From the moment your intent, you put the documents and sent them, and they got them. The intent was to do the conversion, which was the extinguishment of the debt. If the equitable asset needs to be converted, equity looks at it, should have been converted, and it has been converted, whatever is necessary to convert it to extinguish the debt. So there's like a double application of the maxim here. Equity looks at the extinguishing of the merging of the titles as already being done, and if necessary, a conversion was to be applied, it should have been done. Treats it as being done. All right, now let's go to my friend Pomeroy. Pomeroy's page 668 in the PDF. That's section 363 or page 601 in the book. Section 363 in Pomeroy. Page 668. This is the beginning of chapter 1, the fundamental principles or maxims of equity. Section 1, where equity regards that as done which ought to be done. And the analysis is from section 363 through 377, the conclusion. Hang on to your hats. Dorothy, Kansas has gone bye-bye. This is your ticket back home. Section 363, lists of maxims. Those principles which are so fundamental and essential that may, with propriety, be termed the maxims of equity are the following. Equity regards as done which ought to be done, and equity looks to the intent rather than to the form. And he who seeks equity must do equity. He who comes into equity must come with clean hands. Equity is equality is equity. Backwards there. Equality is equity. The next one, where there are equal equities, the first in time shall prevail. Next, where there is equal equity, the law must prevail. And next, equity aids the vigilant, not those who slumber on their rights. Next one, equity imputes an intention to fulfill an obligation. Next, equity will not suffer a wrong without a remedy. Next, and equity follows the law. Now, Pomeroy, in his book, and I think Gibson does too, when they say the law, keep in mind that was written before 1933. Law, in its reference to law, was referencing common law. So continuing on, it must not be supposed that all these maxims are equally important or that they have been equally fruitful in the development of doctrines and rules. It is not an exaggeration to say that he who has grasped them and with their clear comprehension and of their full meaning and effects has already obtained an insight into whatever is essential and distinctive in the system of equity jurisprudence. Now keep in mind that equity represents your substantive rights that God gave you. If you don't have this understanding, you don't have any rights. Continuing on, and has found the explanation of a particular doctrines and rules. So if you don't know these maxims, you don't have the explanations of the doctrines and rules which is governing your life. I propose in the successive section of this chapter to discuss them in order given above. Next, section 364, first maxim, its importance in general operation. First maxim in the list has been stated in somewhat varying language by different text writers. Now, all the different writers look at it a little bit differently, but pay attention to what this guy says. But without any substantial variation of the meaning, I think the following form is both strictly accurate and sufficiently comprehensive. In expressing the equitable principle, equity regards and treats that is done which in good conscience ought to be done. And that's good conscience. What is good conscience? Well, let me tell you, there is no conscience in the court at law. There is no God conscience in that court at law at all. And you wonder why they took the Bible out from the courts. Equity regards and treats that is done which in good conscience ought to be done. Some writers fail to apprehend the full significance of this maxim. Let me repeat that. Some writers have failed to apprehend the full significance of this maxim. A lot of these authors that you read in books of equity here, they are very nil, if they mention at all, the maxims. It's more or less that they ignore the history that establishes the equity jurisdiction. Equity, the maxims, are the source of the law. Why would you leave that out? Some writers have failed to apprehend the full significance of this maxim. That's why. And have described its effect in altogether a too narrow and partial manner. Making reference to number 2, Justice Story. It says, thus, Mr. Justice Story in his, and Mr. Snell in Equity following him says, the true meaning of this maxim is that equity will treat the subject matter of a contract as to collateral consequences and incidents in the same manner as if the final acts contemplated by the parties have been executed exactly as they ought to have been, not as they might have been executed. The most frequent cases of the application of this rule are under agreements. These descriptions is merely the substituting one practical result of the principle in the place of the principle itself. Back up in the text. Others have correctly looked upon it as the very foundation of its all distinctively equitable property rights. Of all equitable states and interests, both real and personal, is the fact and source of the large part of the division of equity jurisprudence which is considered with equitable property. The doctrines and rules which create and define equitable states or interests are in great measure derived from its operation. So far from the maxim being confined to an express and executory contracts to those dispositions of property which give rise to an equitable conversion, it has been applied by the most eminent courts to all cases or all classes of equity. To every instance where an equitable ought with respect to the subject matter rests upon one person towards another, to every kind of case where an affirmative equitable duty to do some positive act devolves upon one party, and a corresponding equitable right is held by another party. That's the equities between the parties, by the way. Whenever the courts of high authority have dealt with the principle in a narrow manner and have given to it a more restrictive operation and effect, their language, although perhaps very general in its terms, should be taken as confined and is intended by the court to be confined to the particular application of the maxim then under judicial investigation. Next section, 365, its meaning and effect. It was the true meaning of the principle taken in its most comprehensive and generic sense. And what are the true effects upon the system of distinctive doctrines and rules which constitute the equity jurisprudence? In the first place, it should be observed that the principle involves the notion of equitable obligation existing from some cases of a present relation of equitable right and duty subsisting between two parties. A right held by one party from whatever causing arising, and the other should do some act and the corresponding duty, the ought resting upon the latter to do such act. The equity does not regard and treat as done what might be done or could be done, but only what ought to have done. Nor does the principle operate in favor of every person, no matter what may be his situation and relations, but only in favor of him who holds the equitable right to have the act performed, as against the one to whom the duty of such performance is devolved. Wherever between two parties, A and B, inequity exists with respect to the subject matter held by one of them, B, in favor of the other, A, and then as between these two, the court of equity regards and treats the subject matter and the real beneficial rights and the interest of A as though the equity had actually been worked out, and is impressed with the character and having the character and nature which they would have borne. When in this proposition it is said that an equity exists between the two parties, this meaning is that some equitable obligation to do some positive act with respect to the subject matter arising from a cause recognized by the rules of equity jurisprudence. Let me repeat that again. Arising from a cause recognized by the rules of equity jurisprudence rest upon B and a corresponding equitable right to have that act done by B with respect to the same subject matter springing from the same efficient cause is held by A. This active relation subsisting between the two parties, a court of equity, partly acting upon its fundamental principles of going beneath the mere external form and appearance of things and dealing with the real fact, the real beneficial truth. In other words, this is all from an equitable point of view because equity created the at-law realm. It's always taken from that point of view. And if you've got a dispute coming from the at-law realm with your commingled, brainwashed mind, you will not be grasping this because you can't tell the difference between public and private. And that's generally everybody's problem. We first have to empty out the cup of the brainwashing at-law garbage before we can realize what we're talking about here in equity, before you have any room in the mind to put the equitable facts in. If you're sitting there asking questions, telling me what you know about at law, and you aren't listening to what I'm saying about equity, you will never get this. So continuing on, the real beneficial truth and party for the purpose of making its remedies more complete treats the resulting rights of A as though the obligation of B has already been performed. Regards A, in fact, as clothed with the same ultimate interest in the subject matter which he would receive, and hold if B had actually fulfilled his obligation by doing the act which he ought to have done. Of course, this interest thus possessed by A is and must be purely equitable one, recognized by courts of equity alone. Since no legal interest in the subject matter could become vested in A except by a complete performance of his obligation on part of B, his really doing the act which his duty bound him to do. Next, 366 is the source of equity property, sources of legal property or titles. This maxim is the source of equitable property and is the sources of legal property or titles. Notice the distinction, equitable versus legal here. It's the source of both of them. All kinds of equitable property, as distinguished from legal ownership, are, with perhaps one or two particular exceptions, derived from this fruitful and most just principle. Its full operation can best be understood and appreciated from a brief comparison of the modes in which absolute property, that is, the perfect right of ownership, dominium, arises or is acquired at law. At law. With the modes in which the analogous right of property arises according to the doctrines of equity. You tell me which came first, the chicken or the egg. In the earliest and rudest periods of the common law, absolute property could only be acquired inter vivos by the accurate observance of certain arbitrary external forms or symbolic acts and gestures. See number 1. Although with the advancing civilization, these external and symbolic acts have disappeared, still, down to the present time, the only absolute property or right of ownership which the law recognizes and which courts of law protect by their legal actions and remedies, whether in land or in things personal, must arise and be acquired in certain fixed, determinate methods. In other words, it's got to be recorded in an account. You got to follow this rule, that regulation, this and that. It's got to be one of these modes, or else at law doesn't recognize it. Continuing on, which alone constitute the titles known to the law. Using that word is in its strict and true sense as means of acquiring property. In other words, if it wasn't done according to what it can recognize, according to the mode at law, then at law can't recognize that to be a valid title. Without following some one of these certain modes, no legal property can be obtained or transferred as between persons in their private capacities. Do you understand what that said? Without following some one of these certain modes, no legal property can be obtained or transferred as between persons in their private capacities. No one in the private can own any property today because they can't do it unless it's being done by one of these particular modes at law. Can't be recognized, can't be seen. Property cannot be held today in private unless it was done by one of these modes. It will never be recognized at law. The most important of these common law methods which must be pursued in order that a legal property may be acquired in land are A, conveyance under seal, whereby the season was transferred, a will, inheritance, marriage, whereby a freehold estate for life might be vested in one of the spouses, actual decision with an adverse possession during the period prescribed by the statute of limitations and under very special circumstances, accession. The important modes of acquiring a legal property in things personal are a true present sale or bailment where the chattel is in existence and capable of immediate manual transfer, a will, succession in case of intestacy were regulated by the statutes of distributions, marriage, adverse possession aided by the statute of limitations, occupancy, the various acts in which include under the generic term accession, unless a person has obtained the legal property in a specific tract of land, although some one of the foregoing modes, he cannot, as demanded, maintain a real action to recover such land, or as leaseor of a beneficial or a plaintiff under the ancient practice, nor as plaintiff under the modern, maintain an action of ejectment for the same purpose. A legal estate acquired by some legal title is indispensable upon the same principle unless a person has a legal property in a specific chattel obtained through some mode recognized by the law. He cannot, as plaintiff, maintain any of the proprietary actions at law for the purpose of recovering the article itself or its value in money or damages for an invasion of his ownership, replevin or detainer, trespass or trover. While he may have legal rights with respect to one thing, the res, which courts of law will protect in rem, courts of law will protect, for the violation of which he may be entitled to appropriate legal remedies, actions at law, causes of actions, aka continuing his legal right of property can only arise and exist upon the occasion of certain determinate acts, according in the counter properly with the right seals and stamps and everything else, or events. Next, 367, effect of executory contract at law. Now, the contract is at law. The executory contract at law. Executory means it's be executed sometime in the future. So what is the effect at law of a contract whereby the owner agrees to sell and convey a designated tract of land, but which is not a true conveyance operating as a present transfer of the legal estate and the legal season? It is wholly in every particular executory and produces no effect upon the respective estate and titles of the parties and creates no interest nor lien or charge upon the land itself. The vendor remains to all intents the owner of the land, and he can convert or convey it to the third person free from any legal claim or encumbrance. He can devise it in the same manner. On his death intestate, it descends to his heirs. The contract in no manner interferes with the legal right to the estate and land, and he is simply subject to the legal duty of performing the contract or to the legal liability of paying such damages for its non-performance as a jury may award, which are collectible from his property generally. On the other hand, the vendee acquires no interest or property right whatever, and he can maintain no proprietary, no possessory act for its recovery. His right is merely a thing in action to recover compensation in damages for a breach from the vendor, and his duty is a debt, an obligation to pay the stipulated price. On his death, both his right and his duty pass to his personal representatives and not to his heirs. In short, the vendee obtains at law no real property, nor interest in real property. The relation between the two contracting parties are wholly personal. No change is made until by the execution and delivery of a deed of conveyance, the estate and the land passes to the vendee. It is unnecessary to describe the similar legal effects produced by agreements to sell chattels, sales of articles to be acquired by the vendor in the future, and all other contracts which are executory in their nature. Section 368. Effect of executory contract in equity. Now, in equity, not a law, in equity. The full significance of the principle that equity regards and treats as done which ought to have been done through the whole scope of its effects upon equity jurisprudence is disclosed in the clearest light by the manner in which equity deals with executory contracts for sale of land or chattels, and presents such striking and complete contrast with the legal method above described. Well, let me read that again. Equity jurisprudence is disclosed in the clearest light by the manner in which the equity deals with the executory contracts for the sale of land or chattels, which presents such striking and complete contrast with legal method above described. You'll find out it's backwards. It's 180 degrees from what it is at law. While the legal relationships between the two contracting parties are wholly personal, things in action, equity now views all these relations from a very different standpoint. In some respects, for some purposes, the contract is executory in equity as well as at law, but so far as the interest or estate in the land of the two parties is concerned, is regarded as executed. Already executed, done. And as operating to transfer the estate from the vendor and to divest it in the vendee. By the terms of the contract, the land ought to be conveyed to the vendee, and the purchase price ought to be transferred to the vendor. Equity therefore regards these as done. The vendee as having acquired the property in the land, and the vendor as having acquired the property in the price. The vendee is looked upon and treated as the owner of the land. An equitable estate is vested in him commensurate with the provided for by the contract, whether in fee, for life, or for years. Although the vendor remains owner of the legal estate, he holds it as trustee for the vendee in whom all the beneficial interest has passed, having a lien on the land, even if in possession of the vendee, as security for the unpaid portion of the purchase money. Two trusts have formed in a contract. It ain't a contract at all. The consequences of this doctrine are all followed out. As the vendee has acquired the full equitable estate, although still wanting the confirmation of the legal title for purposes of security against third persons, he may convey or encumber it, may devise it by will, and on his death intestate, it descends to his heirs and not to his administrators. And in this country, his wife is entitled to a dower in it. A specific performance is, after his death, enforced by his heirs. In short, all the incidents of real ownership belong to it. And as the vendor legal estate is held by him on a naked trust for the vendee, this trust, impressed upon the land, follows it in the hands of other persons who may succeed to his legal title, his heirs, and his grantees, who take with notice of the vendee's equitable right. In other words, a vendee's equitable estate avails against the vendor's heirs, devisees, and other voluntary assigns, and his grantees with notice, and is only when the vendor has conveyed land to a third person who is a bona fide purchaser for value without notice that other equitable principles come into play and cut off the vendee's equitable estate. It follows also as a necessary consequence that the vendee is entitled to improvement or increment of the land after the conclusion of the contract, and must himself bear any and all accidental injuries, losses, and wrongs done to the soil by the operations of nature, or by tortuous third persons not acting under the vendor. One comment about before we get too far off from it. The bona fide purchaser without notice, or the bona fide purchaser becomes with notice the bona fide purchaser. In the case of fraud, Fraud's going to vitiate it anyway. Back on topic, continue on. The equitable interest of the vendor is correlative with that of the vendee. His beneficial interest in the land is gone, and only the naked legal title remains, and he holds in trust for the vendee, accompanied, however, by the lien upon the land as security when any of the purchase price remains unpaid. This lien, like every other equitable lien, is not an interest in the land. It is neither a just ad rem nor just in rem, but merely an encumbrance. Don't we look at it differently on the outlaw side? The vendor is regarded as owner of the purchase price, and the vendee, for more actual payment, is simply a trustee of the purchase money for him. Equity carries out this doctrine to its consequences. Although the land should remain in the possession and the legal ownership of the vendor, yet equity in administering its whole property and its assets looks not upon the land as land, for that has gone to the vendee, but looks upon the money which has taken the place of the land. In other words, a conversion has taken place right before your eyes. Poof. Continuing on, that is, so far as the land is representative of the vendor's property, so far as it is an element in its total assets, equity treats it as money, as though the exchange had actually been made and the vendor had received the money and transferred the land. Although the legal title to the land would still descend to the vendor's heirs upon his death, still when a vendee afterwards completes the contract, takes a conveyance from the legal title from the heirs, and pays the price, the money, being all the time an element of the vendor's assets, and being therefore all time part of his personal and not of his real property, goes to his administrators or executors to be by them administered upon the rest of his personal assets, and does not go to the heirs. Section 369, sources of all equitable property. The foregoing description is shown now in one particular manner by the operation of the fundamental principle, the equitable estate and land, the beneficial property, the real ownership, which arises although no one of the acts or events has taken place which the common law so imperatively demands as prerequisite to the existence of ownership or property. This instance is given simply as an example. An analysis of the different equitable estates, property, and interests analogous to property, either real or personal, known to the equity jurisprudence, will disclose the fact that nearly all, if not absolutely all, arise in the same general manner by the operation upon the particular circumstances of the same fundamental principle and with the same general results. And as an assignment or conveyance of the particular interest in land is called possibility, is at law a mere nullity, so far at least it is attempted to create or transfer any ownership. At the time when the instrument is so executed as to is no present certain vested property right in the signer upon which his granting language can attach, and if some future time contingency happens, the possibility changes to a certainty, and the property right becomes vested in the assigner, and arbitrary and technical rules of the common law concerning conveyances of real estate did not allow the words of assignment to act upon this newly arisen and vested interest so as to transfer it to the assignee. The effect of such a transaction in equity is wholly different. Although when an assignment is executed, there is no present certain right of property in the assigner to be transferred, yet in view of equity, the instrument operates at least as an executory agreement on part of the assigner and creates a present obligation resting upon him with reference to the land, which obligation, though now contingent, may in future become absolute. If, therefore, at a subsequent time the contingency happens and a certain present property therefore vests in the assigner, the obligation now becomes absolute, at once attaches to it. By virtue of that obligation, this property or estate of the assigner ought to be conveyed to the assignee by an efficient legal assurance, and equity regarding that ought to be done as done, treats the property as transferred. And the assignee is vested with the complete beneficial ownership. In this manner, equity in pursuance of the fundamental principle under discussion gives full effect to the assignment or conveyance of a possibility and makes it a source of equitable property and land. Again, a sale of chattel not yet in existence, nor yet in possession of the vendor, but to be acquired in the future, passes no property in the thing to the buyer at law, even when it subsequently comes into the seller's ownership and possession. Such contract gives to the buyer a right of action for damages, but no property. And he can maintain an action of assumpsit, but not replevin, or trover, or trespass. But as such contract, although using language in presenti, in other words, in the present, is in effect an executory agreement and creates a definite obligation upon the vendor, equity upon the same principle in the same manner as last above explained, regards it as an assignment. And when the thing comes into existence or into the ownership of the seller, the real beneficial property in it is at once transferred to and vested in the buyer, and he is the equitable owner. And in its consequence, the same principle that an assignment of a thing in action, completely nugatory at common law, is transferred, and indeed imposed to the ancient theory of law, is regarded in equity as clothing the assignee with all rights of his assigner. This illustration has been taken from express contracts. The principle also extends to cases where the legal relation arises from conveyances inter vivos, or will, in which one of the parties as volunteer, and even to transactions in which the legal relation arise from no such definite cause, but are merely implied from the prior conduct of the parties. And all express active trusts to convey the corpus of the trust property directly to the city key trust, and in all express passive trusts to hold the land for the use of the city key trust, created either by deed or by will. An equity exists between the beneficiary and the trustee. An obligation rests upon the latter, and the equity is treated as worked out, an obligation as performed. And the beneficiary is clothed with the equitable estate, depending in kind, quality, and degree upon the special provisions of the instrument. Finally, in trust arising by operation of law, implied, constructive, and resulting trust, the equity subsisting between the city key trust and the holder of the legal title and the obligation rests upon the latter are treated as though worked out by regarding the beneficiary as vested with an equitable but no less real ownership. 370. The equitable estates derived from this principle. Having thus examined the meaning of the grand principle, equity regards that as done which ought to be done, and explained the rationale of the operations upon equity jurisprudence in giving rise to various kinds of equitable property and rights analogous to property. I shall finish the discussion by very briefly enumerating the most important of these equitable estates, interests, and property rights, which are immediate effects of the principle. Immediate effects of the principle. Immediate. As has already been shown, the maxim applies whenever an equity exists between two determinate parties with reference to some subject matter, that is, an obligation rests upon one and a corresponding right is held by another. Such a right and duty may arise from contract between the parties, and by doctrines of equity and contract must be made upon actual valuable consideration in order that any equitable right and obligation may be created by it, or from the disposition contained in a deed or a will where the party clothed with the right is a volunteer, or from the conduct relation of the parties where the equity neither grows out of express contract, conveyance, or will, as in trusts arising solely by operation of law, and various estates and interests resulting from the maxim might therefore be arranged in classes according to the threefold division, but which will much more convenient to state them under their accepted names and titles as separate species of equitable property. Section 371, conversion. One of the most direct and evident results of the principle is the equitable properties which arise from the doctrine of conversion. When real estate is treated as equity as personal property, or personal estate as real property, land as money, or money as land, nothing is better established than this principle that money directed to be employed in the purchase of land and land directed to be sold and turned into money are to be considered as species of property into which they are directed to be converted. And is this in whatever manner the direction is given. Whatever manner the direction is given, whether by will or by contract, marriage articles, settlement, or otherwise, or whether the money is actually deposited, or only covenanted to be paid, whether the land is actually conveyed, or only agreed to be conveyed, or the owner of the fund or the contracting parties may make land money or money land. A conversion may thus take place where by will or deed or family settlement, land is actually devised or conveyed, or money or securities are actually assigned to trustees with direction in one case to sell the land and pay over the proceeds to the beneficiary, and to the other to invest the fund in the purchase of the land to be conveyed to him. Or it may be in like manner to take place where by marriage articles or other executory agreement, land is covenanted to be conveyed, or money is covenanted to be assigned in the like manner for the like purposes. The effect of the conversion is direct consequence of the principles in question. Personal estate becomes, to all intents and purposes, in view of equity, real, and real estate personal. Money directed to be invested in land descends to the heir of the original beneficiary, or passes under the general description of real property in his will, while land directed to be converted into money goes into his personal representatives, or is included in his residuary bequeathed of his personal property. These are some of the incidents of a conversion and are sufficient at present to illustrate its nature and results. (372) Contracts for purchase and sale of lands. Another immediate and evident consequence of principal and equitable property created by mere agreements to purchase and sell lands. If a contract is made upon the actual valuable consideration and complies with other respects to the requisites prescribed by equity, then I wonder what those prerequisites are, by the way. How about the prerequisites for the trust? Prerequisites by equity, then as soon as it is executed and delivered, the vendee acquires an equitable estate in the land subject simply to the lien in favor of the seller as security for payment of the price, while the vendor becomes equitable owner of the purchased money. There is in this case, as in the last, an equitable conversion. The vendee's interest is at once converted into real property and in all its features and incidents, while the vendor's interest is, to the same extent, personal estate. 372, assignments of possibilities. Assignments of possibilities. Sales of chattels to be acquired in the future. Assignment of things in action. Equitable assignments of money and equitable liens. The operation of the grand principle that equity regards that as done which in good conscience ought to be done is perhaps less immediate and evident in producing these species of equitable properties or interests, but is no less real and certain. Real and certain. Real and certain. In all these instances, an equity exists between the two parties, growing either out of the assignment which at law creates or transfers no property right, either present or future, in the subject matter, or out of the executory contract at which at law only creates a personal demand, a mere right of action. An equity laying hold of obligations thus assumed or imposed upon one of the parties transforms it, so to speak, upon the happening of the contingent event contemplated into the real, beneficial, equitable ownership, property, or interest of whatever nature and extent, absolute or qualified, it may be according to the terms of the instrument. Terms of the instrument. Thus the assignee of a possibility becomes equitable owner of an estate when the event takes place. The vendee of chattels to be acquired becomes the equitable owner. The equitable assignee of a fund becomes the real owner of the money, and from the mortgage, from other transfer and operative as such at law, or from the mere executory stipulations of an agreement, complete equitable liens upon specific lands, chattels, or funds are created. Are created out of thin air. Rights are created. 374, express trust. In every particular instance of that vast section of particular ownership to which generic name of trust is given, where the legal title to the subject matter is vested in one person and the equitable title is held by another, this equitable property is the direct and plain effect of the principle which we are discussing. The truth of the statement is undeniable in all those cases of express trust, which thus divide the total ownership into the legal estate of the trustee and, 2, the equitable estate of the City Key Trust. 2 titles. And we are never thinking about the 2 titles. We're always arguing about the legal one. The real rights is in the City Key Trust, the beneficiary. Continuing on, in an express passage trust, a naked legal title remains in the trustee. But the equitable and the real property, with all its features and incidents, belongs to the beneficiary, so that he is treated in every sense as the true owner. The true owner. Not at law, not unless you bring a superior equitable claim in there today, in a court of equity, on the equitable side of the courts. And that claim would be superior to any at-law claim, because it's the primary relation. Where land is given to a trustee merely upon the trust to convey the same to a specified beneficiary, the principle applies with equal force, and the City Key Trust is clothed with the equitable property, although the directions of the trust have not yet been carried into effect by an actual transfer to him of legal estate. In another class of express active trust, where the terms of the creation of the possession of the subject matter and the control, management, and disposition of it during the time for which the trust is to last are given to the trustee to be exercised by him according to his own discretion, no such equitable property passes to the City Key Trust, and his right for the time being is only a thing in action, not an estate. No obligation rests upon the trustee as part of his fiduciary duty to make a transfer of the title to the beneficiary. The ought required by the maxim is not present, and the principle itself does not apply as long, at least, as the trust remains alive. .375, trust arising by operations of law. Principle is no less truly and directly the source of equitable ownership, regarded as held by the beneficiary in all trusts which arise by operation of law, resulting implied or constructive. Although the fiduciary relation is not created by the terms of any direct conveyance, devise, assignment, or agreement, yet by the settled doctrines of equity jurisprudence, an equity exists between the parties which is treated as worked out. An obligation to convey a subject matter rests upon the holder of the legal title, which is treated as though performed. some modern judges of the great learning and ability have said that the relations commonly known as constructive or resulting trusts are only trusts sub modo, are called trusts only by way of analogy and for want of a better and more distinctive name. Many of these criticisms upon the ordinary nomenclature will be well-founded. It does not deny and was not intended to deny the existence of real, beneficial, equitable property in the beneficiary. He is admitted to be equitable owner, and all the incidents of ownership, although the legal title is vested in another person, the beneficiary does not have anything which the law requires as a title, and he may, even without any written evidence of his rights, his proprietorship may rest wholly upon the acts and words, but still he is the equitable owner because equity treats that as done which in good conscience ought to be done. 376, mortgage, equity of redemption. There remains but one important equitable estate to be considered, that of the mortgagor, called his equity of redemption, and a careful analysis will show that the existence of this as a part of the equity jurisprudence can be accounted for upon no principle whatever other than the one under discussion. By the mortgage in fee, the legal estate is vested in the mortgagee, and upon the condition being broken, this legal estate becomes absolute. Nevertheless, an equity with respect to the lands exists between the two parties, a right in the mortgagor and an obligation upon the mortgagee. Equity of redemption is only an abbreviation of right in equity to have redemption. Right in equity to have redemption. The mortgagor is clothed with his equitable right to a redemption, or in other words, his right to compel a reconveyance and redelivery of possession at any time upon payment of the debt secured and interest, while the corresponding obligation rests on the mortgagee to make the conveyance and delivery. Now, under the common law, the statutes, they've got a cutoff date now, which is a limitation. And under trust, limitations don't apply under private trust. Connect the two together. Upon the universal principle of treating everything as done which in good conscience ought to be done, equity regards this right of mortgagor not as a mere thing in action, but as property, as an estate, as real, beneficial ownership of the land, subject, however, to the lien created by the mortgage as a security to the mortgagee for the payment of his demand. The mortgagor's equitable property is, in this respect, exactly analogous to the equitable state of a vendee subject to the lien in favor of the vendor as security for payment of the purchase price. Now, if you read a lot of cases today, that's basically what they say. The judges are saying that. Security was just a lien in favor of the vendor as the security for the payment of the purchase money. And nobody's bringing up that there were two trusts established at the formation of this. One trust with the trustee being one way, and the other trust, the trustee being the opposite way, and the duties being reversed vice versa also. 377, conclusion. In the foregoing discussion, I have shown in the most conclusive manner that every species of purely equitable property and of equitable interest analogous to property, except those which are intentionally created by the direct and affirmative operation of some instrument similar in its actions to a conveyance at law, is a certain and necessary result of the principle that equity treats that as done which in good conscience ought to have been done. It is no exaggeration, therefore, to say that the principle lies at the very foundation of the Department of Equity Jurisprudence, which deals with equitable estates, property, and interests analogous to property. Analogous to property. And that concludes tonight's maxim. We've been talking about the maxims here in the last 4 shows in the series here of the maxims. And we left off on equity acts in personam. And we're in the Phelps book. We're going to start there. Phelps book, and that is section 221, which is page 347 in the PDF or page 307 in the book. Starting in section 221. Equity acts in personam. By a recent English author, this maxim is ranked first in importance. To its actions upon conscience, he ascribes the doctrines of trust now, fraud, accident, and mistake, and the 3 maxims classified herein as the last 3 restrictive maxims, in which he thus makes derivative and subordinate. Historically, this is the correct view and coincides substantially with that herein presented. Practically, and from the modern standpoint, the maxim may now be regarded as dealing exclusively with remedies. It is not necessary to repeat what has already been stated as to the historical source of the maxim. And that's footnote 4, which is anti-section 7. It has been seen that it emphasizes a marked distinction between the methods of law and equity. 2 distinctions between law and equity. The common law court lays no command upon the defendant personally, but issues a writ of execution directed to the sheriff, commanding him to put the plaintiff in possession of the property in controversy, or in a case of a judgment or debt or damages, commanding him to seize the defendant's property. Equity acts upon the conscience of the defendant, imposes upon him personally a personal obligation, and enforces obedience against his person by attachment for contempt. In other words, by fine and imprisonment. Section 222, and thus acts beyond the jurisdiction. The present practical importance of this maxim is that by it the arm of equity is made long enough to reach property and even control legal proceedings beyond the jurisdiction of the state. Courts of equity are courts of conscience, operating in personam and not in rem. Not in rem. And in the exercise of the personal jurisdiction compel the performance of contracts and trusts as the objects and are not either locally or rationale demonsi within their jurisdiction. A party may be compelled to convey lands situated abroad, although the conveyance must be according to the law of the foreign country and must be sent there for record. The court may decree the re-execution of the dead or the lost deed of land outside the state. If the mortgagors and trustees of the railroad mortgage in default are all within the jurisdiction of the court, it may order a sale of the entire road, although part of thereof is outside its jurisdiction. A party may be enjoined from prosecuting a suit abroad, for a court of equity does not set aside or annul a judgment at law, but simply enjoins the plaintiff. Now, there may be some distinction here when we go into the equity follows the law, and it's not the literal interpretation of that, what it says. It tends to avoid the law and goes by its own precedence. So see footnote 1 there. Such injunctions especially lie to restrain residents of the state, invasion of an exemption or insolvent laws from attachment proceedings in other states. And other than such far-reaching effect may be given to the decree, the defendant may be personally within the jurisdiction of the court by service of process within the state or by voluntary appearance, and constructive notice by publication has no effect outside the limits of the state. Although the court of equity, acting in personam, may decree the conveyance of a land in another state and enforce the decree by process against the defendant, yet neither the decree itself nor any conveyance under it, except by the person in whom the title is vested, can operate beyond the jurisdiction of the state. Hence, a foreclosure in one state of a mortgage upon land in another is of no validity in the latter, nor a decree of partition. And in general, a decree cannot operate ex prio vigoro upon a land in another jurisdiction, either to create, transfer, or vest a title. Section 223, qualification. It must not be understood that equity does not protect rights in personam, or that it interferes with enforcement of all personal rights. On the contrary, it will shortly be seen that equity deals with specific and identified land or specific funds. The subject of its jurisdiction is property and not persons. And when the res lies within the jurisdiction, although the owner may be non-resident, the court is now enabled to, by statute, to enforce rights concerning it. Modern legislation has, in other ways, abridged the scope of the maxim that equity acts in personam. Decrees for the payment of money are now upon the same footing as judgments with respect to their enforcement. Decrees for sale are carried into effect by the appointment of trustees. Whenever a decree directs a conveyance, the decree itself has the same effect as the deed would, if executed. In decrees of divorce, it is decree in rem so far as the main object is concerned. The enforcement of the defendant's appearance and answer by personal coercion is still theoretically possible, but it has been practically superseded by means already explained. For violation of injunctions and other specific orders, the remedy is still in personam. 224, equity acts specifically. I think we'll leave that for the next one. Let's go on to the next book. That is Corpus Juris. We want to do the Corpus Juris. Again, not Corpus Juris Secundum. Corpus Juris, that's in section 183. That's page 221 in the PDF or page 194. Corpus Juris, section 183. Section F, equity acts in personam. That equity acts in personam is one of the oldest maxims of equity, and it is the basic principle of equity jurisdiction. Its meaning is that the equity deals primarily with the person, and usually only through him with the res. Originally, the jurisdiction of chancery was only in personam. The jurisdiction merely of the res without that of the person was insufficient to justify its actions. But the powers of equity have been extended so as to permit it in some cases to act in rem. While influence of the principle has equity acts in personam affects the entire exercise of chancery jurisdiction, its most important modern application is perhaps in permitting the court having jurisdiction over the person of a defendant to adjudicate with references to a subject matter beyond the reach of its process, and by personal decree to require action concerning it. Thus, equity having jurisdiction in personam of the parties may decree specific performance, although the res to be affected is outside the territorial jurisdiction of the court. So injunctions may be granted restraining the commission of acts in other states or countries, such as the prosecution of the actions or proceedings in foreign courts. Mortgages covering property in several states may be foreclosed and a sale had of the entire property in one suit in which the courts has jurisdiction in personam of all necessary parties. The maxim has been applied in numerous other cases. And some of those footnotes there, should look those up in that. Let's go on to the next book. I want to do Pomeroy's next. Pomeroy section 428. That's 775 in the PDF or page 708 in the book. My friend Pomeroy. Section 428, Origin and Original Meaning. Section 428, Origin and Original Meaning. I have already had occasion, while describing the nature of equity, and of equitable remedies in a former chapter to explain the origin of this maxim and the leading conception which it originally embodied. In the infancy of the Court of Chancery, while the chancellors were developing their system in the face of strong opposition, in order to avoid the direct collision with the law and with the judgments of law courts, they adopted the principle that their own remedies and decrees should operate in personam upon defendants and not in rem. The meaning of this simply is that the decree of the courts of equity, while declaring the equitable state, interest, or right of the plaintiff to exist, did not operate by its own intrinsic force to vest the plaintiff with the legal estate, interest, or right. Legal estate, interest, or right, to which he was pronounced entitled. It was not in of itself a legal title, nor could it either directly or indirectly transfer the title from the defendant to the plaintiff. The decree of Chancery spoke in terms of personal command to the defendant, but its directions could only be carried into effect by his personal act. It declared, for example, the plaintiff was the equitable owner of certain land, the legal title of which was held by the defendant, and ordered the defendant to execute a conveyance of the estate. His own voluntary act was necessary to carry the decree into execution. If he refused to convey, the court would endeavor to compel his obedience by fine and imprisonment. The decree never stood as a title in the place of the actual conveyance by the defendant, nor was it ever carried into effect by any officer acting in the defendant's name. It has also been shown that the original character of the equitable remedies and decrees has been greatly modified by statute in the United States. Under these legislation decrees are made to operate of themselves whenever necessary as sufficient title. They either transfer the estate by their own force without any actual conveyance from the defendant, or they carry into execution by officers purporting to act in the defendant's name instead. Side by side with its most important statutory change, the original personal character of the remedies is still left within. The alteration would be impossible, as, for example, whenever a decree simply restrains the defendant from doing any specified act, and wherever the jurisdiction is exercised with the reference to the subject matter situated beyond the territorial cognizance of the court. Section 429, in what sense equitable remedies do operate in rem. It has also been shown when explaining the nature of equitable remedies, that they generally are in another special sense, essentially in rem and not in personam. Equitable remedies very seldom consist of personal judgments, general recoveries payable out of the defendant's assets. The fundamental theory of the remedial action of equity is that it deals with specific and identified lands or chattels, or specific funds, whether consisting of securities and other things in actions or of money, and it seeks to determine, declare, and maintain the estates, interests, and rights of the litigant parties to such identified lands, chattels, or funds. Next, section 430, operation of equity upon the conscience of a party. There's still a third aspect of the remedial action of equity which should be accurately understood, since it lies at the foundation of much of the dealing of the Court of Chancery with legal estates and rights, and especially those conferred by the positive provisions of statutes. I mean, the most important principle that equity acts upon the conscience of a party, imposing upon him a personal obligation of treating his property in a manner very different from that which accompanies and is permitted by his mere legal title, without the beneficial interest, by the way. Continuing on, whenever a legal estate is, by virtue of some positive rule of either the common or statute law, vested A, but this legal estate in A is of its violation of some settled equitable doctrines and rules, so that B is equitably entitled to the property, or in some instance, or some, interest in other, in or claimed upon it, equity grants its relief and ensures B to his right, not by denying or disregarding or annulling or setting aside A's legal title, but by admitting its existence, and that's what I was making reference to over another one we'd be getting into later, that would be admitting its existence by recognizing it as wholly vested in A, and then by working upon A's conscience and imposing upon him the duty of holding and using his legal title for B's benefit, so that in the ordinary language of the courts, he is treated as a trustee for B. If he's a trustee, it must be a trust imposed, resulting by operation of the law. So one or two familiar examples will be identified the working of this fundamental principle. The testator has given certain lands to A by a will properly executed, but A procured the device by wrongful representations made to the testator, and the land should, by doctrines of equity, belong to B. The statutes of wills, however, is peremptory in its prescribed mode of executing a will. There can be no will without conforming to the statutory requirements. Equity does not attempt to overrule the statute. It admits the validity of the will and the legal title vests in A, but on account of A's wrongful conduct in procuring the device to himself, it says that he cannot consciously hold and enjoy the legal title for his own benefit, and imposes upon his conscience the obligation to hold the land for B's benefit as the equitable owner thereof, and then arises the further obligation upon his conscience to perform and complete B's equitable ownership by conveyance. Now we're talking about the equitable title. In exactly the same manner, the property or the equity of the party is worked out in all those cases where the peremptory provisions of the statutes of fraud stands in the way of any legal right or claim, and is in the specific enforcement of the verbal contract for the sale of land, which has been part performed by the plaintiff. Another illustration of principle has been seen in the doctrines established by the courts of equity concerning the effect of the registry upon recording acts. These statutes declare in general terms and without any exception that the subsequent guarantee or mortgagee who first puts his deed or mortgage upon the record shall thereby acquire the precedence over prior unrecorded conveyances. Courts of equity have added the rule that if the subsequent party who thus obtains the legal benefit of the record has notice, his recorded instrument shall still be subordinate to the prior unrecorded conveyance, of which he was charged with notice. In giving this effect to notice, the courts of equity do not assume to nullify the provisions of the Recording Act. They admit that a subsequent grantee has, by means of his record, obtained the complete legal title, which cannot be directly set aside nor disturbed, but they say that the notice of the prior conveyance makes it unconscientious for him to hold and enjoy the legal title for his benefit, and then impose upon him his conscience the obligation of holding it for the benefit of the prior unrecorded grantee. Everything is opposite in equity under personal at law. Next section, 431. This principle, which I have attempted to explain and illustrate in the preceding paragraph, in which underlies a very large part of the remedial action of equity, was stated in this unusual clearances and accuracy by Lord Westbury in the following passage. Quote, the Court of Equity has for a very early period decided that even an act of Parliament shall not be used as an instrument of fraud, and if the machinery of perpetrating a fraud, an act of Parliament intervenes, and a Court of Equity, it is true, does not set aside the act of Parliament, but it fastens on the individual who gets a title under the act and imposes upon him a personal obligation, because he applies the act as an instrument for accomplishing a fraud. In this way, the Court of Equity has dealt with the statutes of wills and the statutes of frauds. See number 1, footnote. Although Lord Westbury here speaks only of a case where the equity rights of one person arise from a fraud of another, and who has thereby obtained the legal estate, yet the principle applies whatever be the grounds on occasion of the equitable interests and claims which are asserted in opposition to the one having the legal title. So whatever the grounds and occasions of the equitable interest and claims which are asserted in opposition to the one having the legal title. Footnote 2 with a lot in it there. Review that. Let's go on to the next book. That was Pomeroy. So the next one we'll go to is BizFam, and that'll be in section 47. on page 272 in the PDF or 77 in the book. Next, BizFam. Section 11, that's section 47 also. Equity acts in personam, and that's on page 272 in the PDF or 77 in the book. Excuse me, that's 78 in the book, really. Section 47 is on page 40 or 78 in the book itself, or 272 in the PDF. Equity acts in personam, section 47. It was against the person that the jurisdiction of the Court of Chancery was originally acquired, and the attachment against the person has always been and still is one of the ordinary means of enforcing obedience to its decrees. Indeed, it may be said that, quote, generally, if not universally, equity jurisdiction is exercised in personam and not in rem, and depends upon the control of the courts over the parties by reason of the presence or residence, and not upon the place where the land lies in regard to which relief is sought, unquote. And that's footnote 2, citing a case there. Hence, when the parties are within the jurisdiction of the Court of Chancery, it will not ordinarily hesitate to grant relief, although the property to be ultimately affected by the decree may lie in another forum. Thus, the Court of Chancery in England decreed specific performance of a contract respecting the boundaries of Pennsylvania and Maryland, when colonies entered into by the proprietaries. A trustee residing in one state may be compelled to make a conveyance of real estate situated in another, and an account may be taken between a mortgagor and a mortgagee in a court of equity, although the mortgage premise lies outside the territory jurisdiction. Footnote 5 there for a case to support that. Next paragraph. It follows from this, however, that a decree in equity cannot, if of itself, divest a title at law, but can only compel the holder to convey, and therefore it was held in a recent case in Virginia that the Court of New York had no power to make a title to land in a former state by decreeing authorizing the committee of a lunatic to convey. As for the owner was incapable of executing a deed, his title would be vested only by some process by the court of the sovereign, the state, within whose territory the land was situated. This question is one of the great practical importance in foreclosure suits against railroad corporations whose lines of railroad extend to more than one state. It is now settled by the highest authority that the decree of foreclosure and the sale of the entire mortgage property is valid, although a portion of the property may lie out of the territorial jurisdiction of the court making the decree, provided, of course, that the jurisdiction over the defendants in personam had properly attached. Such was the ruling of the Supreme Court of the United States in Mueller versus Dowes, footnote 2, and where Mr. Justice Strong said, quote, without reference to the English Chancery decisions where the objection to the decree would be quite untenable, we think the power of courts of chancery in this country is sufficient to authorize such a decree as was made. Here is an undoubtedly a recognized doctrine that the Court of Equity, sitting in a state having jurisdiction over the person, may decree a conveyance by him of land in another state and may enforce the decree by process against the defendant. True, it cannot send its process into that other state, nor can it deliver possession of land in another jurisdiction, but it can command the enforcement of a transfer of title. And there seems to be no reason why it cannot, in a proper case, affect the transfer by the agency of the trustees when they are complainants, unquote. And so in McElroy versus Pittsburgh and Steubenville Railroad Company, a bill for foreclosure of the mortgage in which it appeared that a railroad company whose road was partly in Pennsylvania and partly in West Virginia had mortgaged all their rights to the whole road. The court decreed that the trustee who had brought the suit, being within the jurisdiction, should sell and convey all the mortgage property, as well as in the state of West Virginia as in Pennsylvania. But where, in order for the relief sought, it was necessary to deal directly in the land itself, the foreign situation of the property will be a bar to the jurisdiction. Thus, a bill cannot be brought for a petition of land outside the jurisdiction, or the court cannot issue a commission either, nor to remove a nuisance similarly situated, For no writ or to abate the nuisance would run, nor can title be made by a master or commissioner where the real estate is beyond the territorial jurisdiction of the court by whom such officers are appointed. Doctrine that equity acts in personam has also been applied for the purpose of restraining the defendants within the jurisdiction from prosecuting suits without the jurisdiction. The question whether an injunction should issue under such circumstances came before Lord Hardwicke in McIntosh versus Ogilvie and was decided in the affirmative. Since rulings have been made by many state courts in this country, these decisions have all been approved by the Federal Supreme Court. Footnote 6. The maxim that a court of equity acts in persona must not be understood to mean the jurisdiction of the chancellor extends to rights of actions for personal injuries. In reverse, this is the case. The subject of the jurisdiction of courts of equity is property, not persons. Their processes were directed against persons and sometimes against property, but there must be some right of property involved, in order that the jurisdiction of the court may attach. Thus, subjects will be noticed hereafter, but reference may be made in connection with the refusal of the courts of chancery to entertain any bill to recover damages for purely personal torts or prevent violations of purely political rights. It may not be out of place, moreover, to mention where the rule applicable when the res happens to be within the jurisdiction, and the person whose rights in the res are sought to be affected by the decree as a non-resident. In such cases, and in all events for certain purposes, the court will exercise jurisdiction over the thing, although the personal service upon the defendant may not be possible. Whenever service by publication in lieu of personal service is authorized by statute, cases not infrequently arise whenever there is necessary that the title to real estate should be perfected by getting rid of the outside claim. The title to land will be clouded by the existence of the alleged right which the holder declines presently to assert. There is, as shall be seen hereafter, a jurisdiction in the courts of chancery to remove a cloud upon the title, and this power may be exercised if the land is within the process of the court, although the party affected may be beyond its limits. Next one comes into a new maxim. That was his fam. Next one is Gibson, my friend Gibson. Gibson, section 32, page 52 in the PDF, or page 26 in the book. Section 32. Equity acts in personam. Section 32, page 26 in the book, or 52 in the PDF. When the chancellors first began to exercise judicial functions, they refrained from using common law or statutory processes, probably to avoid conflict with the common law courts, which were jealous of the extraordinary powers exercised by the chancery court. 1. Instead of commanding the sheriff to make the money, decreed the complainant out the defendant's property, the chancellor commanded the defendant to pay the money. 2. Instead of empowering the master to divest the title to the land of the defendant and vest it in the complainant or the purchaser, the chancellor required the defendant to execute a deed to the complainant or to the purchaser. 3. Instead of forbidding the court of law to proceed in a suit or to enforce its judgment in a given case, the chancellor forbade the plaintiff from proceeding in the suit or doing any act towards obtaining an execution. And 4. In general, the decrees of the chancery court were enforced through the personal act of the party himself. If the party failed or refused to do what the chancellor by his decree required him to do, compulsory process was issued. But no compulsory process issued until the party had been served with the mandate commanding him to do what the court required of him. If he then be disobeyed, he was adjudged in contempt and was committed to prison until he complied with the orders of the court. If he still refused, his property and real personal was sequestered and applied to the satisfaction of the decree. Thus it was formerly practiced in North Carolina and Tennessee, but in 1787, in consequence of the then mode of carrying into the effect of decrees of the Court of Equity by attachments, habeas corpus, attachments by proclamation and commission of rebellion being in as many cases dilatory, oppressive, and inadequate. The legislature of North Carolina authorized executions to issue on chancery decrees as at law, and in 1801, the legislature of Tennessee enacted that instead of decreeing parties to convey lands as therefore practiced in equity, the court was given power by decree to divest the title out of the person against whom the decree was pronounced. So they've been changing things a little bit as they go along here. So in effect, it doesn't quite act in personam anymore, acts against the in rem, but now we have a quasi. Continuing on, since the passage of these two acts, our courts of chancery have not acted ordinarily in personam. The vast majority of chancery decrees are now enforced by execution, attachments of property, writs of possession, divestiture of title, and orders of sale, so that it may now be said that the courts of chancery do not act ordinarily in personam. Nevertheless, the maxims of court of equity operates on the person is true. The most important result follow from the maxim, and although in practice our chancery court acts ordinary on the property of the party, yet has all of its ordinary authority to act on the person of the party, as well as been seen by inspection of the code 4478 through 4488, as it will be more fully shown thereafter. The principal cases in which equity now operates on the person in Tennessee are the following. Number one, where the parties reside within the jurisdiction of the court, but the land or the other subject matter in controversy is not. In such case, if equity so require, the court may be attached by attachment compel one party to convey the land to the other. Hence, a specific performance will be decreed as to the lands in a foreign country, so a trust will be declared and enforced, or a mortgage foreclosed or redeemed, or a fraudulent judgment overhauled, and even the sale under the such judgment, and when the lands or a judgment are in a foreign country, but were in order to give the relief sought, it is necessary to deal directly with the land itself without the agency of the parties, then the fact that the land is outside of the jurisdiction of the court will debar the court from granting the relief, because the court will not make a decree that it cannot enforce by its own authority. Thus, a bill cannot be brought for a partition of land outside of its jurisdiction, for the court cannot send commissioners there, but a bill may be maintained for rents and profits of lands outside the jurisdiction. 2. For a discovery of facts or of property, or the delivery of documents, or the surrender of personal property or trust funds is commanded. That goes into the next equity maxim there, and we'll pick up on those the next time. And the last one is Snell's book, section 12, page 76 in the PDF, or 47 in the book. Last one is Snell. Page 76 in the PDF, section 12, page 47 in the book. Number 12, equity acts in personam. If parties are within the jurisdiction of the Court of Chancery, the fact that the property is in another country or forum is not to prevent it from granting relief. In a great case of Penn versus Lord Baltimore, the plaintiff and the defendant have, by grants from the King of England, obtained a large tract of land in America, here entered into articles to settle their respective boundaries, which the defendant refuses to carry out. The plaintiff, both parties being in England at the time, applied for relief to the Court of Chancery. The court held that he was entitled to specific performance of the articles, for though the court had no jurisdiction in the matter, the property being abroad, yet it could be acted on the persons. In like manner, the trustee residing on one state may be compelled to make conveyance of real estate lying in another, and where the line of the railroad corporation, which extends through several states, is sold under the foreclosure of a mortgage, the court may order the sale of the entire property, although part of it is outside the jurisdiction of the court making the decree. It takes us to section 13, which is the next maximum. We'll pick up there on another maxim next time. We've been going over the maxims. This is a treatise in the maxims in equity. And I think we're in part 6 or 7, I forget, but anyway. We left off on the maxim to pick up on is going to be equity acts specifically. And that's out of the Phelps book. So that's Phelps in section 224, and that's page 351 in the PDF or page 311 in the book. So Phelps section 224.
That's only strict. I need area code.
All right, Phelps, section 224. Number 6, Equity Act specifically. Much might be said under this title as being anticipated. Another contrast between the rationale of law and that of equity is here sharply defined. The only actions by which specific property can be recovered at law are ejectment and replevin. In an ejectment, the only result originally was a judgment for damages, but afterwards specific restitution was given in limitation of equitable relief. That was out of Black's Commentaries 200. See footnote 2. In replevin, specific relief might be defeated by a defendant giving a returno habendo bond, a return bond, upon which the property must be restored to him and the plaintiff claim converted into an action for damages. See footnote 3. Cases there. The court has power to enforce delivery of chattels allonged by attachment of the person. This, of course, is an imitation of equitable process. The legal remedy of mandamus is also specific, section 98. So the breach for a contract to convey land and law gives compensation for damages, and equity, in many cases, wholly inadequate or incapable. Please mute out if you're not speaking. So the method of equity is reverse of this. Its object is, in the cases of injury, to restore the plaintiff to the exact position so far as practicable, and he would have occupied if wrong had not taken place. Section 225, specific performance. So this ties in with Equity Act specifically. It wants a specific performance. Equity enforces a specific performance of contracts to convey land and thus places the party in possession of the very subject. It enforces also specific performance of contracts with respect to articles of personal property possessing some particular equity, or particular quality, which cannot enter into a legal estimate of compensation, or where the legal remedy is for any other reason inadequate. Advancing upon the line, it has gone so far as to specifically enforce contracts for personal services for a particular character by injunction restraining their breach. As already stated, time is not, in general, the essence of the contract. Let me state that again. Time is not, in general, of the essence of the contract. And the right to enforce the specific performance is not lost by failure to pay the money on an appointed day. Now, it ties in with the maxim that we went over previously, where equity looks at it, what ought to be done as being done already. So continuing on, if by the terms of the contract notice of the intention to purchase is required, the failure to give such express notice will not bar relief if notice is sufficiently indicated by acts and conduct. But in matter of substance, the plaintiff must show the performance of contract or readiness to perform on his own part. He must be able to make good and not a doubtful title, but objections to the title in order to prevail must be well grounded. The plaintiff must make out his case by clear and satisfactory proof, and reasonable certainty is required to the subject matter of the contract, but the description is sufficient if it identifies the property. The Court of Equity will not enforce an unconscionable bargain, but if the contract was fair at the time it was made, it will not be judged by the light of a subsequent event. The perpetual contract will not be enforced, for the court cannot undertake an endless duty. It is not necessary to repeat the suggestions already offered as to the analogies and distinctions between a specific performance and injunction. It will only be added that both remedies illustrate this and the preceding maxim, and that the other applications of these maxims combined with others. Next section, 226, accident, re-execution. In case of accident, as the loss of a note, bond, or deed, accompanied by such circumstances as called for equitable relief, such relief will be specific, that is, will place the party, so far as practicable, the same position he would have occupied had the loss not been sustained. Re-execution of a lost instrument will, if necessary, be decreed, and in addition, further relief may be administered by directing the performance on the part of the defendant for the specific duty for which he was bound thereby. Next section, 227, mistake, reformation, and rescission. When there's been a mistake in a written instrument, and the mistake is merely one of expression or in terms such as an inadvertence or omission of the rescrivener, equity will act specifically in reforming or correcting or rectifying the instrument so as to place both parties in a position they would have occupied had the instrument been correctly drawn. To warrant the remedy of reformation, the mistake must have been mutual, or if unilateral, the mistake must have been induced by some act or omission of the defendant. The mistake also, if not admitted, must be established by clear and satisfactory proof, as well as the precise form and import of the instrument intended. For a fundamental mistake or a mistake in the subject matter itself, the remedy is rescission or cancellation, whether the mistake be of one or both parties. In cases of mistake, the specific remedy of injunction is also applied where appropriate. The equities of specific performance, re-execution, reformation, rescission, cancellation, injunction, and the like are all, of course, subject to the various defenses arising under the restrictive maxims. We've been going over the enabling maxims here. We haven't really gotten into the restrictive maxims just yet. That brings us up to the next maximum in this book, which is going to be 228, equity prevents multiplicity of suits. But let's jump to another book and continue on the maximum we've been at, to the equity axis specifically. So now let's go to corpus juris secundum, section 182, 221 in the PDF, or page 194. So that's CJ, corpus juris. Section 182, letter E, equity acts specifically. That's page 221 in the PDF, 194 in the book. Section 182, E, equity acts specifically. Maxim that equity acts specifically, or more fully, that equity acts specifically and not by way of compensation. Not by way of compensation. Not by way of compensation. In other words, it's talking about damages. Continuing on, expresses one of the fundamental distinctions between legal and equitable remedies. That's the distinction between performance performance versus the damages. That's the distinction between the legal and equitable remedies. The equitable remedies of specific performance, injunction, reformation, cancellation, and the other like remedies by which the party obtains the precise thing to which it is entitled are illustrations of specific relief afforded in equity as contrasted with some common law remedy of damages in lieu of the matter or thing lost. Common law always wants to give you damages. That's the only thing it can give you. You can't force somebody into doing the contract what it was supposed to do. It just has to give you the damages for the breach. Only in equity can you ask for the specific performance. So which court are you in? Are you trying to enforce your substantive specific rights under equity in a court at law? It'll never happen. Judges and the juries and all the court will not see what you're trying to bring on because it can't. You're in the wrong court. It doesn't have the rules or the eyes to see what you're trying to show them. Stay out of those at-law courts unless you want to purely litigate it on at-law methodology. You want to be in a court of equity for substantive rights of the real man. Otherwise, don't be talking about rights in a court at law. Next, we want to go to BizFam, section 48. That's page 275 in the PDF. Section 48, that's Roman numeral 12, Equity Act specifically. That's on page 275 of the PDF or page 81 of the book. Equity Act specifically. The last maxim which will be noticed is the Equity Act specifically, and not by way of compensation, which embodies the general principle running through the whole system of chancery jurisprudence. This principle is that equity aims at putting parties exactly in the position which they ought to occupy. So that ties right in with that other maxim that equity treats what ought to be done as being done. Which they ought to occupy. So it's making reference to, in a footnote, it says equity looks through the form to the substance. That particular footnote. A lot of these maxims, I'd say all these maxims, really reflect upon the others. They're all acting as one. You can't have one without all of them. They're all tied in and unitized as one. So continuing on. So this principle is that the equity aims at putting parties exactly in the position in which they ought to occupy, giving them in specie what they are entitled to enjoy. In specie means the same thing. And putting a stop, actually, to injuries which are being inflicted. Thus, equity decrees the performance of a contract and does not give damages for its breach. Does not give damages for its breach. That's a different law form, folks. If you want damages, you don't want to be in equity. So also equity will, under certain circumstances, restrain the commission of destructive trespass, whereas at common law, all that the aggrieved party could obtain would be a money compensation for the injury. That's all you can get. You can't get the performance. I want the performance. I want the performance on the extinguishment of the debt, which is the obligation of the trustee on the trust. I don't care whether at-law side wins. If I can get the enforcement of the trust in equity, it makes no difference. Whatever the law says at law, whatever it goes down, equity is going to avoid the at-law decision as if it was never there. You got a win-win situation under this, and you got to see it that way. Continuing on. And so again, the chancellor will sometimes compel a party specifically to make good his representations by which another has been misled, while in the common law act of deceit, damages alone can be recovered. Damages are at law. Specific performance is an equity. Next paragraph. In some exceptional cases, indeed, equity will afford compensation in lieu of specific relief, but such cases are rare. These exceptions, as well as the general principles contained in this maxim, will be illustrated more at length under the appropriate heads of specific performance and injunction. If you want to, you can jump to those sections and under the specific performance and the injunctions for that. Now let's go to the next book, Gibson's. My friend Gibson's. Gibson, section 34, that's 55 in the PDF, or page 29 in the actual book. Gibson's, section 34, PDF number, page 55. Equity acts specifically and not by way of compensation. This principle runs through the whole system of chancery jurisprudence. Equity aims at putting the parties exactly in the position which they ought to occupy, giving them in specie what they are entitled to enjoy, and putting a stop to injuries which are being inflicted. Thus, equity decreases specific performance of a contract instead of giving damages for its breach. So equity restrains the commission of trespass instead of compensating the aggrieved party by damages. In some cases, also, a party will be compelled to specifically make good his representations by which another has been misled. Also, equity will declare a person who has knowingly acquired trust property a trustee, and will make property purchased in his name by a fiduciary with trust funds trust property, and will continue and construe and enforce wills and other express trusts, and will set up lost or destroyed instruments and records, and will cancel fraudulent deeds and remove clouds on titles, and will be, by injunction, protect a party his rights or restrain a party in his wrongs. Restrain a party in his wrongs. This is where the enforcement comes in. Equity is the enforcement arm. Continuing on, in all foregoing cases, the common law either gave no remedy or else merely allowed damages for the wrong. The latter remedy, when allowed after allowed being often wholly inadequate, and sometimes for the poverty of the defendant wholly worthless. In other words, if the party had nothing to take and you were awarded damages, what are you going to get? So, what did you get for your damages? Nothing. So at law can't even give you an adequate remedy. If the party files bankruptcy on you, you get nothing, which is his right to file bankruptcy, which is equitable. Now the last book in this one is number 5, Snell book, which is section 13, page 76 in the PDF, or page 47 in the book. Snell, number 13, Equity Act specifically, 76 in the PDF, 47 in the book. Equity Act specifically. This maxim illustrates the great difference in the jurisdiction of equity and law. Let me read it again. This maxim illustrates the great difference in the jurisdiction of equity and law at law. Hope you can all see it. At law, the only remedy on a breach of contract was actions for damages. Equity, on the other hand, in such a case, acted in specie, that is, compelled the party to do the very thing he had agreed to do. In like manner, equity will restrain the commission of a trespass and compel a party to make good representations which he has misled another. In both these cases, all the common law courts can do was give the injured party damages. This maxim will be illustrated in the chapters on specific performance and injunction. So see those chapters in this book. So let's jump to another maxim now. Let's go back to the Phelps book. First book we were in. Let's go to page 355 in the PDF, which is section 228 where we left off. 355 in the PDF, which is page 315 in the book, with the next maxim. Equity prevents multiplicity of suits. Back to the first book we started on. Section 228, Roman numeral 7. Equity prevents multiplicity of suits. Although restrictive in form and in some of these minor applications, this is a powerful enabling maxim. A powerful enabling maxim. In substance and effect, while its influence is felt throughout the entire system, it is especially active in equity procedure. Like the two preceding maxims, equity acts in personam, and specifically, two maxims, we just finished the one, it deals with remedies rather than with rights. This has been already so often referred to that little remains to be said except by way of recapitulation. Section 229, influence upon procedure. Upon this broad principle is based the rule as to the parties in equity suits, according to all the authorities. The more general form of the rule, as hereinbefore stated, involves the doctrine of representation and the statutory doctrine of constructive parties. Now, keep in mind, when we're talking statutory doctrines here, we're talking pre-33. Pre-33 statutory doctrines. At that particular time, you still had a separate court, which was a statutory court for corporations only. You had common law as another separate venue, and you had equity as a separate venue. Separate courts. The real men and women did not go into the statutory courts where the corporations settled their differences. They stayed in the common law and the equity. Now, since 33, that's been flipped. Your common law has been taken over by equity. Equity's been put into trust, along with the republic and all your substantive rights. And the only thing left is statutes and codes. And everything is all statutes and codes is now fictions, just like it was before. And you think that you want to go into the at-law side, which is the statutory side, which is now the codification of the real law, which is the turning into the real law into privileges granted to you by the state now because of codification. And your substantive rights have been changed into, although they're still in equity, they've been changed to on the statutory side as lookalikes, which are inferior, granted to you by the state. Because now your remedy is an action, cause of action, given to you by the court, instead of a right being in equity. UCC says rights are remedies, but that's at law. Rights are not remedies in equity. Rights are relief. And we're not talking about remedials. So continue back in the book, top of the page again. The more general form of the rule, as hereinbefore stated, involves the doctrine of representation and the statutory doctrine of constructive party, devices by means of which the multitude of suits carried on in different places may be conveniently forestalled and drawn into compass of a single proceeding. It has also been seen to be the basis of the rules of practice as the election of remedies. Election of doctrine of election is that you elect one at the exclusion of the other. One or the other, not both. Either at law or equity, not both. One or the other. To the exclusion of the others. If you collect equity, it's to the exclusion of at law. It has also been seen that the basis of the rules of practice as to the election of remedies, it's given footnote 3, see section 120, ante, and a consolidation of cases, footnote 4, ante, section 119. Converse of consolidation, known as the splitting of the cause of action, is forbidden upon the same principle. The plea of the pending suit is an obvious instance of the practical application, and a cross bill is another. The defense of set-off is referred to the same principle. The third jurisdictional rule as to retaining jurisdiction for complete relief is simply a mode or a special case of this maxim. See number 10, footnote. In several of the foregoing instances, the maxim is used defensively, but is generally enabling in character, appears as well as from the main trend of its affirmative movement in procedure, as also and more especially from the two functions to be now mentioned. Next, section 230, ground of equity jurisdiction. Ground of equity jurisdiction. The prevention of a multiplicity of suits enables a distinct and substantive ground of equitable jurisdiction in cases of discovery, account, and contribution. It also forms the sole basis of remedial jurisdiction of equity in a large class of cases wherein the jurisdiction is wholly attributable to the inadequacy rather than to the absence of legal remedy. The Court of Equity will take cognizance of the controversy to prevent a multiplicity of suits, although the exercise of such jurisdiction may call for the adjudication of purely legal rights and confer purely legal relief. Now, multiplicity of suits could be your at-law side running concurrently with your equity side. Equity doesn't want a multiplicity of suits. It comes in and takes over all. Once it takes jurisdiction over the at-law and puts it into one, preventing a multiplicity of suits. It functions on that maxim that's going out to the exclusion of all others under the doctrine. The great instrument by which the principle is practically operated is the writ of injunction for purpose of restraining unnecessarily or vexatious litigation. Common instances are bills of interpleader, bills of peace, and bills of quietimate. Now, they had before used to put an injunction in to prevent the at-law side from running until the equity side could hear and be adjudicated. But since the courts have been merged in the procedures, the point's moot. And the auxiliary and the concurrent is also moot, because it's being administered out of one court, both jurisdictions. Besides these well-defined classes, there are a large and miscellaneous category of torts, trespasses, and nuisances cases, and in single instance of which equity would have no cognizance, but where the injury is one of repetition or continuance, and its redress at law could only be obtained by a multiplicity of litigation, and the inadequacy of such a remedy to afford complete relief furnishes an independent ground of jurisdiction. In Mississippi, the case last cited, the parties were revival corporations in making cottonseed oil, and the defendant was charged with the sharp practice in getting hold of the empty sacks distributed by the plaintiff among his customers for the reception of material. Here, where a separate legal remedy for each tort might have been had, but the legal remedy would be inadequate to relieve the plaintiff against the vexation of bringing numerous small suits, the defendant was accordingly restrained by injunction. Next, section 231, a factor in common law form. The efficiency of the maxim is also especially remarked in connection with the recent law reforms. By the Decatur Act of 1873, the English courts are expressly required to grant remedies so that all multiplicity of legal proceedings may be avoided, and the main object of the reform procedure in both countries is, quote, to enable the parties to a suit to obtain in that suit, and without the necessity of resorting to another court, all remedies to which they are entitled in respect of any legal or equitable claim or defense properly advanced by them so as to avoid a multiplicity of legal proceedings, unquote. The recent legislation in Maryland conferring equity powers upon law courts in certain cases already mentioned is another instance in point. Section 232, equality is equity. We'll pick up on the next show with that maxim. And we'll finish up the maxim we're working on before we do that. So that's it for tonight on what I'm going to read, and we'll jump to Q&A next. So press star 8 to raise your hand and get in the queue line. Star 8 to raise your hand and get in the queue line. So take notice and acknowledgement with agreement that this show and/or documents is private and not to be construed or relied upon as being legal advice for any individual legal situation or employed for making legal decisions. And you will not use any of this information for making a legal decision or performing a legal procedure. It is not a substitute for legal advice and/or guidance by a licensed attorney. This private show and/or documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing, reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved, without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or in any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in preparation or use of therein reference, and has no interest in any issue referenced to it therein, and is not a party to this or any action arising from, and is only acting as an authorized capacity as to liaisons to communications between the parties. By reading or using this information, you acquire knowledge and agree that you are not a client of Christian Walters. These documents and show recordings are incomplete and void without this notice agreement being attached herein by reference and a breach of this agreement. Upon breach of this agreement, the breaching parties become liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding. We've been doing a treatise on the maxims. We left off on next maxim, which would be equality is equity. And we're starting in the Phelps book again. That's section 8 on page 359 in the PDF, or page, excuse me, page 319 in the book. That's page 359 in the PDF, or 359 in the book. Okay, the Phelps book, section 8, which is really section 232, equity or equality is equity, and that's on page 359 in the PDF or 319 in the book. Equity or equality is equity. This is the last of the enabling maxims. This is the last one of the enabling maxims, designed so placed from the fact that the aggressive quality is the least pronounced of any of them, that it may sometime be used defensively. It might indeed be assigned to a class by itself under the name of administrative maxim. It does not enable the creation of any substantive equitable title, but it resembles the primary maxims in giving rise to important adjustive equities. Its active agency is a potent and progressive instrument of law reform, and is a positive feature that especially classifies it with the enabling maxims. No fundamental principle is broader in its scope, more characteristic of the genius of equity, or more universally pervasive of its jurisprudence. Next, section 233, applications. More frequent occasions for its practical applications are to creditors' bills and administration suits, to proceedings in for its practical applications to creditors' bills and administration suits, to proceedings for its practical applications. To proceedings in insolvency, to bills for an account of partnership or other transactions between creditors and debtors for their sureties, or to foreclose mortgages and enforce liens. In all cases of distribution of insolvent estates and apportionment among creditors, it is made pro rata upon the principle of equity. Upon the same principle, contribution will be enforced among joint debtors and co-sureties, and also the marshaling, where necessary, of assets and securities. When the estate of the testator is inadequate to pay the legacies in full, abatement is made pro rata, and the same rule of equity governs in applying the statutory provisions as to advancement, an analogous doctrine in regard to the redemption of legacies. See footnote 4, which is saying anti-section 189 in the book. Next, section 234, qualifications. Qualifications. This maxim is not to be understood as interfacing with the diligent pursuit of the legal right by creditors of obtaining liens by judgment, execution, attachment, or mechanics lien, or voluntary preference by bona fide assignment, mortgage, pledge, or other security, subject to the restrictions of insolvent system or of the bankruptcy laws. When such are enforced, herein equity follows the law. Now, we've gone over that one before, and that does not literally mean what it means, and I would suggest that you go and review that maxim. Palmer would be the best one to review it with. Continuing on, herein equity follows the law, nor does it even prevent the active intervention of equity to aid creditors in perfecting liens, although formally defective and therefore legally insufficient, and when otherwise meritorious and founded on valuable consideration. Herein equity assists and supplements the law. And those other, Palmer and some other authors, states actually that equity avoids the law. Next section, 235, law reforms. There's been no more active agency than the maxim in question promoting reforms embodied in statutes and constitutions, besides being the basis and already suggested of bankrupt and insolvent systems. I want to look at that again, if this is the insolvent system, since we're considered B in bankruptcy. Continuing on, there is a numerous category of reforms in the law so plainly attributable to the principle of equity that they may be allowed to speak for themselves. Number 1, abolition of primogeniture and equal division of inheritance. 2, placing real and personal assets on same footing for payment of debts. 3, abolition of distinction between different classes of debts as to distribution. 4, reversing the common law presumption in favor of joint tenancy and the jus acquiescendi. 5, equality of taxation. 6, equality of representation. 7, removing disabilities of coverture. And the last one, 8, removing disabilities of race and color. So the next we'll be picking up on the restrictive maxims, but now let's jump to another book, and that will be Corpus Juris. And that's section 207, page 233 in the PDF, or page 206 in the book. Corpus Juris. No, that's not Corpus Juris Secundum. That's the prequel to the Corpus Juris Secundum. It's Corpus Juris. Corpus Juris, that's on page 206. And that's page 233 in the PDF, section 207, M. Equality is equity. The maxim that equity is or equality as equity expresses an ancient equitable principle of wide and general application. The meaning of this maxim is that the absence of relation to or conditions requiring a different result, equity will treat all members of a class as upon an equal footing and will distribute benefits and impose burdens and charge either equally or in proportion to the several interests and without preferences. The maxim is restricted in its application to situations or conditions where the parties are on the same footing. It is also restricted to the maxim that equity follows the law, and by the maxim where equities are equal, the first in order of time must prevail. But the presumption is in favor of equality of rights. A right to the preference must be proved. The rule that those who share benefits must contribute proportionately to the expenses is an application of this maxim. So next, section 208, since that made reference to it, between equal equities, the law will prevail. Number one, in general. The maxim that between equal equities, the law will prevail is closely connected with the maxim that where equities are equal, the first in order of time will prevail. It has been termed its complement. Its general meaning is that unless one who seeks the aid of equity can establish an equity superior to that of the holder of the legal title to the subject matter, he fails to overcome the legal right, which consequently prevails against him. This rule is almost frequently enforced by supporting the legal title to land as against an equitable right no stronger than that of the legal owner, but the maxim is applicable to the species of property than land, and superior legal rights short of actual title have the same advantage. The maxim is applicable where there is no equity in either party, where the party having the legal right requires another interest inconsistent with his equity, so that he cannot honestly claim both. His priority is lost and the equities will prevail in order of time. Ex vi termini, the maxim has no application unless the equities are equal. Section 209, number 2, junior equity acquiring legal title. The holder of the junior equity, by acquiring also the legal title, obtains the superior right, although at the time of doing so he had notice of the earlier equity, the purchaser, and purchased the legal estate for purpose of obtaining the advantage, provided his equitable interest was acquired without notice of the prior claim. There is authority, however, for the view that the legal title also must have been acquired without notice of prior equities in order to confer priority. 210. Between equal equities, the first in order of time shall prevail. It is the maxim that between equal equities, the first in order of time shall prevail, but this is the equivalent forms of stating that the rule has been criticized as inaccurate. A more accurate statement is that between persons having only equitable interests, if their interests are in the other respects equal, priority in time gives a better equity. It is essential to the application of this maxim that the interest of both claimants shall be purely equitable, for one, in addition to the equal equity, has also the legal title. He will prevail irrespective of the element of time. But where conflicting equities are otherwise equal in merit, and neither claimant has the legal title, that which first accrued will be given preference. This test, however, is the last resorted to, and does not prevail when any other equitable ground for preference exists. It is only where equities are equal to the element of time become material and decisive to the priority of right, and where the respective equities are not equal, the stronger or more meritorious one will prevail regardless of which accrued first in order of time. In determining the relative merits of opposing equities, no technical rules are applied, but the question is determined on the broad principles of right and the justice particular to the courts of equity. The collateral incident of the transaction may give either claim priority over the other, such as the presence or absence of notice, or payment of or non-payment of a valuable consideration. The maxim has been applied to a great variety of cases, but perhaps its most frequent application is in the determining of priority among different lien holders. The rule will not be applied against a preference given by a recording act. Okay, let's move on to the next book, and that'll be Snell, Section 7, that's page 72 in the PDF, or page 43 in the book. Confusion here on this one. I don't have this right marked right or something here. Anyway, I believe this is Snell's book. It should be 41. Page 264 in the PDF, and that's page 70 in the book. Section 41, Roman numeral 5, equality is equity. Another equitable maxim is that equality is equity. This may be illustrated by a manner in which the court acts in case of a power in trust, where the donee of the power, who has the option of selecting out a class, has failed to exercise his discretion. In such a case, if there is more than one intended beneficiary, equity will divide the property equally among all. So also in the case of a joint purchasers of learning of the court of equity against the right of survivorship and the favor of treating the parties of interest in the subject matter of the purchase as tenants in common in proportion to the sums respectively contributed by each. That concludes that short section. All right, so the next book will be my friend Gibson. Gibson's, that's section 47, page 67 in the PDF, and that's page 41 in the book. Section 47, equity delights in equality. Page 67 in the PDF and 41 in the book. Equity delights in equality. This maxim is sometimes more strongly expressed thus: equality is equity. The common law delighted in preferences, and it was the law of people fond of distinction in personal rank, in social position, in forms of procedure, in evidence of debt, and in forms of actions. But the Chancery Court, early in its history, endeavored to break down these distinctions insofar as property was concerned. Joint obligations were made several, liens were apportioned, contributions was enforced among co-contractors, co-sureties and co-litigants, and the estates of debtors were divided ratably among their creditors. These changes in the common law, thus enforced originally in equity, have long since by statute or otherwise become part of the general law of the land. In accordance with this equitable maxim, the Court of Chancery will divide a common fund equally between those entitled. And if the fund is not sufficient to pay all in full, a pro rata distribution will be ordered. So when a common liability rests upon several persons in favor of a single claimant, as where several persons own the same debt, the Court of Chancery will require each person so liable to discharge an equal portion of the liability. Or if any one of them should pay more than his share, equity will require the others to contribute enough to make good the excess. Or an insolvent partnership, an insolvent corporation, or an insolvent estate is wound up in Chancery, the court always proceeds upon the principle that equality is equity and apportions the assets pro rata among all the creditors preferring none unless they have a prior lien. The same rule prevails when, in any case, a creditor files a bill on behalf of all the creditors to wind up the business of the debtor under a general assignment. So where there is not enough money to pay all the legacies in full, equity will make a pro rata deduction from each. And so it may be stated in general terms that whenever there is a common burden, it must be borne equally by all, and there is a common benefit, it must be shared equally by all. Of course, this maxim will not prevent parties by contract among themselves changing the operation of this general rule. Let me repeat that again. Of course, this maxim does not prevent parties by contracting amongst themselves changing the operation of the general rule. Next, let's jump to Pomeroy. Section 405, and that's 743 in the PDF or 676 in the book. Pomeroy, Section 405, page 743 in the PDF or 676 in the book. 405, its general meaning, and the maxim is equality is equity. We have seen in the opening paragraphs of the introductory chapter that the notion of equity or impartiality, aequium, lay at the very foundation of the aequius as conceived by the Roman jurists, and the same idea was from the outset incorporated into the equity jurisprudence created by the English Court of Chancery and has been perpetuated in all its doctrines into which the notion could possibly enter until the present day. While the common law looked at and protected the rights of persons as a separate and distinct individual, equity rather regards and maintains as far as possible the rights of all and are connected by any common bond of interest or of obligation. The principle equality is equity, or equity delighteth in equity, or equity delighteth in equality, is of a very wide and general application, is the immediate and conceded source of several important and distinctive doctrines of equity jurisprudence. This is not all. It furnishes a practical rule for the guidance of equity courts in their administration of a release, and whenever they obtain jurisdiction over a great variety of cases, unless some compulsory dogma of the law stands in the way. I shall briefly mention the important equitable doctrines which are derived from this principle and indicate a few of the cases in which it operates as a rule controlling the administration of release. Next, 406 is the source of certain equitable doctrines, pro rata distribution and contribution. Where a number of persons had separate claims against the same individual or the same fund, the law generally gave certain classes of such claimants a complete precedence and even to exhaustion of the fund, if necessary, over the others, arising solely from the form of the security, as for example a bond or other specialty creditors or over simple contract creditors. Also among several persons having claims of the same grade against a single individual or fund, and one his superior activity, either by means of action or judgment or not, obtains payment of his demand and first in order of time, is entitled at law to the precedence thus acquired over the others, even though they should thereby be prevented, in whole or in part, from procuring satisfaction. Conversely, this is familiar doctrine of the law that when a creditor has a single claim against several persons, each of such debtors is required to so completely and individually liable that the creditor may enforce payment of the entire demand from any one of the number. The law will interfere with the action of the creditor, and it will not compel him or any manner to obtain satisfaction from all the debtors, par se passu, and after one of the number had thus been obtained the payment, the whole amount, the ancient common law, prior to its adoption of doctrines barred from equity, failed to give him any right of recourse upon his co-debtors by means of which the burden might finally be distributed among them all in just proportions. The rules of the modern law giving such right to reimbursement are the direct importation of the equity jurisprudence. And I might add that equity is the source of the law. Continuing on, that was Bouvier. Finally, the common law prior to statutory changes exhibits a decided preference, in fact, leaned very strongly in favor of joint ownership over ownership in common, and in favor of joint right among creditors over several right, and joint liability among debtors over several or joint and severally liability, and all the legal consequences of survivorship and of its extinction of the right or liability on the part of any one of the creditors or debtors who dies. Under all the conditions of the fact, equity proceeds among very different principles upon the principle that equality is equity, and that right or burden should be equalized among all the persons entitled to participate. It is not to be understood, however, that the court of equity would always directly interfere with parties under the circumstances above mentioned for the purpose of carrying out the principle of equality, but could not, for example, restrain a creditor from prosecuting his legal demands by legal means, merely on the ground that the result would give him a precedence over others. And in other words, the principle of equity is the principle of equality is equity is not of itself the source of the equitable jurisdiction which would not otherwise have existed. The true doctrine is that whatever the court of equity upon ground of equitable cognizance acquires jurisdiction over a case falling under the general condition of fact mentioned above, it will apply the principle of equality in determining the collective rights and liabilities of all the parties. Next, 407. Under the limitation last stated that the subject matter properly belongs to the equitable jurisdiction, the following general principle may be regarded as firmly established of a wide application. Whenever several persons are entitled to participate in a common fund or are all creditors of a common debtor, equity will award the distribution of the fund or a satisfaction of the claims in accordance with the maxim. Equality is equity. In other words, if the fund is not sufficient to discharge all claims upon it in full, or if the debtor is insolvent, equity will incline to regard all the demands as standing upon an equal footing and will decree a pro rata distribution or payment. On the other hand, whenever a common liability rests upon several persons in favor of a single claimant, equity will enforce such liability upon all the class in accordance with the same maxim. Equality is equity. It will apply the maxim either directly by apportioning the burden ratably among all the individuals on whom the common liability rests, or indirectly by giving the right of contribution to a member of the class from whom the payment of the whole demand has been obtained, enabling him to recover contributory shares of the amount from the other members of the class, by which means the entire burden is finally adjusted upon and among all of them. It will be easily seen upon examination that this comprehensive principle of equity lies at the foundation of several well-settled doctrines of jurisprudence, and it furnishes the rule upon which the court of equity proceeds to award its relief in numerous cases which do not fall within either of these special doctrines. Next, section 408, ownership in common. One of the most remarkable illustrations of the principle being a direct antagonism with the especially favored dogma of the old common law is seen in the preference with equity gives its ownership in common over joint ownership of lands. It may be stated that the general proposition that equity always leans in favor of ownership in common, and wherever it is possible to do so, will hold an ownership to be in common, and thereby disregard the legal right of survivorship, although at law the ownership would be strictly joint. It was also an invariable rule in common law that when purchasers take a conveyance to themselves and their heirs, they will be joint tenants, and upon the death of one of them, the estate will go to the survivor. The same rule prevails in equity unless circumstances exist from which the contrary intention to the parties may be presumed, enabling the court of equity to disregard the legal rule. The same is true of a joint contract to purchase land, and it may be two or more vendees where they have paid or agreed to pay the purchase price in equal proportions. Equity would regard their right as a joint one, and upon the death of one vendee would not decree a conveyance to the survivor of the heirs of the deceased vendee as owners in common. Although the legal right was allowed to operate under these special circumstances, still equity leans very strongly against joint ownership. Whenever circumstances occur from which it is reasonably implied that the tenancy in common was intended, court of equity will hold the ownership to be in common and will disregard the legal right of survivorship by declaring the survivors to be trustees of the legal estate for the representatives of the deceased purchaser or owner. In pursuance of this view, the doctrine is well settled, long previous to all legislation on the subject, that where two or more purchased lands in advance or agreed to pay the purchase money in unequal portions, this makes them in nature of partners, and however the legal estate may survive the death on one of them, the survivor will be considered in equity as only a trustee for the representatives of the other in proportion to the sums advanced by each of them. This equitable doctrine is always applied to mortgages, where money is advanced by two or more persons, no matter whether in equal or unequal proportions. They take a mortgage to themselves jointly. In law, their estate is joint, and on the death of one of the debt, the security would belong wholly to the survivor. In equity, however, the interest of the mortgagees is in common, and on the death of one, the survivor is held in trustee for the personal representatives of the deceased mortgagee. These equitable doctrines, drawing such distinctions between conveyances, contracts for purchase, and mortgage at law in equity, were established before any statutes had changed the legal view, but they have become unnecessary and obsolete in the United States in consequence of modern legislation. This legislation, although through the states, has declared that the conveyance of land to two or more grantees shall, unless a contrary intention is clearly expressed, create an ownership in common and not a joint ownership. As the original doctrine of equity is thus incorporated into law by statute, there is no longer any need of an equitable rule as above described. Furthermore, either as an inference from the statutes or from a gradual adoption of the equitable principles, and the right of interest of two or more vendees in contract for purchase of land is no longer strictly joint, even at law. In a great majority of the states, that is, the right and interest of the heirs and representatives of the deceased vendee are fully recognized and protected. Finally, by the equitable theory of the mortgage, which, as has been shown, prevails in nearly all the states, the interest of the mortgagee being regarded as personal property and not as an estate in the land, and right of two or more mortgagees is not strictly joint when considered with reference to third persons or even to the mortgagor himself. Next section, 409, joint liability, death of joint debtor. Another admirable illustration of the principle that equality is equity is shown in a case analogous to the last one described, of a mode in which equity treats liability arising out of a contract joint at law. It is one of the oldest and most familiar doctrines of law, and when two or more persons promise to bind themselves to pay a sum of money or to do any other act, their obligation or liability are joint. It follows from the legal conception of joint obligation, and when one of the joint debtor dies, the liability on his part and on the part of the estate, ipso facto, ceases, and the only obligation of the entire debt rests at law upon the survivor or survivors, and he or they could be sued at law by the creditor. This injustice might result from a purely technical rule of the law is very apparent. The doctrine of equity is quite different. Presuming upon the reasonable presumption that it is the intention of the parties in every such agreement that the creditor shall have the several as well as the joint obligation of each debtor as surety for payment or performance, equity declares as a rule that every contract merely joint at law shall be regarded as against the debtor parties a joint and several undertaking, creating a joint and several obligation. As a consequence to the equitable view of the obligation, the doctrine is settled that upon the death of one of the debtors, the liability does not remain upon the survivors alone. If the survivors or survivor are insolvent, or if the creditor has exhausted his ordinary legal remedies against them in vain by means of a judgment and execution returned unsatisfied, then such creditor may maintain a suit in equity against the personal representatives of the deceased debtor and enforce payment out of his estate. In England, the doctrine is settled by the modern decision is still broader and more efficient. The creditor is entitled to sue the personal representatives of the deceased debtor in equity at once without attempting, much less exhausting, any legal remedy against the survivor. In other words, the creditor has at times the opinion to sue the survivor at law or the representatives of the deceased in equity, whether the survivors are solvent or not, and this rule has been adopted in some of American states. Certain of these states, the common law dogma concerning joint debtors is wholly abrogated. Special provisions of their codes and procedures or of statutes expressly authorize the legal action to be brought in the first instance against the survivors and the personal representatives of the deceased joint debtor, or even against some, any, or one of them, at the option of the creditor who sues. There is one important exception as established by the courts of England and in many of the United States to the doctrine that equity will regard and treat a joint obligation arising from contract as joint and several, and so to render the estate of the deceased debtor liable to a suit in equity brought by the creditor, and that is where the deceased debtor is a surety. It is well settled, quote, that if the joint obligor is dying to be surety, not liable for the debt irrespective of the joint obligation, his estate is absolutely discharged both at law and in equity, the survivor only being liable. In such case where the surety owed no debt outside the irrespective of the joint obligation, the contract is the measure and limit of his obligation. He signs a joint contract and incurs a joint liability and no other. Dying prior to his co-maker, the liability also all attaches to the survivor, unquote. See number footnote 5. Next, section 410, settlement of insolvent estates, marshaling of assets. Marshaling of assets. Another remarkable and most just application of the principle, often leading to results different from those produced by the operation of legal rules, may be seen in those instances where the court of equity acquires jurisdiction from any cause to wind up, distribute, or settle an estate, property, or fund against which there are a number of separate claimants. One example is of settling the affairs of an insolvent partnership, corporation, or individual debt in creditor's suit brought by one on behalf of the other creditors, where the assets are not sufficient to satisfy all demands in full. The court always proceeds upon the principle that equality is equity and of apportioning the property pro rata among all the creditors. The principle is carried to such an extent to the settlement of insolvent partnerships and partnerships where one of the members has died that firm creditors are compelled in the first instance to resort to the firm assets and the creditors of the individual partners to individual assets, for either class can have recourse on any balance left remaining of the other kind of fund. A second example of the marshaling of assets in the administration of estates of deceased persons. At the common law, certain classes of creditors enjoined a precedence over others and were entitled to pay in full even to the exclusion of the inferior orders by the administrator or executor out of the legal assets of the decedent's estate according to their established priority of right. But a court of equity, having obtained jurisdiction over the administration, regards all the debts in general as standing upon equal footing and as entitled to the payment pro rata out of the equitable assets. If the estate is not sufficient to pay them all in full without any reference to the legal right or priority, in order to attain this result and to carry out the principle of equality as equity in administrations, the doctrine of marshaling was established. Next, 411, abatement of legacies, apportionment of liens, apportionment under trust powers, and contribution among co-contractors and co-sureties. Among other doctrines derived from the principle that equality is equity as their source are the following: the abatement of legacies, where a pro rata deduction be made from all legacies of the same class when the assets are insufficient to pay all in full. It is true that the principle is not carried out with the absolute rigor in the cases of legacies, since two different classes are admitted, the general and the specific. The latter, the specific, being entitled to priority of payments, but the deduction is applied to those which belong to the same class, and the leaning is strongly in favor of placing any particular legacy in the general class. The apportionment of the money secured by the mortgage or the encumbrance among the various owners of the different parcels into which the mortgaged premises has been divided. Whenever a mortgage or other encumbrance has been placed on a tract of land and the tract is subsequently conveyed, subject to the mortgage, in parcels to different owners, or liens or interest in distinct portions of the land are subsequently acquired by different persons, In adjusting the payment of the whole mortgage debt, either voluntarily by way of redemption or forcibly by way of foreclosure, equity applies, unless some other controlling equitable consideration interfere. The principle of equity, or the principle of equality, in other words, equity makes pro rata apportionment among all the owners of partials and holders of the interest. Now, let me interject that some other controlling equitable consideration would be, number one, a different type of relation, a, say, trust relation, where the equities between the parties are different. Continuing on, it would be observed, however, that the particular application of the principle is not universal, for in several of the states, on account of the assumed equitable consideration, a different rule has been adopted. The whole subject is examined in the subsequent chapter on mortgages. The execution of the power in trust when the donee has failed to act under it. A power in trust partakes so much of the nature of the expressed active trust, and if the donee upon whom it was conferred fails to make any portion under it, the court of equity will not suffer the power to wholly fail, but will carry it into effect. In accordance with the principle of equity, where a power in trust is given to appoint among the members of the designated class as among the children of the donee, and the like, the donee upon whom the power is conferred can appoint in favor of anyone in the class, and the court of equity will not interfere with this distinction. Where the donee, however, fails to make an appointment, the court makes no selection of a particular beneficiary out of the class, the court of equity will carry out the power under the principle of equality, by dividing the funds subject to the power in equal shares among all the persons composing the designated class. Finally, the most important doctrine, perhaps which results from the principle equality is equity, is that of contribution among joint debtors, co-sureties, co-contractors, and all others upon whom the same pecuniary obligation arising from contract, express or implied, rests. This doctrine is evidently based upon the notion that the burden of all such cases should be equally borne by all the persons upon whom it is imposed, and necessarily effect to equalize the burden whenever one of the parties has, in pursuance of his mere legal liability, paid or been compelled to pay the whole amount, or any amount greater than his proportionate share. No more just doctrine is found on the entire range of equity, and although this is now a familiar rule of the law, it should not be forgotten that the conception of the origin are wholly due to the creative functions of the chancellor. 412. Conclusion. The preceding paragraphs give a sufficient illustration of the principle equality is equity, and they demonstrate the fact that the court of equity endeavors to carry the maxim into operation in the administration of remedies whenever jurisdiction is for any cause obtained over the subject matter of the controversy. The various doctrines to which I have mentioned as originated from the principle, the cases selected as examples of the operation, will be fully examined in the subsequent chapters of this work. Now we'll move on to the last one, which will be Merwin, which is a new one. That's out of the 1895 book, and that's the Principles of Equity and Equity Pleading. Principles of Equity and Equity Pleading, 1895. That's in section 125. That's page 171 in the PDF, or page 70 in the book. Again, that's Merwin, 1895, Principles of Equity and Equity Pleading, section 125, page 171 in the PDF, or page 70 in the book. Section 125, equality is equity, or equity delighteth in equality. This maxim in its general purpose serves to express the idea that the predominant aim of equity is to work out exact justice so far as it can be done. It has two important practical applications. 26. The first relates to the ownership of property. The rule which equity used to follow, in absence of any express agreement, was that there were two or more contributed in equal proportions to the purchase of property, they should own it as joint tenants. This rule was applied formally even in the case of real estate. The persons contributing jointly to its purchase were held to be joint tenants, although one important incident of this joint tenancy was that the survivor took the whole if the joint tenancy had not in the meantime been severed. This is contrary. However, the doctrine of survivorship is not favored, and the disposition is, in all conveyance of two or more persons who treat them as tenants in common rather than joint tenants, I think the rule which the Court of Equity would adopt here now would be to treat the parties as tenants in common. I do not think, however, that the equity can claim the sole credit of adopting a presumption of joint or common ownership from the equal contribution of payment. I have no doubt that under the same circumstances, the same presumption would exist at common law. 127. The second more important application of this maxim is to the case of joint sureties. Where two or more persons become sureties for a principal debtor, the inflexible rule is equity is that they enter into common liability. They embark on the same ship, and under no circumstances, by no artifice of circumlocution, is one surety allowed to obtain an advantage over another. In this case, the invariable rule is equality is equity, and therefore, if one surety has been compelled to pay the whole debt to the creditor, all the sureties must contribute and pay to him their respective shares. 128. So also, if the debtor has given to one surety any surety by way of mortgage or otherwise, to identify him against loss or account of his suretyship, all his co-sureties have the right to share equally in the benefits of his surety. One surety cannot, by an agreement between himself and the principal debtor, gain an advantage over his co-sureties, and therefore it is implied that in what I've said, although the agreement between the debtor and the surety may have been that the surety should be for his sole benefit and indemnity, equity will not allow such an unjust preference and will require the surety shall be applied equal proportions to all the sureties who have been compelled to pay the principal debt. 129. On the same principle, if the creditor releases one surety, he will thereby release all the sureties, while equity, as we have seen, will guard the sureties of any unjust preferences given to the debtor to one surety. So on the other hand, it will guard them from any equally unjust attempts by the creditor to relieve one surety at the expense of the other sureties. If one be released, all are released, for equality is the instance is equity. The rules are so great and extent now recognized and applied at law. Equity deals with the individual. 130. Passing from maxims strictly, there is an important characteristic of equity jurisprudence next to be noticed, and that is that the particular sense of the court equity acts in personam. Might be getting into one that we had gone over already. Let's see. Yeah, I don't know if we want to get into that one. Finish off the paragraph there. So equity acts in personam, that is to say, it deals with an individual and his conscience and compels him to do his duty to the specific case, and this does not without reference to the situs of the subject matter of the controversy. All right, so that's the last book, and we'll open it up for Q&A now. So we're discussing the maxims. Picking up on the next maxim, which is, next maxim is, equity follows the law. And we're starting in the Phelps book, section 1, and that's on page 3 36 in the PDF or page 324 in the book. Equity follows the law. Section 1, 2, 36 in the PDF, 324 in the book. Section 236 in general. Of the 6 restrictive maxims, and maybe I should make a statement here that we've ended the enabling maxim section and we're starting on the restrictive section. So we're at first one in the restrictive section. Equity is following the law. So the 6 restrictive maxims given below, the first operates to prevent creation of distinctively equitable rights and is therefore primary. The other 5 mainly operate to prevent their enforcement by the appropriate equitable remedies and are therefore generally remedial in broad sense of relating to the remedy. More correctly, anti-remedy. Anti-remedy, anti-remedial. So the first is restrictive, and as to the sphere of equity, the other 5 as to the exercise of the power within its sphere. As these latter, and especially the last group of 3, are far the most important and of the most frequent application in practice, and they presuppose that the prima facie exists of the equity in which it is their office to defeat, in a particular sense, by reason of its special circumstances. The philosophy of the restrictive maxims may be called the statics of equity. They are constantly invoked by defendants and by plaintiffs occupying a defensive position. We'll look at this case, footnote number 1, as Clay versus Freeman, and some of these other ones are listed in footnote 1. Following is a table of the restrictive maxims as herein classified and arranged. Number 1, equitius sequitur ligum. Number 2, between equal equities, law prevails. And number 3, between equal equities, priority of time prevails. And those 2 are grouped together, 2 and 3. 4, who seeks must do equity. 5, who seeks equity must come with clean hands. And 6, vigatibus non dormitibus equitus solventit. The last 3 are within a group themselves. That's 4, 5, and 6. So look at these as being grouped together. Also in enabling maxims, they are grouped together also in groups. Keep that in mind. Next section, 237, equitus sequitur ligum. Manifest object of this maxim is to keep equity jurisdiction within bounds, or at least to profess to do so. Okay, now let's talk about the discretion of the judges. Do you think for 1 minute that the judges have total discretion? No. They are bound by legal maxims. At law, there is no bindings at all. They have total discretion at law, especially when you choose and invoke the at-law side, because you're in total control whether you're going to invoke equity or you're going to invoke at law. And generally, everything is at law without invoking. So by default, everything goes to at law unless you raise your pretty little hand and stick your head up and say, hey, I'm invoking equity here by the particular way that equity is going to recognize and take jurisdiction. If you don't do that properly, then equity will never be invoked, and it will go default to at law. And there's where the judge has total discretion to rule any way that he wants because you invoked equity. Or excuse me, you invoked the at law, which is going to slide into equity. He's going to use equity to hammer you. Because you signed a contract, and the contract says that you didn't make your payments with credit that was supposed to be according to the contract or Federal Reserve notes, and now you're guilty in a breach of the contract. And that's the only thing the Court of Equity wants to know is when you're going to pay with your credit and when you're going to pay for your Federal Reserve notes on the breach of the contract. When are you going to correct the defect? Continue on. The same principle bounded the jurisdiction of the Roman praetors. Now, where did Rome get the equities from? They got it from God. They didn't come up with the Roman equities. They didn't come up with it themselves. They stole it from God. They just recognized it, and they utilized it in their system. Rome didn't come up with equity. Unlike the Roman priors, the early English chancellors found themselves confronted by rival courts who alone possessed the power of punishing criminality or of redressing by civil suit for damages cases of homicide or assault in which the execution of a doubtful decree might be resisted by violence. It was for the courts of law. And remember, courts of law back then were true courts of law, not today. At law is not law. It's statutes and codes. When they talk about prior to 33 and all these books, they talk about law, they're talking about actual law. It was for the courts of law in such cases to pronounce in the last resort upon the jurisdictional validity of the contested decree, hence the doubtful question of jurisdiction. The chancellors were accustomed to take the advice of judges. By the checks of the common law, courts were thus able to interpose, and the development of equity was cautiously effected under the vigilant supervision and to some extent control. And today, it's pervaded into there from the Juridical Act and is taken over common law, and everything is morphed. It's all equity. Common law analogies were kept in sight, but some of its harshest rules were untouched. Historically, this is what is meant by the maxim, equity follows the law. Its net result is the outcome of the long struggle for jurisdiction. These two venues are fighting for control, in which by the means of the royal support, the chancellors finally prevailed. In 1873 and 1875 on the Juridical Act. Equity's been in precedence since that time. Nobody's ever seen it. Practically, therefore, the maxim must be understood as partial and limited in scope, since, as we have seen, the main business of equity is avowedly to correct and supplement the law, and is not, however, in England considered as at all impaired by the provision of the Juridical Act in the case conflict between equity and law, and within reference to the same matter. The rules of equity shall prevail. Number 4. Next section, 238, applications. First, equity is governed by the rules of law in some cases, it says. Some cases, there's the caveat. As to legal rights, however vigorous or unreasonable, or even where the rule, such as Shelley's case, defeats the manifest intention of the testator. Second, equity also in some cases adopts the rules of law by analogy. What's analogy mean? Doesn't mean synonymous. By analogy, as equity rights, and as the case of the statutes of limitations, which it does not in terms apply to cases in equity. And also in the case of trust estates. Now, trust estates is in italics. Trust estates, exclusive jurisdiction over equity, where the same rules as to quality and devolution apply to the legal estates. Third, equity follows the law and construction of statutes, wills, and contracts, or rather both law and equity use the same canons of interpretation as the means of arriving at the intent. Fourth, equity also follows law in general as the rules of evidence. Next section, 239, qualification. Qualification of this maxim is nothing less than the entire system of juridical equity itself, juridical equity itself, both jurisprudence and procedure, based and has been seen upon the theory that equity does not follow the law where the law does not follow justice or public convenience. As it has been seen upon the theory that equity does not follow the law where the law does not follow justice or public convenience. See sections 145, 146, and 172. The reverse of this maxim is sometimes quoted, lex sequitur equitatem. The reference is to the constant progress of law in direction of equity, under the superior attractive force of the latter. Superior attractive force of the latter. Superior. Following the progress of the law in the direction of equity. We're going in the direction of equity, and nobody ever noticed it. Nobody ever noticed it. I don't know why. It says, see sections 167 and 168. Section 240, between equal equities, the law will prevail. We could go into that one. No, let's not. Okay, let's jump to another book now. Next book is going to be Corpus Juris in section 184. That's 222 in the PDF or page 195 in the book. Corpus Juris. Section 184, G. Equity follows the law. That's page 195 in the book. In general, the maxim that equity follows the law, although frequently stated as a general principle, is really quite restricted in scope. Restricted in scope. I wonder how restricted it is. Equity follows the law so far as the law goes in securing the rights of the parties and no further. And when the law stops short of securing the object, equity continues the remedy until complete justice is done. The maxim is inapt to where the legal remedy is inadequate to enforcement of the equitable rights, and it will be applied as to permit the perpetuation of a fraud. There are, however, two classes of cases which the equity may be said to follow the law. Firstly, in determining purely legal rights, and secondly, in determining analogous equitable rights. 185, number 2, determining legal rights. Where no countervailing equity required different treatment, the Court of Equity in dealing with the legal rights and interests will follow the rules of law in respect thereto. Well, equity, where equitable principles have justified it, have created many rights unknown to the law, and even contrary thereto, the maxim has frequently been given as a reason for refusing to create rights or liabilities unrecognized at law when not justified by equitable consideration. Thus, equity will not impart validity to the instrument which is void at law. It has also been given for the reason for a refusal to change or unsettled rights established by law, and for a refusal to disregard constitutional or statutory provisions. Where a court of law has established a right, it is not within the providence of equity to disregard it, as in the case of determining the amount of a debt by reducing it to judgment or adjudicating the validity of a tax. So in affording relief similar to that granted at law, such as awarding interest, fixing the priority of liens, and the foreclosure proceeding in jurisdictions where the statutory action at law is prevailing method, the maxim has been applied. Equity will, exactly what they're doing today. Exactly what they're doing today. Equity will generally follow the law in preserving the right of exemption as against set-off. Also, will follow legal rules of evidence and accept way of discovery. Will not take jurisdiction because plaintiff cannot establish his legal or his case by legal evidence. 186, number 3, determining equitable rights. Equity, often by analogy, where the conditions are similar, applies the rules governing legal estates and rights to equitable estates and the rights of analogous character. Thus has been held that if a person is capable of holding a legal title to property, he is capable of holding the equitable title. But if he is incapable of holding the legal title, he is equally incapable of having a trustee hold it for him. It was determined at the early day that equitable estates could be guided by the same rules of descent as legal estates, and in construing the limitations imposed on the deed of trust, the rules of law will be followed. The dower proceeding and generally be determined upon legal practices or legal principles. Equity in regard to the incident as well as the principal demand follows the law. Thus, it applies the legal rule of damages. And where there are no rights to men's profits at law, none can be removed or recovered in equity. It is said that the general rule that if an action at law will not lie upon a contract to recover damages for the breach, the court of equity will not decree its specific execution. So let's see. Let's just kill this last paragraph here. Equity delights to do justice and not by halves. Maxim not often quoted in the opinion is that equity delights to do justice and not by halves. The significance of this maxim lies in the last words. It means that it is an aim of equity to have all interested parties in court and to render a complete decree adjusting all rights and protecting the parties against future litigation. The principle of the maxim embraces the well-established doctrine that when equity once acquires jurisdiction, it will retain it so as to afford complete relief. So when I come in through equity, equity is going to take over the jurisdiction of the at-law side. So I take control of the at-law side by first coming into equity, not by going into at-law directly. At-law, you can't take control of the at-law. You've got to take control of the at-law by coming into equity, through equity. Next book, we're going to go to BizFam next, section 38. That's page 259 in the PDF or page 65 in the book. BizFam's book, number 38, Roman numeral 2, Equity Follows the Law. Page 65 in the book or 259 in the PDF. Second maxim which will be noticed is that equity follows the law. The meaning of this maxim is that equity applies to equitable titles and interests, those rules of law by which legal titles, I want to stress that again, legal titles and interests are regulated. It doesn't say anything about beneficial interests here. Legal titles, to the exclusion of beneficial titles. Continue on. Provided this can be done in a manner not inconsistent with the equitable titles and interests themselves. Number 1 footnote. A somewhat different version of this maxim was given in a different case here, Magnatic versus Thompson's, namely that whenever the rights of the situation of the parties are clearly defined and established by law, equity has no power to change or unsettle those rights or situations. Keep on codifying and destroying your rights. Continuing on, thus, equitable estates are subject to the same laws of inheritance as legal estates, and their devolution is the same. And so, at common law, the husband was entitled absolute to his wife's chattels and possession. He is, in a like manner, considered entitled to chattels of which she is the equitable owner. But where the property is settled to the separate use of the femme covert, equity will not suffer the title of the husband to be asserted, for it to do so would be to defeat the title which was created in equity for the benefit of the wife. In the case of executory trusts, also equity will sometimes refuse to apply the strict rules by which legal estates are controlled. And remember, you've got to have a corresponding beneficial estate or trust estate to balance the legal estate. So legal estates are controlled, but this is because such trusts are in an inchoate condition, and the exact quality and duration of the estate are not in themselves strictly defined. Equity also may be said to follow the law when rights and equity are considered barred by lapse of time, in analogy to the statutes of limitations. It doesn't say barred by the lapse of time by the statute of limitations. It says by an analogy to the statutes of limitations. It's analogous to. 39. Forgive my Latin. Vigilantibus non dormintibus equitus vivenitut. So this other maximum, so I just butchered probably, the meaning of which is sufficient, obvious. It is designed to provoke diligence, to punish laches, and to discourage the assertion of stale claims. By virtue of this maxim, such claims are rejected in equity independently of any statute of limitations, and in many cases, equitable relief depends upon the discretion of the chancellor, and the laches of the complaint is often one of the most important of the elements that are taken into consideration when discretion is exercised. I think we just jumped into another maxim here that we don't want to go over. That one doesn't apply to the one previous we've been going on right now, so let's go to the next book. Next one, our friend Gibson. Gibson's, that's section 53, page 71 in the PDF, or page 45 in the book. Section 53. Page 45 in the book, or page 71 in the PDF, section 53. Equity follows the law. Equity follows the law in following particulars. Footnote 60. By law, in this section, is meant the common and statutory law. Now remember, statutory law and common law were different back then in 1907. Yet true law. Continuing on, number 1, adjudicating questions affecting the legal estate, rights, interests, or duties, equity applies the rules of law to the circuit courts would apply in like cases. 2, in adjudicating questions affecting equitable states, rights, interests, or duties, equity will follow the analogies of the law where any analogy clearly exists, especially the law in reference to the descent and distribution of estates and the husband's rights of his wife's chattels, but subject to her equity. 3, whether the legislature has passed an act not expressly applicable to proceedings in equity, nevertheless the courts of chancery will follow such statute unless it contravenes some fundamental equitable right or some equitable remedy. Unless it contravenes some fundamental equitable right or some equitable remedy. 4, where the courts of law of the equity have concurrent jurisdiction, the statutes of limitations will be enforced in chancery. Indeed, it may be generally said that the court of chancery, in enforcing a legal right or in applying a legal remedy, will follow the law when no fundamental rule of equity is thereby violated, where it otherwise a man's legal right or his legal duties or liabilities might to some extent depend upon the court in which the suit was pending. Sounds like discretion, but not. This remark, however, must not be so construed as to intimidate that when the legal cause of action is pending in chancery, the court has not the power to apply the maxims and principles of equity and to enforce any equities that may exist in the case, and especially the power to compel and complain to the equity, or complain it to do equity. Next paragraph. But this maxim must not be too broadly interpreted, for as a rule, instead of equity following the law, it widely departs from the law. Now, keep that in mind with everything I've read so far tonight. But this maxim must not be too broadly interpreted, for as a rule, instead of equity following the law, it widely departs from the law. Courts of chancery follow the law as to the competency of witnesses and the methods of obtaining testimony, but contravenes the rules of law as to the admissibility and force of evidence, especially in cases of fraud, and in cases where parole evidence is heard to explain, vary, contradict, or nullify a written instrument, or to a sale, a judgment, or decree. Keep that in mind. For as a rule, instead of equity following the law, it widely departs from the law. All right, we're going to go to Pomeroy next. Pomeroy, section 425. 771 in the PDF or 701 in the book. That's 771 in the PDF or 704 in the book. Section 425. Twofold meaning here. First, in obeying the law. This maxim in its Latin form, equitia sequitur legem, was frequently quoted in the earlier chances before the extent of the equitable jurisdiction had been fully determined, and in importance, even in supreme and controlling efficacy, that had attributed to it by the writers to do which it does not and never did possess. So far as it can truly be called a general principle guiding and regulating the action of equity courts, its meaning and effect are now settled within well-defined and narrow limits. Well-defined and narrow limits? Wow. Doesn't sound like the judge got much discretion, really. As a practical rule and not a mere verbal theory, not a mere verbal theory. Let me say it again, not a mere verbal theory, folks. It is a whole restrictive and it's in its operation. And its only object is to keep the jurisdiction of equity from overstepping the boundaries which have been established by the prior course of adjudication. There is no, it's like a railroad track. It only goes one direction. Bound to the tracks. The judges are bound to the tracks. With this respect, the maxim has a double import and operation. First, equity follows the law in the sense of obeying it, conforming to its general rules and policy, whether contained in the common or in a statute law. This meaning of the principle was very clearly stated by Lord Chancellor Talbot in the following passage, quote, "There are instances indeed in which the court of equity gives a remedy and where the law gives none. But where the particular remedy is given by the law, that remedy bounded and circumscribed by the particular rules would be very improper for this court to take up where the law leaves it and to extend it further than the law allows. It should be observed, however, that equity had not, in developing its jurisdiction, invaded the particular doctrine of common law which was involved in this case, but it had certainly disregarded other rules as positive and well settled in its previous course of decision." Next section, 426. Secondly, in applying legal rules to equitable estates. Equity follows the law in the sense of applying to equitable estates and interests some of the same rules by which the common law legal estates and interests of the similar kind are governed. Equity having by the exercise of its creative power called into existence the system of equitable states, determined that these estates should partake to a certain extent of the quality of the corresponding legal estates. Now, it's italicized, to a certain extent. To a certain extent is italicized. To a certain extent of the quality and of the corresponding illegal estates. Thus, a use in fee was held to descend according to the same rules as the legal estate in fee, and a husband was entitled to courtesy in such use. It should be carefully observed, however, that the courts of equity carried out the principle in this, its second sense, only to a partial and quite limited extent. A careful examination will show, I think, that the only important rules of the law adopted by the early chancellors to regulate equitable estates, quote, or here's italicized again, were those concerning descent and inheritance. The feudal incidents of legal estates were held not to apply to uses. Equitable estates in fee could be conveyed without livery of season and could be devised by will and were not subject to dower. It is an evident error to say that equitable estates were regulated by all the rules of law applicable to the corresponding legal estates. Let me read that again. It is evident error to say that equitable estates were regulated by all the rules of the law applicable to the corresponding legal estates. The second sense in which the principle is understood was admirably stated in a celebrated opinion, Sir Joseph Jekyll, of which the following is an important passage. Quote, the law is clear and the courts of equity ought to follow it in their judgments concerning titles of equitable estates. Otherwise, great uncertainty and confusion would ensue. And though proceedings in equity are said to be secundum discretionem boni viri, yet when it is asked verbonus est quest, the answer is quae consolata perum quae legis jurat servet. And it is said that the Rourke's case that discretion is a science not to act arbitrarily according to the men's wills and private affections, and so discretion is executed here is governed by the rules of law and equity and not to oppose. But each of it is in turn to be subservient to the other. This discretion in some cases follows the law implicitly, in others assists it and advances the remedy, in others again it relieves against the abuse or allays the rigor of it, but in no case does it contradict or overturn the grounds or principles thereof. It has been sometimes ignorantly imputed to this court. That is a discretionary power which neither thus nor any other court, not even the highest, acting in a judicial capacity, is by the Constitution entrusted with. That was number 3, Cowper versus Cowper. In this case, the court reluctantly adhered to the legal canon of descent, which refers to the whole that the half-blood, and they had held that the equitable estate and fee descended to the cousin of the whole blood instead of the brother of the half-blood of the deceased owner. And that was an unquote, then I'll ask the quote. Some of the sentences of this often quoted passage must, I think, be accepted only within considerable modification. Taken literally, they certainly contradict a large portion of the established equitable jurisdiction, taken literally, and of settled doctrines of equity jurisprudence. The same twofold import of the principle has also been expressed in the following formulas. Number 1, equity is governed by the rules of the law as to legal estates, and that word legal is italicized, legal estates and interest and rights. 2, equity has regulated by the analogy of such legal interest and rights and the rules of law affecting the same in regard to equitable estates, equitables italicized, interest and rights, where any such analogy clearly subsists. Next section, 427, operates within very narrow limits. The maxim is, in truth, operates only within very narrow limits. Operative only within a very narrow range. To raise it in the position of a general principle would be a palpable error. Throughout the great mass of the jurisprudence, equity, instead of following the law, either ignores or openly disregards and opposes the law. Just exactly what Gibson said. Read it again. Throughout the great mass of jurisprudence, equity, instead of following the law, either ignores or openly disregards and opposes the law. As was shown in the portion of the introductory chapter which deals in the nature of equity, one large division of the equity jurisprudence lies completely outside of the law. Which one's that, folks? Trust. It is additional to the law, and while it leaves the law concerning the same subject matter in full force and efficacy, its doctrines and rules are constructed without any reference to the corresponding doctrines and rules of the law. Another division of equity jurisprudence is directly opposed to the law, which relies on the same subject matter. Its doctrines or rules are so contrary to those of the law that when they are put into operation, the analogous legal doctrines and rules are displaced and nullified. Displaced and nullified. Displaced and nullified. As these conclusions cannot be questioned, it is plain that the maxim, equity follows the law, is very partial and limited in its application. Limited in its application, and cannot, like other maxims discussed in this chapter, be required as a general principle. It's very partial. Very partial. Now we're going to go to Snell for the last one. Section 2, Snell's book. Page 46 in the PDF, page 17 in the book. Now, Pomeroy established that equity does not always follow the law. Listen to what Snell says, following on that same vein. That's page 46 in the PDF, page 17 in the book, number 2. Equity follows the law. This maxim has two principal applications. A. In its concurrent jurisdiction, that is to say, as regards legal estates and rights and interests, equity is strictly bound by the rules of law and has no discretion to deviate from them. B. In its exclusive jurisdiction, including for the purpose of its auxiliary jurisdiction also, that is to say, as regards equitable, in quotes or italics, equitable estates, rights, and interests, equity, although not strictly speaking bound by the rules of law, yet acts in analogy to these rules whenever an analogy exists. Remember, that's the exclusive jurisdiction in B, contradistinction to the concurrent jurisdiction in A. Next paragraph. But the maxim in both these applications must be taken with this limitation, that equity will suffer the rules of law to govern and the course of law to proceed in absence, and only in the absence of any circumstance which renders it incompetent on the court of equity to interpose in accordance with the maxim previously mentioned, that equity will not suffer a wrong to be without a remedy. A. As an illustration of the first application of the maxim, the English Court of Chancery follows the law as the court of primogeniture, although the rule in many particular instances in which it is so followed may be productive of the greatest hardship towards all, or some, or one of the younger members of a family, by leaving them, for example, without any sort of provision while the eldest son may be in affluence. Here's the examples. These accidental circumstances create no equitable right or equity in favor of the younger son against the eldest, and do not demand the interposition of a court of equity. The mere absence or want of provision, a circumstance arising perhaps from the culpable neglect of the parent, his will, can create no equity against the eldest son, who has a right to the descended or entailed estate without any reference to the circumstances of the other members of the family. No relief could be given in such a case as that without directly breaking through a rule of law, which a court of equity never does. and has no power to do. And where the circumstances are of a different kind, that is to say, are sufficient to create an equitable right, and it comes right back down to the relation being the key. What type of relation is it? It establishes the equities between the parties. Continuing on, are sufficient to create an equitable right or equity, or even there are a court of equity never does break through the rule of law or refuses to recognize it because it has no power or no discretion in the matter, but while recognizing the rule of law and ever maintaining it, the court of equity will, in a proper case, get around, about, avoid, or obviate it. For example, if the eldest son should prevent his father from executing a proposed will, devising one estate to the younger brother, by promising to convey such estate to the younger brother, and that estate would accordingly descend at law to the eldest son, the court of equity would interpose and say, quote, "True, it is, you, the eldest son, have the estate at law. In other words, the legal estate. But we don't deny or interfere with, but precisely because you have it, you will make a convenient trustee of it for your younger brother, who, in our opinion, is equitably entitled to it." So therefore, it effectively sidestepped the court of law decision. It avoided it and obviated it in one little sidestep. Equity always follows the law, leaves it lay right where it was, but just walks right around it. Continuing on, and again in Loftus versus Ma, the testator in an advanced years and in ill health induced his niece to reside with him as a housekeeper on a verbal representation that he would leave her certain property by his will, which he accordingly prepared and executed, but subsequently by a codicil revoked. The court directed that the trust of the will in favor of the niece should be performed. It held that in the case of the kind of representation that property is to be given, even though by revocable instrument, is binding where the person to whom the representation is made has acted upon the faith of it to his or her detriment. So in other words, she put in all this time taking care of this guy, got kicked off, and all of a sudden he revoked his will somewhere along the line. No, she already put the consideration in of her time and relied upon it. That was a trust. Continuing on, and that it is the law of the court, grounded on this determined that it makes it binding, and that it does not matter that the represented mode of the gift is of an essentially revocable character. So there is no setting aside of law, but there is the kind of voiding of law as in the former case. I'll read that again. There is no setting aside of the law, because equity always follows the law. But there is the like of avoiding the law as in the former case. B. As an illustration of the second application of the maxim now being explained, it may be mentioned, but only briefly in this place, as the matter will be considered at proper length in the following chapter upon trust, that in construing the word of limitations of trust, estates, and deeds and wills, at least where the trust estate is executed, and in some cases where it is executory also, executory contract, to keep in mind, which are not really contracts, they're the formation of two simultaneous trusts. So where it is an executory also, the court of equity follows the rule of law familiarly identified as the rule in Shelley's case, and also observes all the other rules of law for the construction of the words of limitation of legal estates. But where the trust estate is executory only, and the court sees an intention to exclude the rules of law for the construction of the words of limitation, then it is in that case the court carries out the intention in analogy to the rules of law, but not in the servile obedience to them. where such obedience would defeat the execution of the intention. A and B next. As an illustration of the maxim in both these applications, we may refer to the manner in which the equity deals with the statutes of limitations for actions and suits. The old statutes of limitations were in their terms applicable to courts of law only. Statutes of limitations were in their terms applicable to courts of law only, not equity. Nevertheless, equity by analogy acted upon them and refused relief under like circumstances. Don't forget, it could always sidestep it. The rule of equity regarding the statutes of limitation may be stated, and it is believed with accuracy. Thus, in an exclusive jurisdiction, equity never exceeds, although for reasons of its own, such as lapses, etc., it often stops a long way short of within the limit of time prescribed at law, and that in a concurrent jurisdiction, equity never either exceeds or abridges the limit of time prescribed at law. This exemplifies the twofold operation of the maxim under discussion, equity in its concurrent jurisdiction being a slave to law, and in its exclusive jurisdiction being free within the limits of the law to give weight to considerations of its own, effectively bypassing the at law. Number 3, quae prior est tempore potor est jure. Where equities are equal, the first in time shall prevail. That's another maxim, so we'll pick up that, and that concludes what we'll talk about for tonight in the books. We'll start with a new maxim next week. So these maxims might not mean literally what they mean unless you studied them and found out that I know at least 2 of these maxims that do not mean literally what they say. And then when you study those maxims then, and you know what they're actually talking about, you become the key maker. And you can make the key that unlocks the door. Because like the bleary-eyed people who do not study, they can never see clearly because they don't have any equity spectacles on, and they do not see through this form, process, and procedures at law to see the true substance of the real rights of the real man, and they will ever be continually lost in legal land. Got to be doing the study, folks. You must know. Can't do a presumption. You got to become the key maker. So let's stop on one other thing here, touch on something else. We had a strictly legal case win just by litigation on a mortgage foreclosure, and I put a quick little thing in last night about it, but somebody brought up and says, well, okay, how's that tie in with NTT? Well, I put in there a little caveat. I said that NTT and equity is superior, and I would be studying NTT and equity besides focusing in on litigation. But the litigation, really, how we were winning, unless we really understood equity, we would never really understood how we were winning in doing strictly litigation. Because strictly litigation involves discovery. Discovery is purely equitable. Discovery is an equity. Discovery requests are equitable, operating in equity. Now, on a mortgage, In fact, everything that they're charging you with follows the pattern in Gibson's, which is really under part. What page is that on? Chapter 4, which is notice, les pendens, estoppel, acquiescence, negligence, laches, waiver, and consent. And I want to add one more on the end of that, which is contempt. And you want to see sections 918 through 924 for the contempt. But this notice and les pendens section, chapter 4, starts in 65, section 65 through 72. Yeah, 72. But if we jump to the contempt sections, basically the contempt sections in Gibson's talks about that a court looks at the defendant as being contemptible. Court looks at you as being in contempt. And you can't move forward on your defenses other than answer the plaintiff's complaint because you're imputed with unclean hands on you. You've got unclean hands and you can't move forward. There's no offensive thing the court will really honor, affirmative defense-wise, or moving off in an offense because you have unclean hands on you. And you need to impart that unclean hands off of you to the plaintiff to switch it. And there's two ways of going about that we talked about. One was coming in as a counterclaim, which you come in as counter-plaintiff, making a new claim, which is a new case, by filing the fee and paying the fee for the service of the sheriff so that you have a valid counterclaim. That's one way. Or you do the equitable discovery as defendant, and now we understand that that was equitable, and when they fail to respond to the equitable request of discovery, that takes and imputes the unclean hands from you and imputes it to the plaintiff. And here we're winning by strictly litigation methods, but it was really equity that saved our butts. We were really doing equity. And again, equity, trust lives solely in equity. So now we have an understanding, a better grasp of what was going and how we're winning. Just with purely litigation methods because we're doing discovery, and when they don't respond to the discovery request, then that switches the unclean hands from you to them. So that's the tie-in. Wasn't that we did anything under NTT? We just did an enforcement and utilized the maxims under equity through the discovery that they didn't respond to. So why don't we open up for Q&A? We've been going over the equity maxims, and we are on the second section, which is the first section was the enabling maxim section, of which there are 8. And we're on the restrictive section now, of which there are 6. So this is out of the Phelps book, which he breaks them down into 13 maxims. Now, depending on the author that you look at, there may be a few others, like Gibson talks about a few more than Phelps does, but Phelps goes over just 13. He breaks them down into 13, and we're working out of the Phelps book as the main book. So we're picking up on that book in section that's section 240. Between equal equities, the law will prevail. And that's on page 368 of the PDF, or page 328 in the book. Phelps book, page 368 in the book, section 240, that's page 328 in the book itself. Between equal equities, the law will prevail. There's a footnote there, footnote 1. Pomeroy Equity Jurisprudence, section 416, we'll be going there next. And also BizFam, section 40, we'll be going into that. It also says see Blacks versus Cord case, and a few other cases there in the footnote if you want to check them out. So section 240, between equal equities, the law will prevail. This and the following maxim each presupposes the existence of conflicting equitable rights in and to the same subject matter, which are equally honest and meritorious and equally founded upon sufficient consideration. Either alone would move the court into action as against the legal title. Either alone would move the court into action as against the legal title. Being equal, these conflicting equities simply neutralize each other, and equity declines to interfere, leaving the legal title stand. The most common illustrations are under what is called the doctrine of notice. Next section, 241, notice. Notice. A bona fide purchaser for value without notice of a secret equitable lien or unrecorded equitable title is considered as having an equal claim to the consideration of the court of equity with the holder of the equitable lien or title. His legal title will therefore prevail, and none of the equities therefore referred to as raised by the operation of enabling maxims is subject to be in this manner defeated by the defense of a bona fide purchaser without notice. A. Though fraud obtains a deed from B under such circumstances that a court of equity would decree a cancellation of the deed, or regarding that as done which ought to be done, would treat A, the holder of the legal title, as a trustee for B, who would be considered as still the real owner. But for any action taken by B to assert his equity, A promptly records his fraudulent deed and then sells to C, who pays value before he has notice of the equitable claim of the defeated or defrauded party. Here is a new equity raised upon in C upon his payment in good faith without notice, which is equal to the equity of the defrauded vendor. In such a case, the maxim of equal equities applies and the legal title prevails. But if C had either actual or constructive notice before he paid the money, then B's equity, being superior, would prevail over the legal title. That's footnote 1 in BizFam and Principles of Equity, section 262, and also in Pomeroy, section 591. Next paragraph. The doctrine of notice is one of constant application. Its leading rule is that the party taking with notice of an equity takes subject to that equity. See footnote 2. Another of its rules is that relating to constructive notice, when a party has information which puts him on inquiry, he is charged with notice of every fact that which inquiry would have developed. See footnote 3. Now you might want to see, I believe it's in UCC, although we don't use UCC, but it has a good explanation, and that is 1-201, notice. Gives a good definition there in UCC what notice is. Anything that puts you on inquiry where a prudent man should be looking up the facts and he doesn't, well, that would be willful blindness. Continuing on. This rule does not go so far as to require a party to act upon the assumption that every person with whom he deals is likely to be knave, Another familiar rule under the doctrine of notice has already been used by way of incidental illustration. All right, so Phelps breaks these down into groupings of restrictive, and in that restrictive section there are some subgroupings, and this one maxim that we're on now, that between equal equities the law will prevail, also takes in the second one, or the third one really, the next one, which is between equal equities priority of time will prevail. And those two are tied in together as acting as one. So we'll go into section 242, which is the next maxim, which is between equal equities priority of time will prevail. So the corresponding legal maxim is, and forgive my Latin, quae por est tempor petor est jure. When under the last maxim considered, conflicting equities are equal, so that the court has no other means of deciding, then as a last resort it falls back upon the legal principle of priority in the order of time. Hence it is apparent that in the mode of their restrictive operation, the two maxims relating to equal equities substantially coincide. One prevents equitable interference with a legal title and the other with the legal principle. As one equity is always prior in the date of the other, the expression equal equities, quote unquote, does not refer to equality in date. If upon comparing the rival equities, either is found in any respect defective, the reference is given to the other, irrespective of the date of origin. Or if any circumstance is discovered which commends the junior equity to consideration as the more meritorious claim of the two, that circumstance will decide the question of priority. I'm going to read that again. Or if any circumstance is discovered which commends the junior equity to consideration as more meritorious claim of the two, that circumstance will decide the question of priority rather than the order of time. How about if that circumstance was a trust? Next paragraph. In fact, it seldom happens that such exact equilibrium is maintained in the cases that description are rarely met with in practice. In this country, moreover, all conveyances and encumbrances are required to be recorded. And that's the problem we're having today in the United States in the recording industry and the banking industry, is the fact that we've bypassed black-letter law in recording of internal documentation transfers by mirrors. Continuing on, the effect of this system here, as in Ireland, is to preclude questions on equal equities, which often arise in England. See footnote 1. Go do priorities, next section, 243. The two maxims relating to the equal equities combine in producing the doctrine of priorities. The doctrine of priorities is practically a branch of the larger doctrine of notice and has just been very briefly adverted to. It must be remembered that both maxims relate to equities only. Equities only. In the absence of fraud or negligence amounting in effect to fraud, neither of them can be used to deprive the holder of the legal title of his advantage. Priority in this connection means priority of lien or preference in distribution, and not simply priority in point of date, although the latter, as just stated, the case of balanced equities, will generally determine the former. Any of the equities raised under the operation of the enabling maxims may come into competition with each other as a struggle for the preference or priority, such as the equity of a defrauded vendor and an equitable mortgage or other lien, the equity of an assignee over choice of action of an expectancy. One of the leading rules of determining priority is that an equity founded on valuable consideration is superior to an equity founded on mere voluntary transfer. Thus, a vendor's lien would be enforceable against the grantee of the purchaser, the consideration for the conveyance being natural love and affection. See footnote 2, Pomeroy, section 685. It results from the rule that when both the competing equities stand upon a valuable consideration without other circumstances, the equities are equal and the one prior in time is prior in right. Thus, under general assignment for the benefit of creditors, the creditors have an equal equity to that of the holder of the unpaid check upon the insolvent assignor's bank, and when notice of the assignment precedes the presentation of the check for payment, are entitled to priority. Between a mortgagee whose mortgage has been discharged of record through an unauthorized act of a third party, and a purchaser who buys in the belief, induced by such release, that the mortgage is satisfied, the equities are balanced, and the rights in the order of time must prevail, in the absence of negligence or a part of the defrauded mortgagee. An agreement giving an attorney a lien for professional services upon the judgment constitutes an equitable assignment of the judgment pro tanto, and by priority of time prevails over the equal equities of set-off acquired by the judgment debtor and by his purchase of a judgment against the plaintiff. On the other hand, the equity of the beneficial owner is superior to the legal title of assignees in bankruptcy or insolvency who take as volunteers subject to equities. An equity of subrogation to a purchase money mortgage is enforced as against a mortgagor's trustees in insolvency. Another rule for determining priority is that an equity to a specific thing or a specific lien is superior to a mere general lien, such as that of a judgment. The last rule that will be mentioned under this head is that the equity of a party who has been misled is superior to who has misled him. Okay, that finishes the Phelps book for that maxim, those two maxims, and we'll go on to the next. Next one we'll go to is Corpus Juris. Corpus Juris, Section 208. Section 208, that's page 234 in the PDF, or page 207 in the book. Section 208, 234 in the PDF, and page 207 in the book. Section 208, between equal equities, the law will prevail. Number one, in general. The maxim that between equal equities, the law will prevail is closely connected with the maxim that where equities are equal, the first in order of time will prevail, and has been termed as its complement, and that's why Phelps puts them and matches them together. So its general meaning is that unless one who seeks the aid of equity can establish an equity superior to that of the holder of the legal title to subject matter, he fails to overcome the legal right, which consequently prevails against him. This rule is most frequently enforced by supporting the legal title to land as against an equitable right no stronger than that of the legal owner. But the maxim is applicable to other species of property than land, and a superior legal right short of actual title have the same advantage. So the maxim is applicable to other species of property that land and superior legal rights short of actual title have the same advantage. The maxim is applicable where there is no equity in either party. Where the party having the legal right requires another interest inconsistent with his equity so that he cannot honestly claim both, his priority is lost and the equities will prevail in order of time. And there's a Latin term, ex vi termini. The maxim has no application unless the equities are equal. Section 209, number 2, junior equity acquiring legal title. The holder of a junior legal equity, by acquiring so the legal title, obtains the superior right, although at the time of doing so he had notice of the earlier equity and purchased the land estate for the purpose of obtaining the advantage, provided his equitable interest was required without notice of the prior claim. There is authority, however, for the view that the legal title also must be acquired without notice of prior equities in order to confer priority. Now the next maxim matching that, Section 210, between equal equities, the first in order of time shall prevail. is a maxim that between equal equities, the first in order of time shall prevail, but this and equivalent forms of stating the rule have been criticized as inaccurate. A more accurate statement is that between persons having only equitable interests, if other equities are in other respects equal, priority of time gives a better equity. Let me repeat that. The more accurate statement is that as between persons having only equitable interests, now that brings into the equitable nature versus equitable character as applied to legal titles, which is very interesting, a way of splitting hairs and using equitable character as a wrap for the legal title, which actually does not give it any beneficial nature at all, because a person can only transfer what rights he has in the title that he holds at the time of the transfer. So continuing on, it is essential to the application that this maxim that the interests of both claimants shall be purely equitable, for if one of the additions to the equal equity has also the legal title, he will prevail irrespective of the element of time. But where conflicting equities are otherwise equal in merit, neither claimant has the legal title. That which first accrued will be given preference. This test, however, is the last resort to and does not prevail when any other equitable ground for preference exists. It is only where the equities are equal and the element of time becomes material and decisive to the priority of right. Where the respective equities are not equal, the stronger or more meritorious one will prevail regardless of which accrued first in order of time. So, would a equitable character be equal to an equitable nature on a legal title? I don't think so. Continuing on, in determining the relative merits of the opposing equities, no technical rules are applied, but the question is determined on the broad principles of right and justice particular to courts of equity. If you're in a court at law, forget about this stuff. It does not even can't even be recognized. And where we go first into arguments, we go into, per the debtor-creditor voluntary act that we did, we voluntarily elect the legal realm, which is to the exclusion of your equitable substantive rights. We've been in the wrong courts, ladies and gentlemen, all this time. You're going into the courts at law, arguing substantive rights that you think you have, and a court can't hear you. In other words, you've taken your private natured substance and you crossed it over the boundary into the legal and commingled it with the public side. And you've breached the trust, and now you're in contempt. And you wonder why you go to jail, why you get foreclosed on, why they can't hear you. There's no beneficial nature that can be heard or character from the private side on the beneficial title can't be heard in the legal realm at all. And the warning shot across your bow of your ship, your vessel, is you need to go for a psych evaluation because you're commingling. You're breaching the trust, and we can't have that stuff in here because it's something that we can't hear. Continuing on, the last. The maxim has been applied to a great variety of cases, but perhaps its most frequent application is the determining the priority among the different lien holders. The rule will not be applied as against the preference given by the Recording Act. Now we go to BizFam next. Section 40, or number 4, Roman numeral 4. That's page 263 in the PDF or page 69 in the book. 263 in a PDF or 69 in the book. Two persons having each an If two persons have each an equally good equitable right, but one of them has legal title to the subject of the dispute, equity will not interfere, but leave them to the courts of law. When, of course, the holder of the legal title will prevail. Thus, if a purchaser for valuable consideration without notice of a prior equitable right obtains the legal estate at the time of his purchase, he will be entitled to priority in equity as well as at law. Indeed, the maxim in question goes further. For the bona fide holder of an equity who has acquired it for value without notice of a prior equity may, even after he has received notice of the prior equity, obtain an advantage by getting an outstanding legal title of his advantage of court of chancery and will ordinarily deprive him. A good illustration of the effect which equity gives to the acquisition of a legal title in those cases in which the equities are equal, as afforded by Thorndike versus Hunt, see footnote 4, where their trustee under two different settlements, having misappropriated the funds of one, replaced them by a transfer of funds belonging to another. In a suit instituted by City Key Trust under the first settlement, the trustee transferred the money into court, and the fund was treated as belonging to that estate, the legal title consequently resting on the account general for the purposes of that trust. The question was whether the City Key Trust under the second settlement had any right to follow this fund. It was held that he had not, because the transfer being without notice and for value, that is, in discharge of the debt due to the defrauding trustee, the City Key Trust under the first settlement had just as strong an equity to retain the fund as the City Key Trust under the second settlement had to follow it, and it therefore followed that the circumstances of the legal title being held by the accountant general for the former was enough to create a preference in his favor. See footnote 1, Snell's Equity, section 18 and 19. Now we want to back up, or let's see, we're going to go to section 45 in this book also to pick up that second maxim that is a tie-in. Same book, just go to section 45. Section 45, that's page 270 of the PDF or page 76. Section 45, number 9, Roman numeral. Between equal equities, priority of time will prevail. This is a rule which applies to determine the order between conflicting equities. If nothing else intervenes to turn the scale, the man who first in time will be first in right. The maxim is frequently applied in question to arise under titles acquired through equitable assignments, and that the nature of this doctrine and the reason of its application have been stated by a very high authority. Quote, I take it, said Lord Westbury in Phelps versus Phelps, or Phillips versus Phillips, quote, to be a clear proposition that every conveyance of the equitable interest is an innocent conveyance, and that is to say, the grant of a person entitled merely in equity passes only that which he is justly entitled to and no more. If therefore a person seized of an equitable estate, the legal estate being outstanding, makes an assurance by way of mortgage or grants as annuity, and afterwards conveys the whole estate to a purchaser, he can grant to a purchaser that is which he is the estate subject to the mortgage or annuity and no more. The subsequent grantee takes only that which is left in the grantor. Hence, grantees and encumbrances in claiming an equity take and are ranked according to the dates of their securities, and the maxim applies, quae prior est tempore petori est juror. The first grantor is petor, and that is potentior, and it is better and superior because a prior equity. See footnote 1. But in order that this maxim should apply, the equities must be equal. But in order for this maxim should apply, the equities must be equal. If they're not equal, it doesn't apply. Should they for any reason be unequal, should the balance be disturbed by fraud, laches, or negligence, the prior equity may be postponed. See footnote 2. Okay, that includes that book's tie-in. Now we jump to Snell's book. Snell. Snell's book, Section 3. That's page 49 in the PDF or page 20 in the book. Snell doesn't have any corresponding maxim to tie in with that, so. Snell, Section 3, page 49 in the PDF or page 20 in the book. By prior est tempore pretori est juror, where equities are equal, the first in time shall prevail. This maxim is often misunderstood. This maxim is often misunderstood. It's been understood by some as meaning that as between persons having only equitable interest, qua prior est tempore pretori est juror, but this proposition is far from being universally true. So here's the kind of like the reasons why Jesus taught in parables, where he said that was to hide the truth from those who shouldn't have it. And literally some of these maxims do not mean what they literally mean by what they literally say. Unless you do the study and dig into what they actually mean, because you'll find out that sometimes they mean something else. And there's a way of hiding the truth. And if you do the study, you find that you discover the truth, just like the key maker in the movie The Matrix was who they were looking for. And when you study these maxims and you find out what they are from the literal meaning, you become the key maker. You can get by the bleary-eyed watchers of our ancient legal treasures because you know how to navigate the clear path through the minefield, and you don't wake up the bleary-eyed watchers so that they hammer you. Continuing on, in fact, not only is it not universally true as between persons having only equitable interests, but it is not universally true even where the equitable interests are precisely the same nature, and in that respect precisely equal. For example, in the common case of two successive assignments for valuable consideration of a reversionary interest in stock standing in the names of trustees, if the second assignee had been given notice to the trustee for the first has admitted to do so, the second assignee has priority over the first. Another form of stating the rule is thus, quote, as between persons having only equitable interests, if their equities are equal, qui prior est tempore per est juror, this mode of stating that the rule is so obviously incorrect, yet when examined it has to be involved a contradiction. For when we talk of two persons having equal or unequal equities, in what sense do we use the word equity? For example, when we say that A has a better equity than B, what is it meant by that? It means only this, that according to those principles of right and justice which the court of equity recognizes, the court of equity recognizes, to the exclusion of at law, I might add, and acts upon, it will prefer A to B and will interfere to enforce the rights of A as against B, and therefore it is impossible, strictly speaking, that two persons should have equal equities, except in a case in which the court of equity would altogether refuse to lend its assistance to either party as against the other. If the court will interfere to enforce the right of one against the other on any ground whatever, say on the ground of priority of time, how can it be said that the equities of the two are equal? That is, in other words, how can it be said that the one has a better right to call for the interference of a court of equity than the other? The court may correctly state it thus, that as between persons having only equitable interests, if such equities are in all other respects equal, quae prior est tempora petori est jure, that in a contest between persons having only equitable interest, priority of time is the ground of preference last resorted to. That is, that a court of equity will not prefer one over the other on the mere ground of priority of time, until it finds, on an examination of the relative merits, that there is no other sufficient ground of preference between them. Or in other words, that their equities are in all other respects equal. If the one has only the other grounds a better equity than the other, priority of time is immaterial. Let me read that again. But if the one has on other grounds a better equity than the other, priority of time is immaterial. Now take that into consideration as the equitable nature versus the equitable character as applied to the legal title on the legal side. Continuing on, a single case will for the present suffice to illustrate the application of this maxim. A, B, and C, three vendors, entitled in common to a piece of land, sold the land to D. On the day of the completion of the purchase, A, B, and C, and D all attended the office of the vendor's solicitor. When D paid A and B their respective shares of the purchase money, but paid off C, who was a friend, until the day following, having promised C faithfully to pay him his portion of the purchase money on that following morning. Then A and B and also C executed a deed of conveyance to D, in which the payment of the entire purchase money was acknowledged by A and B and also by C, and A and B and also C severally also signed receipts endorsed on the deed of conveyance for their respective purchase monies. Then C very negligently and foolishly let D take away the deed of conveyance, together with the other deeds, in his bag, although C should have kept the deed and the deeds at his solicitor's until payment of his share of the purchase money. D the same afternoon deposited the deeds with his banks and never paid C at all. Held as between the bankers equitable mortgages by deposit, and C, vendor having equitable lien, that the bankers, although second in date, were first in right because of C's negligence. Next one that ties in, the next maxim, number 4, next page. Where there is an equal equity, the law must prevail. This maxim is intimately connected with the one immediate preceding it, which depends on the other for its complete elucidation, each of the supplement of the other. The maxim immediately under consideration may have thus briefly explained. If the defendant has a claim to a passive protection of the court equal to the claim at which the plaintiff has to call for the active aid of the court, he who has the legal title will prevail. The case of Thorndike versus Hunt, number 1, footnote, furnishes a remarkable illustration of this application of this rule. Trustee of a sum of stock for T was ordered in suit instituted by a city key trust, T, to transfer money into court. The transfer was made and the funds was treated as belonging to T's estate. The legal estate, therefore, vested in the accountant general, now paymaster general, for the purposes of T's trust. But it afterwards appeared that the trustee had provided himself with the means of paying T's fund into a court by fraudulently misappropriating funds which he held in trust for another set of key trusts, B. The question was whether B had the right to follow the money into the court as against T's estate. It was held that B had no such right, and for the following reason: that T had no notice of a want of equitable title or honest right to the trustee to make this payment with B's money, that the transfer was for valuable consideration because there was a debt due from the trustee from which the trustee could have been liable by execution of his goods or by other means, that therefore B's right of equity to follow the money being no greater than T's right to retain it, the circumstance that the legal title was held for T by the accountant general was sufficient to create a preference in favor of T. It is also observed that B was not altogether without a remedy, for of course he could proceed against a defaulting trustee personally for the money, for the trust money, but the case was a very hard one, and the like of which will not easily succeed again, the editor believes. See footnote 1. The most important class of cases in which the two connected maxims have received a principal application are those where a purchaser sets up the defense that he has purchased for valuable consideration without notice of the adverse title. The person setting up this plea thereby admits that on his purchase of a good title did not pass to him. It likewise assumes the conflict between the legal and the equitable title, or between the holder of the title, legal or equitable, and a person who is trying to assert an equity against him. In this event, from the nature of the case, that the question cannot arise between two legal titles, for their coexistence in the two adverse individuals in respect to the same subject matter is impossible, nor can the plea be used by a person having an equitable title against another having equal equity who is prior in point of time. Having premised this remarks with regard to the general scope of the species of defense, it is proposed to direct the attention of the student to the various cases in which the defense may or may not be made available. Rule number 1, where a person who sets up a plea has a legal estate, and remember there's always a corresponding equitable estate with a legal estate. They got to balance, or else there's no trust, or even the best right to call for a legal estate, a court of equity will grant no relief against him. Nothing can be clearer than a purchaser for valuable consideration without notice of a prior equitable right, obtaining the legal estate at the time of his purchase, is entitled to priority in equity as well as at law, according to the well-known maxim, where equities are equal, the law shall prevail. Thus, A, the owner of the estate, contracts with B to sell to him, and B pays part of his purchase money before the conveyance to him has actually been executed in law. Until the actual conveyance of the property to B, he has no title, whereas in contemplation of equity, which looks on as done which ought to have been done, B, from the moment of the contract, is the owner of the estate. If then A, after the contract of sale with B, makes an absolute conveyance of the legal estate to C, who purchases it for valuable consideration without notice to B's lien or claim, hereas C has the title, has the legal estate to him or in him, and has besides purchased bona fide for value without notice, and his equity to retain the estate is equal to B's right to enforce his equitable lien on it and claim to it. Therefore, the court of equity will refuse to give B any relief against C. Not only is it clear that a purchase for valuable consideration without notice of a prior equitable right, obtaining the legal estate at the time of his purchase, will be protected, but it has also been decided that such a purchaser who has not obtained the legal estate at the time may protect himself by subsequently getting in the outstanding legal title, so long as he does not, by that act, become a party to the breach of trust. So long as he does not, by that act, become a party to a breach of trust. Because as the equities of both parties are equal, there is no reason why the purchaser should be deprived of the advantage he may obtain at law by superior activity or diligence. Phelps versus Phelps, or Phelps versus Phillips, the law on the point It is thus laid down by Westbury, L.C. It is well known that if there are three encumbrances and a third encumbrancer at the time of his encumbrance and payment of his money had no notice of a prior encumbrance, then if the first mortgagee of the encumbrancer has the legal estate and the third pays him off and makes the assignment of his securities and the conveyance of the legal estate, he is entitled to track his third mortgage to the first mortgage that he has acquired and to exclude the intermediate encumbrancer. But this doctrine is limited to the case where the first mortgagee has the legal title, for if the first mortgagee has not the legal title, the third mortgagee, by paying off the first and obtaining a mere equitable transfer, acquires no priority thereby over the second. And not only where the purchaser has actually obtained, but where it has the best right to call from the legal estate, will be entitled to a protection of equity. Thus, in Wilmot versus Pike, a first mortgage of X estate to be made to A in fee, A's second mortgage in 1826 was then made to B of the same estate together with the Y estate by a release and conveyance of the respective premise to C as trustee for B, with the power of sale. B afterwards, in 1835, advanced a further sum to the mortgagor on a security of the same estate X and Y, but gave no notice of the further advance to A or C. Subsequently, C, in 1840, after inquiry of A, whether he had notice of any encumbrance other than his own, and that of which C was trustee for B, advanced a further sum on his or C's own account to the mortgagor on the same security, gave notice of his mortgage to A. The question and the cause arose between B and C in respect of the third and fourth mortgages of 1835 and 1840, respectively, as to which entitled to priority. It was held that as to X estate, B was entitled to priority over C, according to the maxim, quae prior est tempora priori est jure, for as regards the estate B and C, had only equitable interest, and the legal estate being outstanding in A, the first mortgagee. But with regard to Y estate in C, the fourth mortgagee having the legal estate in him, although by virtue only of his position as trustee in the second mortgage of 1826, and also having advanced his money without notice of B's further advance of 1835, was entitled to priority over B as to further advance. If the first encumbrancer had a declaration of trust only by the borrower and none by the trustee, and the second encumbrancer has a formal mortgage of the equity of redemption, and the trustee is a party to the deed and declares himself a trustee for the second encumbrancer, will not that declaration by trustee give the second priority over the first? I think the second would, in that case, have a better right to call for a legal estate than the first, and if it would be so the case of the stranger, I think the trustee cannot be precluded from his situation as trustee from claiming the benefit of the legal estate without notice. His case, however, might perhaps be supported on the simple ground that he had the legal estate and advanced his money without notice, leaving every trust of which he had notice untouched by his present claim. Cases where questions arise between volunteers and subsequent purchasers for value may also be classified under this head. A purchaser for value or mortgagee having obtained possession of all the title deeds would likewise have the best right to call the legal estate. Rule 2. Where an application is made to the auxiliary jurisdiction of the court, the contradistinguished from the concurrent jurisdiction by the possessor of the legal title, and the defendant pleads in his possession as a bona fide purchase for valuable without notice, and the defense is good, the court gives no aid to the legal title. The branch of the subject will be illustrated by the following cases. In Bassett versus Northworthy, the bill was filed in error at law, claiming under the legal title against the person claiming as a purchaser for value, purchaser for the devisee under the will of an ancestor, which will the plaintiff alleged had been revoked. The prayer of the bill was for discovery of the revocation of the will. The defendant pleaded that it was not purchased for valuable consideration, bona fide, without notice of any revocation, and the plea was allowed. Of course, the plaintiff might afterwards proceed at law in an action of ejectment endeavoring to make out his case upon his own evidence. Again, in Wallen versus Lee, a tenant in tail in possession under a marriage settlement filed a bill for discovery and delivered up the deeds of trust of the estate, which had been mortgaged by his father, who was tenant for life under a settlement and a private act of Parliament. The defendant pleaded that the plaintiff's father, alleging himself to be seized in fee and being in actual possession of the premise as apparent fee simple owner, and being also in possession of the title deeds relating thereto as apparent fee simple owners, therefore executed the several mortgages under which the defendant claimed, and the defendant averred that he had no notice of an alleged fact that the plaintiff's father was only a tenant for life. It was argued for the plaintiff that the defendant was neither in possession nor had the means of procuring it. The court ought to not allow him to keep the deeds for the sole purpose that counsel chose to call extortion. It was held, however, that the plea was a good defense. This bill, said Lord Eldon, is filed by a person having got possession if the principle is that the court will not stir against the purchaser for valuable consideration without notice, that the legal reason of the son, tenant in tail, when his father's estate determines, the legal rights are that he shall have possession of the estate. I do not know that I am entitled to such say as much of the title deeds, but only that the recovery and trover and a value of the deeds or in tenure in which the judgment is for the deeds or their value, but without attending to the imperfection of the law in such actions, it is probably the ground of jurisdiction for the specific delivery up of the thing. I will suppose his right at law to the specific delivery up. It is true he is not seeking an equity to recover possession of the estate, but he was seeking to recover something which he cannot recover at law, and the value of which non-constant he can recover at law without the discovery of the deeds. It is a necessity, then, that the court must hold as against the purchaser for valuable consideration without notice, that if the possession of the estate has been gotten from him, the possession of the deed shall be taken out of his hands by the court and thrown to the person who has got it from him the possession of the estate. It is not worthwhile considering rather whether the principle of the plea is not this: I have honestly and bona fide paid for this, and in order to make myself the owner of it, and you shall have no information from me as to the perfection or imperfection of my title until you deliver me from the peril in which you state I have placed myself in the article of purchasing bona fide. Principle of the last mentioned decision was followed by Lord Chancellor Sugden versus Joyce D. Moylan's. There, an heir law obtained possession of the title deeds relating to the impropriate ties, in which the second brother, under the will of the father, was tenant for life and deposited them with the bankers, and by way of equitable mortgage to secure the sum which the bankers advanced to him, on a bill being filed by the administrator of the bona fide creditor of the father of the administration of the estate, praying that the bankers might be decreed to deliver up the deeds. The bankers insisted that they were purchasers for valuable consideration without notice of the will or the title of any persons claiming thereunder, or of the demands of the plaintiff, and submitted to the bill should either be dismissed or that the plaintiff should pay off the mortgage. The Lord Chancellor dismissed the bill against the bankers with cost. Quote, I apprehend that the defense of the purchase for value without notice was a shield as well as against the legal as against the equitable title. That is, a good defense cannot be denied. Suppose a tenant for life under a will with remainder over, and the tenant for life, being heir at law of the testator, conveys the inheritance of the purchaser without notice. The remainder man cannot have any relief in equity against the purchaser. He must establish his title outside of this court as well as he can. It is the same as with respect to the title deeds. A defendant, therefore, uses the possession of the deeds as they have right to do as a shield to protect them against the plaintiffs, and they can make no use of the deeds themselves. They cannot maintain possession of them against the true owner. But if this court they give the right to say that they ought not to be compelled to deliver them up as they obtain them bona fide without any fraud. See footnote 1. But as already suggested, it seems to be the rule does not apply where the Court of Chancery concurrently with courts of common law afford legal as distinguished from equitable relief. And keep in mind today that the procedures or the rules have been merged in the two courts and they're acting as one, but they're still two separate jurisdictions. But the fact that they are concurrent, running simultaneously at the same time, the point is moot. Also applies to auxiliary. The case of William versus Lambry well illustrates this distinction, as a widow filed a bill against the purchaser for her husband claiming her dower. The defendant pleaded that he was not a purchaser of the estate for value without notice of the vendor being married. Lord Thurlow, however, overruled the plea. Rule 3. This rule is best stated in the words of Lord Westbury in Phelps versus Phelps. Now I take it to be clear proposition that every conveyance of an equitable interest is an innocent conveyance, and that is to say the grant of a person entitled in equity passes only that which he can justly entitled to, and no more. If therefore a person possessed of an equitable estate, the legal estate being outstanding, making an assurance by way of mortgage, or grants an annuity and afterwards conveys the whole estate to the purchaser, he can only grant to the purchaser what he has, namely the estate subject to the annuity or mortgage, and no more. The subsequent grantee takes only that which is left in the grantor. Hence the grantee and encumbrances claiming only in equity take and are ranked in the absence of exceptional circumstances, that is, according to the dates of the securities, and the maxims applies. Quae pari est tempore, petore est jure. First grantee is petor, and that is potentior, and he has a better and a superior because a prior equity. The first grantee has a right to be paid first, and it is quite immaterial whether the subsequent encumbrancer at the time took their securities and paid their money, had notice of the first encumbrancer or not. Thus in Ford versus White, the property in Middlesex was mortgaged to A and afterwards to B and subsequently to C with notice of B's encumbrances. C registered as mortgage before B and afterwards assigned to D, who had no notice of B's mortgage. Held by Sir J. Romilly, M.R., that as C's interest was equitable, he could not, by assigning it to D without notice, put him in a better situation than himself, and consequently than D was not entitled to priority over B, the prior registration by C notwithstanding. Rule 4. Where there are circumstances that give rise to an equity, you've got to determine the relationship first because that's key to the establishment of equities between the parties. So where are circumstances that give rise to an equity as distinguished from an equitable estate, for example, an equity to set aside a deed for fraud or to correct it for mistake or accident, the purchaser under the instrument puts forward the plea of purchase for valuable consideration without notice, and the court will not interfere. Thus in Sturge versus Starr, a man already married performed a ceremony of marriage with a woman and then joined with her in assigning her as life interest and trust fund to purchaser, held that it, though she might not have executed such an instrument, had she been aware of the fraud practiced upon her, the fraud could not affect the rights of a bona fide purchaser. This female had doubtless the strongest equity possible, but that equity, however strong in S, was no equity against the purchaser. No equitable doctrine is better established than the person who purchases an estate, although for valuable consideration, after notice of a prior equitable right, makes himself a malified purchaser, but will not be enabled by getting the legal estate to defeat such prior equitable interest, but will be held a trustee for the benefit of the person whose right he sought to defeat. Thus in Potter versus Sanders, it was held that if the vendor contract with two different persons for the sale of each to them of the same estate, and if the party to whom the second contract was made should, after the notice of the first contract, procure the conveyance of the legal estate in pursuance of a second contract, the court will, in a suit of specific performance by the first vendee against the vendor and the second purchaser, decree the latter to convey the estate to the plaintiff. and to such an extent as the doctrine of notice has been allowed to prevail, that has been given, and that is even infringed upon the policy of the Registrations Act. Thus, in Lee Neves versus Lee Neves, where the land in registered county settled on the first marriage by deed which was not registered, were settled upon a second marriage, the notice of the former settlement by deed which registered pursuant to the statute, it was held that the former settlement would be preferred in equity to the latter settlement. This is a species of fraud and dolus malus itself, and there is expressed knowledge that the first purchaser had the clear right to the estate, and with that knowledge an attempt was made to take away that right by getting the legal estate. It must be borne in mind that where the last mentioned case, the husband who registered the second settlement was the person to blame for not registering the first. It also requires a very strong case to get over the effect of the local registry acts. Example, express notice accounting to fraud is required, and merely constructive notice is not sufficient. It has long been settled that if a person purchases for valuable consideration with notice for a person who brought without notice, he may settle himself under the first purchaser, for otherwise the first or bona fide purchaser would not be unable to deal with his property, and the sale of the estate would be very much clogged. And even if a person who buys the notice sells to a bona fide purchaser for valuable consideration without notice, the latter may protect his title. In Harris versus Forth, A purchased an estate with notice of the plaintiff's encumbrance and then sold it to B, who had no notice, who afterwards sold it to C, who had notice. Held that A and C had notice, yet if B had no notice, the plaintiff could not be relieved against the defendant C. In a similar case, it had been assumed that the estate which A had, which had successfully assigned to B and C, was the legal estate. Had the estate been equitable, as will have been seen in the third rule of this maxim, A, having not notice to prior encumbrance, could not, by concealing his knowledge from B, make B's purchase more extensive than his own, or give a better right to assignee than which he had himself possessed. A purchaser for valuable consideration of an estate, even with notice of voluntary settlement, will not be affected by it, even though such voluntary settlement be in itself free from fraud and even meritorious as a provisions for relations, as it is a consequence of the words of the statute 27 Elizabeth, section 4, against fraudulent conveyances. Notice is either actual or constructive, but where there is, in general, no difference between them in their consequences, although in an exceptional case, as between just pointed out, constructive notice has not the effect of actual notice, and for many reasons it is necessary to distinguish between actual and constructive notice. Number one, as to actual notice, it suffices to say that in order to make it binding, it must be given by a person interested in the property and in the course of negotiations. Vague reports of a person not interested in the property will not affect the purchaser's conscience, nor will he be bound by notice of a previous transaction which he has forgotten, and not only in a mere assertion that some other person claims of a title not sufficient, but even a general claim by the person himself who gives the notice is perhaps not sufficient to effect a purchase. In the recent case of Lloyd versus Banks, it was laid down by Carnes L.C. that it could be shown that the trustee in any way had gotten knowledge of a kind to operate upon the mind of the rational man or man of business, and to make him act with reference to the knowledge so obtained, then there had been fixed upon the conscience of the trustee, and through that upon the trust fund, a security against it had been parted with in any way inconsistent with the encumbrance so created. 2. Constructive notice. Constructive notice in its nature is no more than evidence of notice, a presumption of which is so violent that the court will not even allow it being controverted unless by the most convincing evidence to the contrary. It is by no means easy to say that what accounts to constructive notice, for such depends upon the circumstances of each particular case. In the case of Jones versus Smith, Wigham v.C. states the law of the subject will with great clearness. The facts of the case were as follows. The person before advancing money on a mortgage inquired the intending mortgagor and his wife whether any settlement had been made upon their marriage, and they were informed that the settlement had been made, but of the wife's fortune only, and it is not included in the husband's estate. The only property in which the proposed has as a security. He then advanced the mortgage money, and without having seen the settlement or knowing its contents, held that the mortgagee was not, under the circumstances, affected with constructive notice of the contents of the settlement, or if the fact of the settlement comprised the husband's estate. It is scarcely possible to declare a priority has been deemed constructive notice, because unquestionably that which would not affect one man may be abundantly sufficient to affect another. But I believe I may, with sufficient accuracy for present purposes, assert that the cases in which the constructive notice has been established resolve themselves into two classes. First, cases in which the party charged with had actual notice of the property in dispute was in fact charged, encumbranced, and in another way affected. The court has thereupon bound him with constructive notice of the facts and instruments to the knowledge of which he has been held or had been led by inquiry after the charge, encumbrance, or other circumstances affecting the property of which he had actual notice. And secondly, the cases in which the court has been satisfied from the evidence before it that the party charged had diligently, designedly abstained from inquiring for the very purpose of avoiding notice, a purpose which, if proved, would clearly show that it had a suspicion of the truth, the fraudulent determination not to learn it. If proved, would clearly show that it had a suspicion of truth, that a fraudulent determination not to learn it. So not to learn it is a fraudulent determination. If, in short, there is not actual notice of the property in some way affected, and no fraudulent turning away from the knowledge of the facts, which res gesti would suggest to the prudent mind, if a mere want of caution, as distinguished from fraudulent and willful blindness, is all that can be imputed to the purchaser, then the doctrine of constructive notice will not apply. A purchaser will, in equity, be considered as, in fact, he is a bona fide purchaser without notice. An illustration of the first part of the rule has been cited in the case Biscoe versus Earl of Banbury. In that case, a person purchased with actual notice of a specific mortgage. The deed creating the mortgage referred to other encumbrances. Held that the purchaser, knowing of the mortgage, ought to have inspected the deeds and would have led him to knowledge of the other deeds, and the other way, the whole case must have been discovered by him. As an illustration of the second part of the rule may be cited in the case of Birch versus Elams, where the title deeds in the estate were deposited with the plaintiff as a security for his demand. The defendant, 14 years after, upon the eve of the bankruptcy of the mortgagor, took a mortgage. He had notice of the deposit with the plaintiff, but avoided acquiring the purpose for which it was made. The court decreed for the plaintiff. The mere absence of the title deeds has never been held sufficient per se to affect a person with notice if he is a bona fide inquired for the deeds and the reason excused, example, that a wife's maid jelly covers them, has been given for the non-delivery of them, or for the case of the court cannot impute fraud or gross and willful negligence to him, but the court will impute fraud or gross and willful negligence to a person dealing respectively in the estate if he omits all inquiries as to deeds. It is clear from the notice to the agent, attorney, or counsel for the purchase is, for certain purposes at least, constructive notice as to principal. And the same rules apply if the same agent be concerned for both the vendor and purchaser in the same transaction, even if the agent himself be the vendor. However, a notice to counsel, agents, and solicitors, in order to effect in equity their employers, must have been given or imparted to them the same transactions, for if the law were otherwise, it would make purchasers and mortgagees' titles dependent on the memory of the counsel or agents, where, however, one transaction is closely followed by connected with another, or whether it is clear where the previous transaction must have been present to the mind of the solicitor or counsel, even engaged in another transaction, there the second transaction is, to all intents and purposes, one and the same transaction. This subject was fully considered in Wigram versus V.C. in the important case of Fuller versus Bennett. There, after the commencement of the treaty on the sale, the estate by A and the purchase of it by B, A agreed to give C a mortgage on the estate as a security for the antecedent debt. The notice of the agreement with C was given to the solicitors of B, the purchaser. The treaty for the sale by A to B afterwards ceased to be prosecuted for 5 years, and many things, of course, happened in the meantime. A then died, and B purchased the estate, and at a lower price from the heir and divisee of A. B conveyed the estate and mortgage to D. The same solicitors were concerned for B for the commencement of the treaty with A until the final purchase of the estate, and for D in business of the mortgage. It was held under the circumstances of the case that B and D had, through their solicitors, constructed notice of the agreement with C, and that the estate in their hands was subject to the lien of C for the amount agreed to the secured by the proposed mortgage. In the judgment, his lordship thus succinctly lays down the general rules. General proposition: first, the notice to the solicitor is notice to the client. Secondly, where the purchaser employs the same solicitor as the vendor, he, the purchaser, is affected by the notice of whatever the solicitor had notice in his capacity of solicitor of either vendor or purchaser in the transaction in which he is so employed. And thirdly, the notice to the solicitor, which will alone bind the client, must be noticed that the transaction in which the client employs him have not, in general propositions, been disputed at the bar. Finally, in order to affect a person with constructive notice of facts within the knowledge of his solicitor, it is necessary not only that the knowledge should be derived from the same, or what is practically the same, transaction, but the knowledge must be material to that transaction, and as such as was duty of the agent to communicate to his principal. See Weil versus Paulin, where it was held by Lord Wesley C. that the transferee of the mortgage would not be affected by the knowledge of the solicitor acting for him in the transfer of the encumbrance subsequent to the original mortgage, so as to prevent him from taking further advances, such knowledge not being material to the business of the transferor. And of course, the limit to the rule is only reasonable. In fact, the court very much dislikes the third variety of constructive notice, and the person who relies upon it must prove it very strictly. 5. He who seeks equity must do equity. 6. He who comes into equity must come with clean hands. And 7. Equity aids the vigilant, not the indolent. In other words, delay defeats equities. These three maxims must be viewed together in illustrating the great distinctive and governing principles of equity, and nothing can call forth a court of equity into activity but conscience, good conscience really, and good faith and personal diligence. And that concludes that book. Let's jump to Gibson's now. Gibson section 54. That's page 72 in the PDF or page 46 in the book. Section 54. Where there is equal equity, the law must prevail. If two persons have equal equitable claims as to the same subject matter and as to their equitable interest therein, are equally entitled to the aid of the court, but one of them has the legal estate to said subject matter, then he will prevail. The Latin term here, forgive my Latin, which means where the right is equal, the condition of the possessor and of the defendant is the better. Where the right is equal, the condition of the possessor and of the defendant is better. The equity is equal between persons who are equally innocent and have been equally diligent. It is upon this account that the Chancery Court constantly refuses to interfere, either for relief or discovery, against a bona fide purchaser of the legal estate for valuable consideration without notice of the adverse title, if he avails himself of the defense at the proper time and in the proper mode. Proper time and in the proper mode. In such a case, the equities being equal, the legal title prevails. Now the corresponding maxim, section 55, where there are equal equities, the first in order of time shall prevail. This maxim is generally given in its Latin form, quae prior est tempore potori est jure, he who is prior in time is superior in right. The maxim is sometimes misunderstood and misapplied. Its true meaning is this: as between persons having equal or equitable interests only, if their interests are in all other respects equal, priority in time gives superiority in right. In a contest between persons having only equitable interests, priority of time will give superiority of right, provided there is no other sufficient grounds of preference between them. Provided there is not other sufficient grounds of preference between them. Section footnote 68, which is Pomeroy Equity Jurisprudence, section 414 and section 678 through 734. Continuing on, for if the equities are equal and one of the parties has in addition the legal title, then another maxim would apply. Where there is equal equity, the law must prevail. See section footnote 69. Court of Chancery in the conflict of equities, the party having the superior equity will prevail, and if the equities are equal and neither party has the legal title, then priority prevails, and if no priority, the defendant prevails. Under the operation of this maxim, grantees and encumbrancers take and are ranking according to the dates of the securities. Parties claiming liens or having judgments or attachments or execution liens or assignments all hold in order of time, provided there is no other ground of preference. In a race of diligence between creditors having equal rights in law or equal rights in equity, he who is first in time becomes first in right, for equity regards according to diligence. And that takes care of my friend Gibson. How long this section is here, starting in 416 in Pomeroy. I wanted to go to another section because he's got two. They're relatively short. Let's see if we'll finish it up. All right, we're going to Pomeroy, the last book, section 416. That's on page 760 in the PDF or page 693 in the book. And then we're going to jump to section 413 for the backup maxim. Section 416, where there are equal equities, the law must prevail. Its application. 416. Section 416, its application. This maxim and the one examined in the last preceding section, which we're going to jump back to. We're starting with this one first. The preceding section must be taken in connection, and in order to constitute the enunciation of the complete principle. The first applies to the certain condition of facts, and the other supplements its operation by applying to additional facts for which the equitable rights and duties may be affected. The two are, in fact, counterparts of each other. They work in conjunction. And taken together, they form the source of the doctrines. In their entire scope concerning priorities, notice, and purchases for valuable consideration and without notice, any full examination of these two maxims and an explanation of their effects would of necessity be a complete discussion of those doctrines and will therefore not be attempted at present but will be postponed to a subsequent chapter. See footnote 1. See the next chapter sections on priorities and notice. So 417 now, its meaning and effects. The meaning of the maxim is if two persons have equal equitable claims upon the interest in the subject matter, or in other words, if each is equally entitled to the protection and aid of the court of equity with respect of his equitable interest, and one of them, in addition to his equity, also obtains the legal estate in the subject matter, then he who thus has the legal estate will prevail. Thus, precedents of the legal estate might be worked out in a court of equity, refusing to interfere at all, and thereby leaving the parties to conduct their controversy in a court of law, where the course of legal estate alone would be recognized. See footnote 1, Thorndike versus Hunt, and a bunch of other cases there. One of the most frequent and important consequences and applications of this principle is the doctrine that when a purchaser of property for valuable consideration and without notice of a prior equitable right or to interest in the same subject matter obtains the legal estate in addition to his equitable claim, he becomes, in general, entitled to a priority both in equity and at law. Now let's back up to Section 413. Section 413, that's on page 755 in the PDF or page 688 in the book. Where there are equal equities, the first in order of time shall prevail. Section 413, its application. The equities spoken of in this maxim embrace both equitable estates, interests, and primary rights of property, such as the Sedekey Trust estate in any species of trust, the mortgagee's equitable interest, equitable liens, and interest of the assignee under an equitable assignment, and the like. Also the purely remedial rights or rights to some purely equitable remedy to which the distinctive name equity has been given by modern judges and text writers, such, for example, as the equitable right to the reformation. With respect to equities considered in this comprehensive matter, and to legal interest, the maxim quae prior est tempore petore est juror is of wide and importance application in both equity and at law. Next section of 414 is true meaning. Rice versus Rice. True meaning and effect of the principle, when there are equal equities, the first in order of time shall prevail, often have been misunderstood. And its correct signification cannot be better explained than by employing the exact language used by a very English equitable judge in a recent case, footnote number 1, Rice versus Rice, as follows. Quote, what is the rule of the Court of Equity for determining the preferences as between persons having adverse equitable interests? The rule is sometimes expressed in this form. As between persons having only equitable interests, quae praetori est tempore praetori est juror, is incorrect statement of the rule, for that proposition is far from being invariably true. In fact, not only is it not universally true as between persons having only equitable interests, but it is not universally true even where the equitable interests are precisely the same nature, and that respect precisely equal. It can be of the same nature to be precisely equal. Not character, nature. As in the common case of the two successive assignments for valuable consideration of reversionary interest in stock standing in the name of the trustees, where the second assignee has given notice to the trustee and the first has omitted it, see footnote 2. Here the second assignee would obtain priority over the first. Continuing on. Another form of stating the rule is this. As between persons having only equitable interests, if their equities are equal, quae pure est tempore petore est juror, thus form of stating the rule is not so obviously incorrect as the former. Yet even this enunciation of the rule, when accurately considered, seems to me to involve a contradiction. For when we talk of two persons having equal or unequal equities, in what sense do we use the term equity? For example, we have say that A has a better equity than B, and what is meant by that? It means only that according to the principle of right and justice that a court of equity recognizes and acts upon, it will prefer A to B and will interfere to enforce the rights of A against B, and therefore it is impossible, strictly speaking, that two persons should have equal equities except in a case in which a court of equity would altogether refuse to lend its assistance to either party as against the other. If the court will interfere to enforce the right of one against the other on any ground whatever, say on the ground of priority of time, how can it be said that the equities of the two are equal? That is, in other words, how can it be said that the one has a better right to call for the interference of a court of equity than the other? To lay down the rule, therefore, with perfect accuracy, I think it should be stated that in some form as thus: as between persons having only equitable interests, if their interests are in all other respects equal, priority in time gives the better equity, or by prior est tempore potori est jure. I have made these observations not, of course, for the purpose of mere verbal criticism on the enunciation of the rule, but in order to ascertain and illustrate the real meaning of the rule itself. And I think the meaning is this: that in the contest between persons having only equitable interests, priority of time is the ground of preference last resorted to. That is, that a court of equity will not prefer the one to the other on a mere ground of priority of time until it finds upon the examination of other relative merits that there is no other sufficient grounds of preference between them. That there is no other sufficient grounds of preference between them. Or in other words, that their equities are in all respects equal, and that if one has on the other grounds a better equity than the other, priority of time is immaterial. See footnote A. Examining the two relative merits or equities, the two parties having adverse equitable interests, the point to which the court must direct its attention are obviously these: the nature and condition of their respective equitable interests, and the circumstances and the manner of their acquisition, and the conduct of each party with respect thereto. Conduct of the party? Conduct of the party, of each party with respect thereto. And in examining these 2 points, these points, it must be applied the test, not of any technical rule, according to common law, or any rule of partial application, but the same broad principles of right and justice which the court of equity applies universally in deciding upon contested rights. C3b. Says, I add in the foregoing that the following language of another most able equity judge in the celebrated case of Phelps versus Phelps again, quote, I take it the clear proposition that every conveyance of an equitable interest is an innocent conveyance, that is to say, the grant of a person entitled merely in equitable passes only to which it is justly entitled to and no more. If therefore the person seized of the equitable estate, the legal estate being outstanding, makes an assurance by way of mortgage or grants an annuity and afterwards conveys the whole estate to a purchaser, he can grant to the purchaser that which he has, viz. The estate subject to the mortgage or annuity and no more. The subsequent grantee takes only that which was left in the grantor. Hence, grantee and encumbrancers claiming in the equity take and are ranked according to the dates of their securities, and the maxim applies quae priori est tempore potori est jure. The first grantee is priori, and the other one is potentior, and has been better and superior because the prior equity. The first grantee has a right to be paid first, and it's quite immaterial whether the subsequent encumbrances at the time when they took their securities and paid their money had notice of the encumbrances or not. Continuing on, Section 415, its effects. It follows from this application of the principle that when several successive and conflicting claims upon or interests in the same subject matter are wholly equitable, and neither is accompanied by the legal estate, which is held by some third person, neither possesses any special feature, or incident which would, according to the settled doctrines of equity, give it precedence over the others wholly irrespective of the order of time. Under these circumstances, the principle applies. Priority of claim is determined by priority of time. See footnote 1 and A. There are, however, many features and incidents of equitable interests which prevent the operation of this rule. However, there are many features and incidents of equitable interest which prevent the operation of this rule and which give a subsequent equity the precedence over a prior one, as will be fully shown in the next chapter. The principle embodied in this maxim lies at the foundation of the important doctrines concerning priorities, notice, and the rights of purchasers in good faith and for valuable consideration, which so largely affect the administration of equity jurisprudence in England, though to a less extent in the United States, and which are discussed in the following chapters. And that concludes the dissertation, quite lengthy dissertation for tonight. We'll pick up on the next maxim next time, which will be, let's see here, he who seeks equity must do equity. He who seeks must do equity. It's going to start on page 373 in the PDF, or it's going to start section 244 in the book of Phelps, and that's where we'll pick up next time. Over the several weeks, we've been going over the maxims out of the Phelps book, and we did the enabling maxims first, the first section, and we're on the second section, the restrictive maxims, because they're broken down into two sections, enabling and restrictive. And the restrictive section, we're going into now the fourth maxim of the list there on the restricting maxims, which is he who seeks equity must do equity. And that starts on the Phelps book, which is section 244, Roman numeral 4, in the restrictive maxim section, or it's 373 in the PDF or 333 in the book. 373 in the PDF or 333 in the book. All right, opening on up in the Phelps book there, section 244, 373 in the PDF, 333 in the book. Maxim, he who seeks equity must do equity. So we now come to the last group of three hard-working maxims. So within the group, they're grouped within themselves. And these next three maxims will work as a group, really. So we now come to the last group of three hard-working maxims, each of them first-class importance. First-class importance, both theoretically and practically. They are closely connected and often so blended in their pronounced restrictive effect that it is difficult to distinguish their separate operation. And that's footnote number 1, Sperhawk versus Yerkes. So for many purposes, they might be treated as one consolidated precept. He who seeks equity must do equity, must come with clean hands, and come promptly. So there's the three maxims all grouped together. He who seeks equity must do equity, and the next one must come with clean hands, and the next one, the last one, must come promptly, because equity aids the vigilant. Referring to the common equitable defenses before enumerated, it will be found upon examination that all of them are based upon this group of maxims. See section 160, ante. The fourth and fifth stand preemptively for conscience, and the sixth for public policy, although both factors are more or less apparent in each. They are all universal, and constant application in every variety of case in which the plaintiff seeks to set in motion the machinery of equity for the purpose of justice or oppression, or to secure an undue advantage, or to profit by his own wrong or in spite of his own neglect. Taken together, they illustrate the often quoted expression of Lord Camden, quote, "Nothing can call forth a court of equity into activity but the conscience, good faith, and reasonable diligence, and where these are wanting, the court is passive and does nothing." See, again, section 160, ante. Next section, 245, older applications. Taking up the maxim, he who seeks equity must do equity, there are one or two worn-out applications which must be first disposed of, simply because they are so often made to figure as stock illustrations. The wife's equity to a settlement is one of them. Section 246, wife's equity. The wife's equity has been already referred to in another connection as superseded by modern legislation. Nothing further need be said of this obsolete doctrine except to state that it applied when the husband was obliged to resort to the court of equity to obtain possession of his wife's funds, and that the court required him to do equity by making a fair settlement upon his wife. So he who comes into equity must do equity really boils down to whoever comes into equity asking equity to do something for it must realize and recognize also. That is equal and fair. Both parties have equal rights, and the other party coming in and bringing the action against you must recognize your rights, or else they can't ask equity to do them. Next section, 247, usury. In the case of usury is analogous. And the state of the law was such that the effect of usury was to absolutely avoid the contract. The borrower, claiming the intervention of equity to set it aside, was granted relief only upon his doing equity by paying the real debt with legal interest. Since the only forfeiture now is as of usurious excess, this illustration also is of merely historical interest. Next, 248, tracking consolidation. The English doctrine of tracking mortgages was in part referred to this maxim, but more appropriately belongs to the second restrictive maxim. See reference 5, Bispham Principles of Equity, section 158. Unlike most equitable doctrines, it is not founded in justice. It is not founded in justice. Footnote 1, case cite there. As has been generally rejected in this country as inconsistent with the registration system. It is only mentioned in this connection because a modified form of the doctrine under the name of consolidation of mortgages happens to be left in such an unsettled condition in this state by reason of cantinia or orbitur dicta, and which may possibly make some figure in the equity litigation in the future. In this retrenched form, tracking or consolidation is distinctly attributed to the maxim now under consideration, and the means of it is this, quote, that in order to prevent circuitry of action and upon the principle that he who seeks equity must do equity, if a mortgagor goes into equity to redeem, he will only be permitted to do so upon payment, not only of the mortgage debt, but of all debts due from him to the mortgagee, unquote. See footnote 2, another case. But the rights of third parties will not be allowed to be prejudiced by the operation of this doctrine, which, as against creditors and assignees of a mortgagor who may seek to redeem, should seem inconsistent with the provisions of this registry law. See number 3, footnote. No instance can be found on the actual application of the doctrine in this state. Now, if we back up a bit, you could apply that to what's happening in the banking industry today. Next section, 249, modern applications, partition. A plaintiff suing in equity for a partition must contribute his portion of the mortgage on that land which had been paid off by the defendant. If, in the case of partition, the defendant had made improvements on the common property, the court will give him the benefit of them by allotting to him, so far as practical, the part of the land improved, according to the actual value of the land itself, without the improvement. See footnote 2. When the improved portion has been leased, the ground rents are not to be charged to the defendant to taking an account of mezzanine profits. So if there is any really foreclosure penalties and forfeitures in there, like deficiency judgment, equity abhors penalties and forfeitures. And equity will eat out the injustice of the at-law side, just like it ate out the heart of the injustice of the common law courts. And the maxim that equity follows the law is like this. Equity follows behind the law, sweeping up its mistakes and cleaning up after it to its injustices and correcting them, the harshness of them. That's the true meaning of that. Equity follows the law. It does not have to do the law at law. It cleans up after the law and makes its corrections of the law's mistakes. Section 250, compensation. Upon the same principle, when a court of equity is asked to vacate a deed obtained by a trustee from a city key trust, the latter will be required to refund the purchase money with interest. So when the plaintiff seeks to dispossess a bona fide occupant who has made valuable improvements on the land, supposing his good, the former will be required to take due compensation to the latter. And the same equity of compensation for betterments had been applied in the case of a trustee who had purchased trust property and had been disposed at a suit of his cessity trust. See footnote 1, case cite there. So in cases of specific performance, like breach of contract, when a vendor is unable to convey to the vendee to the full extent agreed, but has acted in good faith, the deficiency is comparably immaterial. The vendor may still be entitled to enforce the contract so far as may be, but in such case he must also do equity by compensating the vendee or submitting to the proportionate abatement from the contract price. See footnote 2. An apt illustration of the maxim of its purely defensive operation is afforded by fraudulent construction company. Contracts to build railroads for illegitimate profit for directors. On a suit to foreclose a mortgage made in pursuance of such a contract, defrauded stockholders were allowed to intervene by cross-bill, contesting the validity of the mortgage. They thus made themselves actors, and as such were held amenable to the maxim, and they who seek equity must do equity, which in this case required fair compensation for work actually done. So it is just that they should pay a fair share or fair price for what they had received, that this mortgage, given for the construction of the road, though excessive by reason of fraud in the contract, should stand for the reasonable value for what the company actually received in the way of construction. See footnote 3 for the case on that. Next section, 251, election. Proceeding from the same maxim as the application of the doctrine of election expressed in the rule, one who receives the fruits of any transaction cannot deny its validity while it's retaining its benefits. It's either one or the other, to the exclusion of the other. Choose one. See footnote 1 for case sites on that. A creditor, for instance, who participates in the distribution under a deed of trust elects to abide by its validity and waive his paramount lien. Waive his paramount lien. Wonder if that could be applied to a bank. When you get them into a trust, they waive their paramount lien. A creditor will not be permitted to claim a destructive share of an insolvent estate and at the same time impeach the adjudication by which the debtor was adjudicated insolvent. But a creditor filing a claim under a deed of trust is not thereby precluded from proceeding against the assigner in insolvency. A party who has accepted office under a questionable appointment is not allowed to dispute the title of others holding under the same appointment. Where the consideration of a husband's debt went to the wife's separate use, no injunction will be granted at her instance to restrain the husband's creditors from taking her property. Election is often confounded with estoppel, and both doctrines savor of laches or acquiescence. It is in the application of these doctrines that the maxim in question most frequently combines its operation with other two maxims of the same group. Now 252, estoppel. He who has been silent when he ought to have spoken shall not be heard to speak when he ought to be silent. Let me check something here. Yes, that's still under that maxim. So the principle of estoppel is that when one party to a transaction has, by his representations, conduct, or silence, obtained an unfair advantage over the other, he will not be permitted to avail himself of it by any court of justice. This remedy is always so applied as to promote the ends of justice. It is available only for protection and cannot be used as a weapon of assault. Estoppel is a rule founded in justice which prevents a party from alleging anything contrary to the conventional state of things on the faith and of the truth of which he has induced another to act. This doctrine of equitable estoppel, or estoppel in passe, stands upon the broad ground of public policy and good faith, is interposed to prevent injustice and fraud, and is freely adopted and applied by courts of law. It applies to corporations, to married women, and in measure to infants. To make a principle of estoppel available, there must be fraud or its equivalent in culpable negligence, and a negligent must have been proximate to the cause of the loss, and a neglect of some duty owing to the party misled or to the public. The statements relied must have been with full knowledge of the party of all the facts affecting his rights. Misrepresentations will or must have been as to alleged existing facts or promises are binding only as contracts. When the doctrine is evoked concerning the title to land, the party misled must not only appear to have been ignorant of the true state of the title, but without the means of acquiring knowledge. Section 253, other instances. When a transaction is sought to be avoided on the ground of fraud or mistake, which is rescission, in parenthesis there, in italics, the plaintiff must do equity by restoring the defendant as nearly as possible to the original condition, status quo, by returning the consideration. But the operation of the restrictive maxim in such a case may be itself restrained by higher consideration of public policy. Thus, where a suit by a state to cancel a sale of school lands is obtained by bribery of the state agent, the defendant insisted that the state should do equity by returning the consideration. The court nevertheless decreed cancellation absolutely, without return of the money paid, upon the ground that the party ought not to be permitted to corrupt public officers with entire safety to himself. Trustee misappropriates trust money, breach of trust in other words. It has an equitable interest of his own at the same time. The court will not allow him to receive any part of the trust fund in which he is equitably interested until he has made good his default as trustee. Otherwise, if a trustee interest is a legal one. As a general rule, the owner of a taxable property who seeks to enjoin the collection of taxes which he claims to be in excess of what is lawful must do equity by paying or tendering so much of the tax as is justly due. An absolute deed will only be declared a mortgage upon payment of the debt secured. The power of late exercised by courts of equity to make railroad receiver certificates prior liens over existing mortgages is claimed to be legitimate application of the maxim, which compels the plaintiff, the trustee under the defaulted railroad mortgage seeking foreclosure, to do equity by paying current debts out of current receipts. The equity treats everything as being fair and equal, and you get no more than wants the performance for what it was bargained for. None of this at-law stuff, take the house, take everything the guy's got, come in and make it so that he owes even more on the deficiency judgment and force him into bankruptcy. Equity will not allow that. Section 254, when available to plaintiffs, protection afforded by this maxim is also available to the plaintiff when occupying a defensive position, as when a defendant sets up a claim to some affirmative relief. Thus, where a bill to enforce a lien and a claim for rents and profits, there was a plea for limitations as the rents and profits, and the affirmative claim the answer to the allowance of improvements. The court compelled the defendant to do equity by deducing the allowance for improvements from the whole amount of rents and profits, including those barred by limitations. And where to a bill for foreclosure, the defendant filed a cross bill setting up a mistake in the mortgage by which property was included which was intended to be accepted, that's E-X-C-P-T-E-D, and the court held that by doing the simple equity of paying the mortgage debt, the defendant could extinguish the mortgage altogether. Extinguish the mortgage altogether. Now let's take and say, okay, a $100,000 house, by the time you get done paying for it in 30 years, costs you 3 to 5 times more than what you paid for it. Is that equitable? I don't think so. So equity would eat out the heart of the interest and just pay the principal and whatever interest is fair and just, not 3 to 5 times the interest. Get it? The power of equity? Next section, 255, qualification. This maxim does not mean that the plaintiff must do equity to the defendant in all transactions which have ever taken place between them, but only with respect to the transaction with which the plaintiff is seeking equity, and such as are equitably related to. It is for the court to determine upon the circumstances of each case whether there is a requisite equitable connection between the grounds of the complaint and the defense. And as even in such case, the operation of the maxim may be defeated by a paramount and special public policy. Special public policy? That's the exception to the privateness. Section 256. Next maxim, he who comes into equity must come with clean hands. We'll pick up there on the next time, but we're going to jump to a next book now. That'll be the next one to go on. Next book is Corpus Juris. We're going to Corpus Juris next. Corpus Juris, that's section 151. That's page 199 in the PDF, or page 172 in the book. 199 in the PDF or 172 in the book, section 151. So let's begin at the top there at 150. A, in general. This is talking about the maxims in general. Before we actually jump to he who seeks equity must do equity. In general, A, pervading the administration of equity in all its branches, there appears a recognition of certain broad principles so generally accepted and of such fundamental character that they have become known as maxims. These maxims are, in the strictest sense, principia, beginnings out of which have developed the entire system of equity jurisprudence, having not anywhere been authoritatively declared as a code of rules. They have not been expressed in precisely the same form by different writers, and treatises are not in accord even as to what precepts should be dignified as maxims. In their application, they are subject to limitations and exceptions, and sometimes one maxim restricts or limits the use of another, or in combination of several maxims, which we've been discussing, may control the decision. And I have used these three maxims, the one we're on now and the two following that, in a group, in a case that has won. They are applied in the status of the case and the parties as they stand at the time of the relief as administered by the decree, rather than at the date of the institution of the suit. The maxim of equity will not be applied for the purpose of defeating equity. Now, Section 151, he who seeks equity must do equity. In general, he who seeks equity must do equity. The maxim expresses a cardinal principle and is the oldest of the equity jurisprudence and is the most extensive application, being applicable to all classes of cases wherever necessary to promote justice. Maxim is, however, a general guiding principle in the administration of equity rather than the exact rule governing the specific and well-defined cases. That would be the rules, the exact case, the sites and things. But if you look at a lot of Supreme Court decisions from the chat group and things, you will find out that the appellate courts and the Supreme Courts, they go by maxims. They quote the maxims. Section 152. Number 2, scope and limitations of the rule. A, in general. The maxim requires that any person seeking the aid of equity shall offer to accord, or will be compelled to accord to the other all the equitable rights to which the other is entitled in respect to the subject matter. Relief inconsistent with the equities of the adverse party will be denied, and where the granting of the relief raised equitable rights in favor of the defendant, the according of such rights will be imposed as a condition of granting the relief. However, the maxim and its application is subject to certain restrictions and limitations. The maxim should be applied only to cases where the result would be worked out without its aid and would be against equity and good conscience. The party seeking relief is not required to sacrifice his own rights. Next, 153, as a department of nature of action or relief sought. The application of this maxim being restricted in suits and equity to the cases where the plaintiff is wholly without remedy at law and entirely dependent upon a court of equity for relief, where a party has a legal right capable of effectually asserted at right, ask for assistance of the court of equity because of some serious, although non-insurmountable difficulty at law, such as the taking of an account, the necessity of discovery, the existence of a trust, or some collateral ground, such as to prevent an improper disposition of a subject pledged for the security of a debt by which the rights of the party complaining may be affected. The court can impose no condition upon the mere ground that the party applies for relief, and is bound to give that relief according to the legal rights of the parties. It has been held that as anyone going into equity and asking its aid, whether that aid is such as could be obtained in a court of law, or whether it is of a character obtained only in a court of equity, so submits himself to the jurisdiction of the court as to be bound by the maxims. Bound by the maxims. If you come into a court of equity, that court is bound by the maxims. That is the discretion in which the judge rides on a narrow railroad track that only goes between 2 points determined by the maxims. Continuing on, the maxims does not apply to cases where the party is not seeking to avail itself of the ordinary equitable jurisdiction of the court, but is seeking to avail himself of a substantial right under the express provisions of the statute. It is not available as against defendant, although seeking relief by cross-bill, where the relief prayed is only incidental to the defeat of plaintiff's claim. If, however, defendant by way of a cross-bill seeks affirmative equitable relief, the maxim is applied so far as the relief thus sought is concerned. Defendant may rely upon a legal defense without reference to the maxim, and if such defense is established, it's entitled to prevail. The maxim cannot be applied where the parties have stipulated for a purely legal liability and the suit is upon such obligation. Next section, 154C, restriction to rights independently enforceable. Since the doing of equity is imposed a condition of obtaining equitable relief, many things may be required which defendant could not compel if driven to the independent action. On this ground, the statute of limitations has been held no bar to the imposition of the condition to the grant of equitable relief. But the courts cannot impose merely arbitrary conditions, and it has been held that a plaintiff who shows himself otherwise entitled to the aid of a court of equity will not be denied relief unless defendant brings forward some corresponding equity growing out of the subject matter then in the suit. I'll read that again. Unless the defendant brings forth some corresponding equity growing out of the subject matter in the suit, which would at some time subject to the transaction and some other proceeding, entitle him to a remedy against the other party in respect to the subject matter involved. So let's say you got your debtor-creditor contracts that were formed on the at-law side, but it was really a trust, and you got the information and records to prove that it was a trust. The formation of your signature and your assets were then converted. Then that rises out of the subject matter, and it is an equity that the defendant could use against the plaintiff. Next section, 155, D, restriction to equities arising of the same transaction. One of the most important qualifications of this maxim is the equity which the party seeking equity is required to do arise from or belong to the transaction as to which he seeks relief. But the whole transaction is usually considered, not merely the particular phase on which the party seeking the relief bases his rights. It has been held that this is a reciprocal equity between the parties which must be accorded, and that the defendant cannot insist upon plaintiff's doing equity to a stranger. Remote consequences of plaintiff's acts due to negligence of others will not be visited by him as to require him to answer for them. Next section, 156. Notice defeating equity. Where defendant acted with full knowledge of an adverse claim, he has no equity to be protected therefrom, and the maxim is inapplicable. Thus, it cannot be successfully invoked to overthrow the plain contract voluntarily entered into with knowledge of all the facts. 157F, fraud or public policy defeating equity. The maxim that he who seeks equity must do equity will not be applied in favor of one guilty of actual fraud by requiring restoration to him in such manner as enable him to obtain any advantage or security in the perpetration of the fraud. And in such case, the maxim that he comes into equity must come with clean hands is applicable and controls. Where a defendant acts is against public policy, the same doctrine applies. Next section, 158G, conduct of suit. One seeking equity must do equity by proceeding seasonably, while his adversary has fair opportunity and means to defend, and must continue to do equity during the litigation. Section 159H, parties bound. The maxim binds not plaintiffs alone, but any party who affirmatively seeks equitable relief, including plaintiffs, cross-complainants, defendants, and interveners. But where the maxim does not bind one who does not seek affirmative equitable relief, it gives the court no power to impose terms on defendant as condition of dismissing a bill not sustained by the proofs, even where the defendant has filed a cross bill seeking defensive relief. Next, infants. An infant, equally with an adult, may be required to do equity as a condition of equitable relief, but there is authority to the contrary. Section 160I, impossibility to do equity. On the principle of this maxim, relief will be denied to anyone who is unable to perform his obligation under the transaction sought to be enforced or from which he seeks relief. He is considered to have waived his right to its enforcement. One who has received to the full benefit of the contract, where it is such a nature that it cannot be restored, cannot have the aid of equity to avoid the contract obligations. Section 161J, necessity of tender. An actual tender is not essential to equitable relief, where the party offers to do equity in his bill. A tender of performance before the commencing proceedings for the specific performance is not necessary where defendant, without any default of plaintiff, has refused absolutely to perform. 162, number 3, applications of rule. Perhaps the most familiar application of the maxim in the suits is to rescind contracts or to avoid other transactions, where plaintiff is required to restore benefits received and place other parties in status quo, but the maxim finds frequent application in proceedings for injunctions, specific performance, cancellation of instruments, quieting titles, partition, redemption, ejectment, where equitable defenses are set up, or were used as a substitute for a bill in equity under Pennsylvania practice, relief against void or irregular proceedings, judicial sales, usury, or wrongful acts of officers or corporations, marshaling assets and securities, and in general creditors' bills, and numerous other cases. Thus, the basis of the rule of stopping one of his own latches, or that the persons for whom he stands in privity, has been traced to this maxim. And we'll stop there for this book. We'll go to the next one, and that will be BizFam. BizFam, section 43. That's page 267 in the PDF or page 73 in the book. Section 43, Roman numeral 7. He who seeks equity must do equity. That's on 267 in the PDF or 73 in the book. Usual illustration of this maxim is the case of a borrower for money on usurer's interest who comes into the court of equity to ask for relief by having the transaction set aside. Maybe we ought to read that again. Usual illustration of this maxim is the case of a borrower of money on usurer's interest who comes into a court of equity to ask for relief by having the transaction set aside. Equity will not afford him redress except upon the terms of his returning the amount actually borrowed with lawful interest, but it is as equitable that the person who has loaned the money should have the amount with lawful interest returned to him, as that the borrower should be relieved of his unjust obligation to pay the usurer's rate. So also, a mortgagor who files a bill to redeem must offer to do equity by paying the mortgagee his debt, interest, and costs, and he cannot insist that the debt is barred by the statute. Another striking illustration of this maxim is found in the rule that when the husband comes into chancery for the purpose of getting his wife's equitable property, he will not be asserted except upon the terms of making a reasonable settlement upon his wife. Again, where a bona fide possessor of property improves it in good faith and under an honest belief of ownership, equity in some cases may refuse to aid the real owner in ousting him, save upon terms of allowance for such expenditures. So if you made improvements on your property, you got foreclosed upon, those are included. They can't take those. You made payments on your mortgage, you brought your mortgage down, they can't take the whole house and then turn around and get you for a deficiency judgment. At law, they can. And then force you into bankruptcy because you don't have any money. They took your house. You got everything. Equity won't allow that. Continue on. Still again, when a property owner seeks to enjoin the collection of taxes on the ground that the amount is excessive, he must pay to the proper officer the amount which he concedes to be properly due. Other illustrations of application of this maxim will be found in the authority cited in the note. See footnote 6. Among these, Willard versus Taylor may be particularly referred to. In that case, it appeared that in 1854, the plaintiff had leased from the defendant a hotel at Washington for the terms of 10 years, with the option to the leasee of purchasing the fee at a fixed price at any time within the term. At the date of the lease, gold and silver coin was the only legal tender. Subsequently, the Legal Tender Act was passed in April 1864. Just prior to the expiration of the term, the leasee elected to exercise the option to buy, and the tender of the price in paper money, which was at the time much depreciated. On the refusal of the leaser to accept, the lessee filed a bill to enforce specific performance of the contract. It was held that he was entitled to a decree, but only to condition that the stipulated sum should be paid in coin. Equity looks through the form and the substance into the substance. Looks past the form, process, and procedures, ad law. Gets to the real intent, which is the subject matter of equity. Maxim is applicable to a defendant as well as to a plaintiff, and the party who seeks to avail himself of the equitable defense must stand the test of the doctrine of the consideration, as well as one who appears as plaintiff in the cause. All right, now we'll jump to the next book. It'll be Snell. Jumping to Snell's book. Section 5, that's page 70 in the PDF or page 41 in the book. Next book is Snell. Snell, Section 5, page 70 in the PDF and 41 in the book. Number 5, as an illustration of the maxim, he who seeks equity must do equity, may be briefly notice the rules which govern what is termed married woman's equity to settlement. The general rule is that when a femme sole marries, her property, not being settled to or otherwise belonging to her for the separate use, so subject to certain conditions, passes to her husband all her truces and actions which the husband can reduce into possession without the aid of a court of equity, and also all her things in possession he may realize, but the moment he is obliged to ask for the assistance of equity for the purpose, the court will only aid him on the condition if, for instance, the testator bequeaths the legacy to a married woman, her husband can only realize the legacy through a court of equity. The moment the husband comes into a court and claim it, the court will tell him, quote, "We will help you get all the money and only on the condition that you make a fair settlement for the benefit of the wife and the children." And so on. The condition of the same maxim is where the person having title to the estate stands by knowingly suffers a person ignorant of his title to expend money upon the estate, either in buildings or in other improvements, and then afterwards asserts his title in a court of law. Upon proving his title, judgment would, of course, subject to the recent changes, be given for him without any compensation for the improvements executed by the defendant. In equity, however, and consequently now also in a court of law, a person who has expended money under such circumstances on the estate of another would be entitled to be indemnified for the expenditure, either by pecuniary compensation or otherwise in some cases, example, if he were a lessee under a defective lease, by confirmation of his title. Maxim is also frequently illustrated that classes of cases where, in consequence of some misdescription of the property sold, a court of equity will not enforce specific performance of contract at the suit of the vendor unless he, the vendor, makes compensation to the defendant for the injury sustained by the latter from the misdescription, and so conversely, if the purchaser seeks to profit any misdescription. How many mortgages that you've seen that there was a misdescription of a scrivener's error in the description of the property, and the plaintiff's coming in and foreclosing on you? Why don't you apply this maxim and read that little section over again? Okay, now the next book, we're going to Gibson's, my friend Gibson's. Section 39, page 58 in the PDF, or page 32 in the book. Gibson's, section 39, page 58 in the PDF, 32 in the book. 39. He who seeks equity must do equity. Under the operation of this maxim, courts of chancery are enabled to adjust to the equities of complainant to the equities of the defendant, and thus do complete justice between the parties. Formerly, as was the practice of the court, to refuse relief to complainant unless the complainant would acknowledge or concede or provide for the rights, claims, and demands justly belonging to the defendant, and out of growing out of that, or necessarily connected with, the subject matter of the controversy. The ecclesiastical chancellors sought to enforce in their courts the divine injunction of doing unto others as would have been others do unto us, which is the only another form of the maxim. But now the courts of chancery does not want for the complainant to offer to do equity, but acts on a supposition that, knowing the rule of the court, he is willing to do whatever equity towards the defendant the court may require of him. Number one, if a borrower of money upon usury seeks the aid of a chancery court to have canceled the usurer's contract, the court will require him to do equity by paying the lender what is legally due him. 2, if a taxpayer seeks relief from an overassessment, he must pay what is justly due. 3, if a party seeks to have a tax deed declared a cloud, he must pay all the taxes paid by the holder of the deed. And 4, if a person asks for a petition, he must pay his portion of any encumbrance removed by the defendant. And 5, if the husband seeks the aid of chancery to a court to reduce the wife's personal estate into possession, he will be required to do equity to the wife by allowing the court to settle upon her for the sole and separate use of herself and the children a reasonable portion of the proceeds of said estate. 6, if the owner of land allows another to make improvements thereupon the belief that he has the right, the Court of Chancery will compel such owner seeking to assert his title to pay for such improvements. 7, where a complainant seeks to have a certain fund decreed to him, he will be required, if insolvent, to pay the defendant what he owes him. 8, where a complainant has the deed declared a mortgage, he must pay the consideration he receives. 9, where a complainant obtains the rescission of a contract or the cancellation of an instrument, he must make the defendant whole. 10, where a married woman avoids a sale, she must restore the consideration she received. 11, a mortgagor may not be allowed to redeem without paying the encumbrance discharged by the mortgagee. 12, a judgment will not be enjoined unless complainant pays what he owes the judgment creditor. And 13, in general, whenever a complainant seeks to recover property from which the defendant has removed an encumbrance or to the value which the defendant has added in good faith, relief will be granted the complainant only in condition that the defendant be reimbursed to the extent the complainant has been by him benefited. It will thus be seen that in giving the complainant relief, a court of chancery will require of him whatever the defendant may, in good reason and good conscience, be entitled to in reference to the subject matter of the suit, although his requirement may be one that the court would not otherwise enforce. The condition thus imposed on the complainant is as where the price of the decree the court gives him. Under this maxim, an equitable right may be secured to the defendant which could not be obtained by him in any other manner, which he could not have secured by a suit brought for that purpose. The equity of the complainant is required to do must, however, be connected with the subject matter of the suit or grow out of the very controversy before the court, and conditions must not be arbitrarily imposed. The principle contained in the maxim enlarges the powers and jurisdiction of the court when equities arise in favor of the defendant out of the subject matter of the controversy, and hence thus might be termed a jurisdictional maxim. It also enables the chancellor to determine the whole controversy in all its branches and, if necessary, to make the sort of equitable compromise decree giving to each party what, in good reason and good conscience, he ought to have, and require of each what, in good reason and good conscience, he ought to do, thus fulfilling that other maxim, boni justus est literis dimitri, ni less ex lite orator. It is the duty of the good judge to so thoroughly decide the suit that another suit will not arise out of it. That's it for Gibson. So now we're moving on to Pomeroy, section 384, page 703 in the PDF or page 636 in the book. Pomeroy, section 385. page 703 in the PDF, 636 in the book. Section 385, its meaning. This maxim expresses the governing principle that every action of a court of equity in determining the rights and awarding remedies must be in accordance with conscience and good faith. Isn't this just what everybody has been desiring for all these years? Everything to be in good conscience and good faith, to be done fair and equal and righteously and justice. Here we've been in the wrong courts all this time, ladies and gentlemen. You've been in the wrong courts. You've been in the that law side, trying to enforce your substantive rights. And you wonder why you got defeated, why you got hammered. Continue on. In its broadest sense, it may be regarded as the foundation of all equity, as a source of every doctrine or rule of equity jurisprudence. It is the undeniable that the courts of equity do not recognize and protect the equitable rights of litigant parties unless such rights are in pursuance of the settled judicial notions of morality based upon conscience and good faith. But as a practical principle guiding the equity courts in their administration of justice, the maxim is only used in a much narrower and more special meaning. Even in this narrow specification, it is the principle of most extensive application. It has been applied, in fact, in every litigation to every species of remedy. The meaning is that whenever be the nature of the controversy between two definite parties, and whatever be the nature of the remedy demanded, the court will not confer its equitable relief upon the party seeking its interposition and aid unless he has acknowledged and conceded or will admit and provide for all the equitable rights, claims, and demands justly belonging to the adversary party, and growing out of the necessary involved in the subject matter of the controversy. It says, in effect, that the court will give the plaintiff the relief which he is entitled only upon the condition that he has given or consents to give the defendant such corresponding rights as he also may be entitled to in respect of the subject matter of the suit. That is fairness. Everything we've been looking for. That is what is right, fair, and just. That is justice. That is the will and consciousness of God being demonstrated to you by reading what and understanding what the maxims are. They are the interfaces to the understanding of the God-conscious mind. Continuing on, these meanings of the principles was more definitely expressed by the eminent judge in the following terms, quote, the court of equity refuses its aid to give the plaintiff what the law would give him if the courts of common law had jurisdiction to enforce it, without imposing upon him conditions which the court considers he ought to comply with, although the subject of the condition should be one in which the court would not otherwise enforce, unquote. In this narrow and particular sense, the principle becomes a universal rule governing the courts of equity and administering all kinds of equitable relief, and in any controversy where its application may be necessary to work out complete justice. See footnote 1. Next section, 386, where applicable. We analyze this general formula, we shall obtain a more accurate notion of the real scope and effect of the principle. In the first place, the court only applies where a party is appealing as actor to a court of equity in order to obtain some equitable relief, that is, either some relief equitable in its essential nature, equitable in nature as an injunction or a cancellation, or equitable because it may come within the power of the court to administer by virtue of its concurrent jurisdiction as an accounting or a pecuniary recovery, and is necessarily assumed that the party would, but for the operation of the rule, be entitled to all the relief which he demands. I want to stress that equitable nature versus equitable character. Continuing on, unless the party were otherwise so entitled, there would plainly be no occasion for the invoking the rule. With respect to the terms in which may be imposed upon the party as a condition to obtaining the relief in accordance with the rule, that is, that equity which he must do, it is undoubtedly true, as said Vice Chancellor Wigram, that the court obtains no authority from the principal to impose an arbitrary condition not warranted by the settled doctrines of equity jurisprudence. The court cannot deprive a plaintiff of his full equitable rights under the pretense of awarding to the defendant something to which he has no equitable right, something which equity jurisprudence does not recognize. The principle only requires the plaintiff to do equity according to its true meaning. Therefore, the terms imposed upon the plaintiff as a condition of his obtaining relief must consist of the awarding or securing to the defendant something to which he is justly entitled by the principles and doctrines of equity, although not perhaps by those of common law. I'll repeat that. Although not perhaps by those of common law. Something other which is distinctively equitable right. I might add, say, statutes and codes. Continue on. In many cases, his right or relief thus secured or to obtain by the defendant under the operation of the rule might be recovered by him if, as plaintiff, the parties being reversed had instituted a suit in equity for that purpose. But this is not indispensable, nor is it even always possible. The rule may apply, and under this operation, an equitable right may be secured or an equitable relief rewarded by the defendant, which could not be obtained by him in any other manner, that is, which a court of equity, in conformity to the settled methods, either would not or even could not have secured the conferred or awarded by his decree in a suit brought for that purpose by him as the plaintiff. Next section, 387. Finally, the principle will not apply so as to compel the plaintiff to do equity where the relief sought by the plaintiff and the equitable right or relief secured or awarded to the defendant belong to or growing out of two entirely separate and distinct matters. The true meaning of the rule is that the respect is that the equitable right or relief secured to the conferred upon the defendant must be something connected with the subject matter of the very suit or controversy for the proper decision of what the principle is invoked. Or to state some doctrine in a more detailed particular terms, quote, the rule is applied where the adverse equity to be secured or awarded to the defendant grows out of the very controversy before the court or out of such transaction as the record shows to be part of its history, or where it is so connected with the cause and litigation as to be presented in the pleadings and proofs with full opportunity to afford the party thus recriminated to explain or refute the charges, unquote. See footnote 1. If the conduct of the plaintiff growing out of the subject matter entirely distinct and unconnected with those embraced within the suit can affect his rights to obtain relief, which would be otherwise proper, it must be by virtue of another equitable maxim. He who comes into a court of equity must come with clean hands. That one works in conjunction with this one that we're doing now. Section 388 is a general rule regulating equitable release. With this explanation of its scope and meaning, it may be regarded as a universal rule governing the court of equity and its administration of its remedies, that whatever may be the nature of the relief sought by the plaintiff, the equitable rights of the defendant growing out of or immediately connected with the subject of the controversy in question will be protected. And for this purpose, the plaintiff will be required, as a condition to his obtaining the relief which he asks, to acknowledge, admit, provide for, secure, or allow whatever equitable rights, if any, the defendant may have, and to what end the court will, by its affirmative decree, award to the defendant without relief, whatever relief, may be necessary in order to protect and enforce those rights. Thus, this principle is not confined to any particular kind of equitable rights and remedies, but pervades the entire jurisprudence so far as it's concerned with the administration of equitable remedies. See footnote 1 in A. Next, 389, illustrations of wife's equity. Having thus explained the principle in its generality, I shall now, by way of illustration, state some of the instances in which it has been applied. The most common and striking instance in all events in England is the wife's equity, so-called. By common law, the husband became absolute owner of all the wife's monies, goods, chattels, and things in action which he reduced to possession, the estate for years, and acquired a life interest in all her freehold estates, and it was entitled to their rents and profits. The only mode of securing any of her property to her own use during the marriage was by marriage settlement. Courts of equity have, from upon the very early period, provided the wife a remedy against these harsh doctrines of common law, which no proper settlement had already been made by the parties, by her giving a right to the possession out of her own property when the circumstances were such that the principle, he who seeks equity must do equity, could be applied, and thus right is known as her equity as the settlement. The right of the wife was first recognized in the cases where the husband himself or his assignee or creditor or some other party claiming under or through him resorted to the court as plaintiff and sought its aid to enforce the husband's legal interest and thus to obtain possession of property belonging to the wife. Avowedly acting upon the rule under discussion, the court established the doctrine that it could always require, as a condition of the granting of the relief, that an adequate part of the property should be secured to the wife by a settlement. Subsequently, the court took a further step and allows the wife, as plaintiff under proper circumstances, to assert her equitable right by a suit in her own name. It may therefore be regarded as the established general rule of equity whether the wife is plaintiff suing on her own account, or the husband or some other party claiming under him is the plaintiff suing to reach the property, if the wife's property is within the reach of the court, if it is vested in trustees or has been paid into the court, or is in any other situation which brings it within the control of the court, will not be permitted to be removed out of the jurisdiction and control until the adequate provision is made for the wife, unless she has already been sufficiently provided for, or on her personal examination she waives her right. Thus, the rule thus adopted and occasionally enforced in many of American states at a time when the common law doctrines concerning the property relations between the husband and wife were still unaltered, that is, prior to the modern legislation as to married woman's property. The importance of the rule, however, has been greatly lessened in England, and the rule itself is certainly becoming entirely useless and obsolete in a great majority, if not indeed all, of the states of the effect of the modern legislation. Recent statutes in nearly all, if not quite all, the states have deprived the husband of all rights in his wife's property during the marriage, have secured to her a perfect title in it, and have removed it from the claims of her husband of his creditors, have placed it under her exclusive control and separate use, and have apparently given her full power or disposition over it. It is perfectly obvious, therefore, that no circumstances could possibly arise under which the rule could be invoked and enforced on behalf of the married woman in order to secure her own property, since it is already more completely secured to her by the statutes, and neither the husband nor the assignee nor the creditors could ever maintain a suit in equity for the purpose of reaching it. Next, section 390, equitable estoppel. As another example of application of the principle, if the owner of an estate stands by and suffers another person who is ignorant of his title and supposes himself to be entitled, or to go on and expend money upon the estate, either by erecting buildings or by making other improvements, a court of equity will compel such owner, when he afterwards comes into it to assert his title, to indemnify the one who has made the expenditure, either by making a pecuniary compensation, or in some cases, if the expenditure were by a leasee under a defective lease, by confirming and establishing the leasehold interest. Next, 391, usury. Another remarkable application of the principle is seen in the action of the courts towards parties seeking its aid under the statutes against usury. However, the statutes have made usurious loans and obligations absolutely void. If a borrower bringing a suit in equity for the purpose of having a usurious bond or other security rendered up and canceled, the relief may be granted only upon condition that the plaintiff himself does equity by repaying the creditor what is justly and in good faith due, that is, the amount actually advanced. That's the principle. The amount actually advanced, with lawful interest, unless indeed the statute has gone so far as to expressly prohibit the court from interposing such terms as the price of its relief. The same principle has been applied to a lender seeking the aid of the court to reform a security tainted with usury. The case is entirely different, and another maxim governs this decision. When the lender sues in a court of equity to enforce a usurious obligation, the borrower may set up a defense and defeat the suit without repaying any amount. See footnote 3, which is the maxim, he who comes into a court of equity must come with clean hands, applies to the plaintiff in these cases, following cases to support that. Continuing on, the rule lends to all cases where a party seeks to have a contract set aside and canceled on the ground of its illegality in violating the provisions of some statute. The court will require him as a condition to the granting of the relief to pay what is really due upon the agreement unless the illegality is a malum in se, or that the statute itself prevents the imposition of such terms. 392, other special instances. There is also an application of the principle that where there has been some misdescription of the property on the part of the vendor, a court of equity will not decree a specific performance of the contract in his suit except upon the terms that he makes proper compensation for the injury which the defendant has sustained from the misdescription. Indeed, it is also by virtue of the rule that the decree is made in all suits for specific performance of contracts, and plaintiff, whether the purchaser or vendor, being compelled to perform his part of the agreement as a condition to obtaining relief against the defendant. And the same is true with respect to the relief granted in suits for redemption brought either by a mortgagor or by a subsequent encumbrancer, and where a trustee had purchased land in his own name, but really for the benefit of the Sedekey Trust, he had paid the purchase money with his own funds, and was also a creditor of the Sedekey Trust for other advances made to or for him, and it has been held that such beneficiary could not compel the conveyance of the trustee to himself except upon payment of his entire indebtedness, as well that growing out of this purchase as that arising from the other advances. 393. The following are some additional miscellaneous examples. A contract for the purchase of lands was made in 1854 when the price was payable in gold. Subsequently, when the value of the premise had very greatly increased, and after the passage of the Legal Tender Act, the purchaser offered to pay the price in United States legal tender notes, which were then much depreciated, and upon the vendor's refusal, brought suit to compel the specific performance. The Supreme Court held that under these circumstances, the plaintiff was not entitled to the relief except upon the condition of paying the price in gold. In states where the Court of Equity exercised jurisdiction to set aside or to restrain the collection of illegal assessments or taxes, the relief will not be granted unless the plaintiff pays such portion of the tax or assessment as is lawful and justly due. Where a ward, immediately upon coming of age, transferred all his property to his guardian from an inadequate consideration and released the guardian from all liabilities growing out of the trust, and afterwards brought suit to set aside and cancel such conveyance, and for an accounting, the relief was only granted upon the terms of refunding the amount thus paid by the guardian, or by giving him credit for such amount in the accounting. Some further illustration may be found in the footnote 4B. (394) is the source of certain equitable doctrines. 394 is the source of certain equitable doctrines. So this maxim is the source of. Thus far, I've discussed the principle and view taken of it by great majority of judicial opinions, namely as universal rule guiding the Court of Equity in its administration of every kind of relief, and to be applied in practice according to the circumstances of the particular case before the court or for decision. And thus the aspect of the principle is not regarded as to the force of any special doctrine of equity jurisprudence, nor as the foundation of any special equity interest or primary right. Primary rights, very interesting, primary rights. Secondary rights also. Privities. Continuing on, there is, however, another phase of the principle. It may be looked upon in another light. It is not wholly the rule of the guidance of the equity judge in measuring out and apportioning relief among litigants. It has exercised a molding influence in the development of important branches of equity jurisprudence. Certain doctrines are plainly derived from it as their chief, though not perhaps their only source. The full scope and effect of the doctrine can only be understood by a clear perception of the relations which connect them with their common origins. That is the first key thing that you must ask. What is the relation we're talking about? If you do not, the equities between the parties will be misconstrued. It is key to find what relation we are talking about, and it's very simple. It's either a private trust on the private side, or it's all DC on the public. That's very simple. The equities between the parties in both those are going to be different. DC contracts, the equity is going to be one way, and under a trust, it's going to be another way. Under DC, we're talking and arguing about one title alone, the legal title. And under a trust, we're talking about two titles. We're talking about a beneficial interest who is the true owner and the legal title held in the trustee. Big difference, 180 degrees apart. One's at law, one's in equity. Exclusive head and exclusive jurisdiction of equity is a private trust, not a statutory trust, private trust. If your trust is formed under common law or statutes and codes, you've got a public trust. You're under public obligation, under public policy, under the statutes and codes. Sorry. You need a private trust. Full scope and effect of such doctrines can only be understood by clear perception of the relations which connect them with their common origins. I shall therefore conclude the discussion of the present action by a brief summation of the doctrines, which are thus, as it seems to me, directly referred to the principle that he who seeks equity must do equity. 395, of election. The relation which plainly connects all these doctrines with the principle in question is the fact that the equitable right or interest of one party, recognized and protected by each of them, always grows out of or is necessarily connected with the recognition and maintenance of the equitable right or interest of another party arising from the same transaction or subject matter. In other words, the equity of one exists by the operation of the doctrine only because the equity of another is admitted and provided for. That's equality. The doctrine itself is thus based upon the preservation of reciprocal or correlative equities. The first of the doctrines which I shall notice is that of election. This doctrine involves the notion that no man can claim inconsistent rights with regard to the same subject matter, and that anyone who asserts an interest under an instrument is bound to give full effect to that instrument. He cannot both accept it and reject it, or avail himself of its benefits as to a part and defeat its provisions as to other parts. Election then originates in inconsistent or alternative donations, two gifts, with the intention, expressed or implied, that one shall be substituted for the other. The donee is entitled not to both, but the choice of either. The doctrine is applied under two somewhat different states of circumstances, but the principle is the same in each. If the individual to whom an instrument is of donation, a benefit is possesses the previous claim on the donor, and the intention appears that he shall not have both receive the donation and enforce the claim. He is required by the doctrine to elect between his original and his substituted rights, the gift being designed as a satisfaction of the claim. He cannot accept the former without renouncing the latter. He cannot accept the former without renouncing the latter. It's to the exclusion of one or the other. In the second case, the owner of an estate having an instrument of donation applied to the property of another expression where that property, his own, would amount to an effectual disposition of it to a third person, and having by the same instrument disposed of the portion of his own estate in favor of the proprietor whose rights he assumed. The doctrine imposes upon the proprietor the duty of election either to relinquish the benefit conferred upon him by the instrument, if he asserts his own inconsistent priority rights, or if he accepts that benefit, to complete the intended disposition by conveying in conformity to it that the portion of the property to which purports to affect. It is very evident that the doctrine is based upon the principle that the party who, under such circumstances, asserts his equitable claim to one of his rights must also do equity by relinquishing the other to the person who in that case are entitled to it, and at the end he is compelled to make an election between the two. Next, 396 of marshalling. The second doctrine which I shall notice is that is known as marshalling of securities. If a person has two real estate mortgages, both to one person, and afterwards only one estate to a second mortgagee, the court, in order to relieve the second mortgagee, has directed the first to take the satisfaction out of that estate, only which is not in mortgage of the second mortgagee, if that is sufficient to satisfy the mortgage, in order to make room for a second mortgage. See footnote 1. Same rule applies whenever there's been any lien or security on two funds and another has a subsequent lien on only one of them. The doctrine is plainly referable to the principal. The holder of the security on two funds is compelled to shape his own remedy so as to preserve, if possible, the equity of the one whose lien extends to but one fund. In fact, the whole theory with respect to the marshaling of assets seems to be derived, in part at least, from the same source. A few other doctrines might, I think, be specified as thus related by a common descent, but enough has already been said to show the great importance of the principle. He who seeks equity must do equity, both as the principal rule governing the administration of remedies and to the germ of equitable doctrines. And that concludes tonight's. Been going over the maxims in equity. Left off on 2 to go out of the Phelps book. And we're starting out the Phelps book again on page 384 in the PDF, or at section 256, which is page 344 in the book. And that's in the Phelps book. Section 256, that's 384 in the PDF or 344 in the book. Phelps breaks down the maxims in 2 categories or classes. One's the enabling maxims, which consist of 8, the first 8 in the group. And he breaks all these maxims down into subgroups. So the second main group is the restrictive ones. And that's what we're working on right now, is the restrictive maxims. We're on the restrictive maxims right now. We're on the last 2 of that section in the book. Keep in mind that the subgrouping of each of those maxim groups is multiple ones, because this 5th one that we're doing now, must come with clean hands, works as a group, and in that subgroup is number 4 and number 6, which is who seeks must do equity, and equity aids the vigilant, and those 2 work with this one we're talking about tonight in 5, must come with clean hands. So they need to be taken in groups in their understanding. So page 384 in the PDF, page 344 in the book, section 256. He who comes into equity must come with clean hands. He that hath committed iniquity shall not have equity. It is upon this principle that a fraudulent grantor is not permitted to gainsay his own deed, nor a fraudulent grantee to obtain reimbursement for money paid as part of a fraudulent transaction, nor a party to be relieved from a judgment on the ground that the obligation on which it was rendered was in fraud of the law. Specific performance will not be decreed when it is apparent that the object of the contract was to defraud creditors. No relief will be granted in equity to purchasers of claims against an insolvent corporation for the purpose of speculating upon the liability of stockholders. A party cannot have relief directly inconsistent with his sworn testimony as a witness in a previous stage of the same case, or even in a previous case. A party has been obliged to make good a loss incurred through his own negligence, cannot by subrogation recover another whose negligence contributed. A party depositing money with a bank to give fictitious credit to a corporation is not allowed to withdraw it after the purpose of the fraud has been effected. Upon the same principle, the remedy of divorce can be obtained only by an innocent party, and recrimination, if sustained, is a valid defense. So also when it appears that a non-resident plaintiff has moved into the state for divorce purposes only. Courts of equity are especially alert to enforce this principle in all applications for the extraordinary remedies of injunction, specific performance, reformation, cancellation, or rescission, and the like. The conduct of the plaintiff throughout the matters leading up to litigation will be carefully scrutinized. A typical case of injunction will serve for illustration. 256, injunction. It has already been seen that the uttermost candor of statement is required for the plaintiff in his bill, especially when the application is for a preliminary injunction. There must be full disclosure of all material facts and documents. In a case where the testimony showed that a special circumstance set forth in the bill as a ground for jurisdiction were not the genuine reasons for prosecuting the suit, but that the plaintiff had an ulterior purpose not avowed, the bill was for that reason dismissed. A party who has influenced the action upon which liability was incurred cannot restrain such action by injunction. Infringement of a false trademark or label will not be restrained by injunction, nor of one used under circumstances of fraud upon third parties or upon the public. If a plaintiff seeks to enjoin a railroad company from building on his land upon the ground that he has not been paid, and it turns out that he bought the land in the interest of a rival company and as its representative, so no other purpose than that of obstruction and litigation, this principle will be applied to defeat the discreditable scheme. But the fact that the plaintiff became a stockholder in a railroad company in the interest of a rival company for its purposes does not dissettle him to the assistance of the court in enforcing a mandatory injunction. His statutory right as stockholder to the inspection of the register of stock and bondholders. Upon the same principle, where the majority members of the lodge filed an injunction billed to reclaim their appropriate shares for the lodge fund upon the ground that the separation of the lodge from the general order had deprived them of the benefits to which, as members of the order, they were entitled, it was held that the severance which formed the basis of the equity invoked must appear to have occurred otherwise than by their own fault, inasmuch as the members were responsible for the series of inequitable proceedings which led to the separation, including a fraud upon the court itself in procuring a receivership of the lodge funds upon false charges. The court could not recognize any rights deduced from such proceedings and dismissed the bill. An injunction bill prayed the removal of buildings extending by mistake a few feet over the plaintiff's line. A strip of land was comparatively valueless, except for purposes of litigation. The manifest object of the proceeding being to extort an exorbitant price from the land, the application was refused as oppressive. Mandatory injunction to remove an obstruction from a drain was refused, the plaintiff having caused an increase in the volume of drain water. An injunction to restrain a nuisance will not be granted to a party committing the same nuisance. A bill to remove a cloud from title was dismissed, the title being based upon an inequitable acquisition of the ward's property by a guardian. Next section, 258. Common law analogies. Extirpi causa non obitur actio, in peri delecto peri est condition defenditus. All laws as well as all contracts may be controlled in their operation and effect by these general fundamental maxims of common law, viz., no one shall be permitted to profit by his own fraud, to take advantage of his own wrong, to found any claim upon his own iniquity, or to acquire property by his own crime. If a legatee willfully murders the testator, although no statute has enacted the forfeiture, these principles will prevent his reaping the fruit of his crime. If the assignee of a life insurance policy has murdered the assured, his crime defeats his recovery. If a loss happens through a fault of the assured, the insurer is not liable, whatever may be the terms of the policy. The same principle is equitable familiar application in cases ex contractu. In a suit for breach of contract resting on mutual independent covenants, the plaintiff, to succeed, must have kept his covenants. No contract or claim can be enforced founded on a violation of law or contra bono mors. No person can recover for a breach of contract occasioned by his own fraud. nor can an action be maintained upon judgment maintained by fraud, even though the fraud is such that it cannot be proved without restraining questions already adjudicated. An action by a depositor to recover from a bank money paid out on raised checks will be defeated by proof that the fraud was facilitated by the plaintiff's negligence. Next section, 259, qualifications. Number 1, the unconscientious dealings charged upon the plaintiff must be conformed to his conduct in the matter before the court and not extended to matters eluded. The iniquity which deprives the suitor of his right is not general depravity, but wrongful conduct in a particular transaction. 2, when the transaction has been in effect a fraud upon public policy, which would be defeated by allowing it to stand, relief may be given against it, notwithstanding the plaintiff's participation. Thus, relief has been given against a gambling or usurious contract. On the other hand, an illegal contract will be enforced when public policy requires it. 3, relief may also be granted when a plaintiff, although precipice, has acted under undue influence, such as it may arise from circumstances of iniquity between the parties, but this iniquity must also be so pronounced that the parties cannot be said to be in pari delictu. The mere fact of a relation between them of attorney and client will not accept the case from the general rule. Number 4, in some cases after the transaction has been fully completed and the money contributed has passed into other forms, a partner or agent in whose hands the profits are found cannot refuse to account for them to his co-partner or principal upon the ground that the illegal character of the original contract. And 5, the marriage status being on a different footing from contracts generally, a party may be relieved from his vowed marriage, although fully aware of his invalidity when contracted. Brings us up to the next maximum, or the last maximum in this section, 260, number 6, Equity Aids the Vigilant. Now we'll jump to another book, going now to Corpus Juris, section 163. That's page 207 in the PDF, or page 180 in the book. Corpus Juris. Corpus Juris, page 207 in the PDF. That's page 180 in the book. That's section 163, number C, letter C. He who comes into equity must come with clean hands. Number 1, in general. The maxim that he who comes into equity must come with clean hands, or is frequently expressed, that he who has done inequity shall not have equity, or that he who has done iniquity or has not done equity cannot have equity, is of an ancient origin and broad application. It is the expression of the elementary and fundamental conception of equity jurisprudence, and although not the source of any distinctive doctrine, it furnishes the most important and universal rule affecting the entire administration of equity jurisprudence as a system of remedies and remedial rights. This maxim expresses rather a principle of inaction than one of action. It means that equity refuses to lend its aid in any manner to one seeking its active interposition who has been guilty of unlawful or inequitable conduct in a matter with relation to which he seeks relief. Next, 164, number 2, cognitive maxims. This maxim is cognate, which declares that he who seeks equity must do equity, and one of the converse of the other. The clean hands maxim has been said to be more efficient and restrictive of the two. The maxim now in discussion includes within its operation several others frequently acted upon in courts of equity, among them being the following. No action arises out of a fraud or deceit. A right cannot arise from anyone out of his own wrong. where both are equally in the wrong, defendant who holds the stronger ground, or the wrong defendant holds the stronger ground. Ex turpity causes actio non orbitur, ex dolo malo non orbitur actio, jus ex injura non orbitur, in pari delecto portior est conditio, defendant detendus. Forgive my Latin. Next section, 165, number 3, nature of unconscionable conduct. A, general. Maxim operates so as to exclude, aid, or deny relief, or to form conduct which is fraudulent, illegal, unconscionable. The raised conduct need not be necessary to be of such a nature as to be punishable as a crime or actually fraudulent or constitute the basis of legal action. Any willful act in regard to the matter in litigation which would be condemned and pronounced wrongful by honest and fair-minded men will be sufficient to make the hands of the applicant unclean. The exclusion of the plaintiff from the particular favors of the court of equity equally results where the conduct has been unconscionable by reason of a bad motive, or where the result of any degree induced by his conduct will be unconscionable either in the benefit to him or to the injury to others. Restitution has been compelled of property received under an illegal contract not involving moral turpitude. Next section, 165. B, innocent and willfulness. The party entirely innocent of is, of course, not barred from relief because of the misconduct of others, although his rights have been associated with theirs. The maxim refers only to willful misconduct. The maxim must be morally reprehensible as to the knowledge as to known facts, but this means no more than free and deliberate action with knowledge of the facts. It does not require conscientiousness of the illegal or immoral nature of the act. Next section, 167. C, fraud against third persons. On the basis of the maxim, relief is sometimes refused where a stranger is the sufferer from the misconduct, and although the defendant is himself a guilty participant therein, and may indirectly profit by the refusal of the court to act. Thus, equity will not aid persons to get relief from situations which result from the conveyance of a property and fraud of creditors. It will not be enforced to secret trust by compelling the fraudulent grantee to reconvey, nor will it require such grantee to account. Same rules apply in the case of other devises to defraud creditors. Not only is the fraudulent conduct debtor denied relief, but is also the fraudulent grantee when the latter comes into equity as to assert his claim. In the same manner, under a great variety of circumstances, equity has refused to aid other parties where both are participants in transaction as fraud of the third person, either to carry out their arrangement, to set it aside, or to relieve in any way with reference to it. Next, 168D, similar but distinct misconduct. Relief has often been denied because plaintiff seeking relief against the misconduct of another has been guilty himself of similar but disconnected acts, although in a lesser degree. Next section, 169. E, conduct with respect to suit. One may be barred from relief by misconduct with reference to the suit itself. Thus, equity will refuse to protect one who fails to make a full and free disclosure of all the facts relating to his case. And it has been held that, irrespective of the doctrine of res adjudicans, equity will not aid one who has sought the same relief in separate actions on grounds so inconsistent as to evince a lack of candor and clean hands. Section 170, number 4, parties bound. The maxim opposes itself alike upon whose defends and one whose prosecutes a suit in equity, but has been held not applicable to one who by interpleader. It applies to a corporation as well to as an individual. Next, 171, number 5, objection on court sui sponte. The unconscionable character or transaction between the parties need not be placed by defendant. whenever it is disclosed, the court will, of its own motion, apply the maxims. It does not matter at what state of the proofs or in what order the lack of clean hands is discovered, but where the defendant, who is guilty participant in the transaction by a legal slip, loses his opportunity to disclose its turpitude, he will not, as a matter of favor, be permitted to do so. Next, 172. Number 6, limitations of rule. A, in general. This maxim has its limitations. It will not be allowed to work injustice and wrong. In its application, regard should be had for the doctrine that the fraud without injury is usually not available as a defense in equity. In some cases where plaintiff's misconduct had been directed against defendant, relief has been given by imposing a condition of such a character as to eliminate the intended wrong, and a party purging his conduct as far as possible has obtained relief. Next, 173B, relation of misconduct to subject matter of suit. Misconduct which falls within the maxims must have infected the cause of the action so as to entertain it would be violative of conscience. It must relate directly to the very transaction concerning which complaint is made, and not merely in the general morals and conduct of the person seeking relief. The party is not barred from relief because the misconduct not connected with the matter in controversy, and this is true although the misconduct may be directly connected with the subject matter of the suit. The party may have relief as the transaction in itself untainted, although the title of the subject matter may have originally grown out of the wrongful acts not connected with the present controversy, as where the new transaction is based upon a valid consideration in which the original illegal or otherwise irregular transaction is merged, notwithstanding that such illegal or irregular transaction may appear in the course of the proceeding. One does not always forfeit a right fairly acquired by subsequent misconduct connected with therewith. Inequitable conduct in regard to the proof of some item in fact and in a transaction does not preclude plaintiff from obtaining the relief sought as to other terms. Next section, 174. C, a relation of misconduct to defendant. In the absence of any other equity arising against plaintiff, the general rule is that the misconduct must be so connected with the subject matter as to affect the equitable relation between the parties. But there may be cases where relief may be refused, although defendant was not concerned in the plaintiff's misconduct, as in the cases already considered of similar but distinct misconduct in the parties of the plaintiff and cases frauds upon third persons. Next section, 175. D, where public policy requires intervention. Maxim being one founded on public policy may require its relaxation, even when the parties have been found to be in pari delicto. Relief has at times been awarded on ground that in a particular case public policy has been found to be the best conserved by that course. 176. E, conduct of adversary. The conduct of the other party may be sufficient to prevent the maxim from being applied, as where plaintiff's misconduct towards defendant was invited by him or waived. The courts inclined to measure the comparative guilt of respective parties and extend relief to those who is comparatively innocent. This situation has usually been presented in cases in which the wrongful conduct of the party seeking relief has arisen through undue influence arising from a trust relation of the parties, through mental weakness, threats, fears, or oppressions, and like circumstances which have been regarded as sufficient measurably to excuse the wrongful conduct involved. Section 177, number 7, applications of rule. A, in general. It is not always easy to apply the abstract principles of the maxims to a particular case because its limits are ill-defined. The circumstances under which it is invoked are necessarily an infinite variety. Of course, the doctrine has no applications where the facts do not show a cause of unclean hands. most direct application of the maxim is the uniform refusal of equity to assist in one seeking its aid to enforce and carry out its fruition a transaction with respect to which the plaintiff's hands are unclean. The effect of the maxim is to the court of equity, which leaves the guilty party seeking its aid where it finds him. Not only does equity refuse to aid or enforce such a transaction, but where it has been in whole or in part carried out, equity refuses to undo it on the application of the guilty participant and refuses to relieve him from the legal liabilities or other consequences of his misconduct. That the party has no remedy or no adequate remedy at law does not prevent the application of the maxim, nor is it binding force destroyed by legislation which enlarges the jurisdiction of the courts of equity. Next, particular applications. This doctrine of unclean hands is a bar to equitable relief and has been applied in a great variety of cases, including those relating to trademarks and unfair competition, injunctions, specific performance, cancellation of instruments, subrogation, divorce, mandamus, where such proceedings is considered an equitable action. This maxim aids in the establishment of the doctrine of laches. Next, 178, B, illegal transactions. To the extent and within the limits discussed elsewhere in this work, the maxim excludes from the court of equity either party to a transaction tainted with any form of illegality, either to enforce it or to obtain relief against it, or one seeking to protect a right operating against public policy. A court of equity in one state will not lend its aid to the consummation of a transaction in another state in violation of the laws thereof. An illegal contract cannot be enforced either at law or in equity, and consequently this maxim is not needed to defeat relief in respect to such contracts. Would take us into this book, into the next maxim, which ties in with this one. Now we'll go to another book. We'll go to BizFam, section 41, page 264 in a PDF, or page 70 in the book. Section 42, that's page 264 in a PDF, or page 70 in the book. 42, number 6. He who comes into equity must do so with clean hands. This maxim is also expressed, he that hath committed inequity shall not have equity. Thus a party who seeks to set aside a transaction on the ground of fraud must himself be free from any participation in the fraud, and if he desires relief in equity, and on the same principle, equity will not lend its aid to assist in gambling transactions or to enforce penalties, or to aid in the harsh assertion of legal rights, or to set aside a conveyance executed to defraud third parties. And the court will sometimes act sui sponte upon the same principle when one of the several confederates to the fraudulent transaction has acquired the result of the fraud. Equity will not aid the others in obtaining their share of the spoils. About the earliest illustration of this doctrine is almost transitional in the famous case of the highwaymen. Lord Kenyon once said, by way of illustration, that he would not sit to take an account between two robbers in Howells Health. There was been question whether the legend in regard to the highwaymen did not raise from that saying. It seems, however, that the case was a real one. The highwayman did file a bill in equity for accounting against his partner, but the bill, it is needless to say, was promptly dismissed. And moreover, the plaintiff's solicitors were summarily dealt with by the court as for a contempt in bringing such a case before it. Of course, this maxim only applies to the particular transactions under consideration, for the court will not go outside the case for the purpose of examining the conduct of the complainant in other matters, nor questioning his general character for fair dealing, nor is it nor is it every prosecution of an unfounded claim that will bar a man from coming into court of equity. There must be willful misconduct in regard to the matter of litigation. It has been held in some cases that equity will not necessarily refuse its aid simply because the fund or other subject matter in respect of which the relief is asked may have been originally created by an illegal transaction. Instances which has been found in Sharp versus Taylor, Brooks versus Martin, and in other cases, English and American, cited in the note. See footnote 6. But the doctrine in Sharp versus Taylor and the kindred cases is not to be extended. The whole subject was reviewed by Mr. Justice Pickwim in McMullen versus Hoffman, where the distinction was thus expressed, quote, "In the case before us, and the cause of actions grows directly out of the illegal contract of the court distributes, and if the court distributes the profits, it enforces the contract which is illegal. But where A claims money from B, although due upon an illegal contract, and B acknowledges the obligation and waives the defense of illegality and pays the money to a third party upon his promise to pay it to A, the third party cannot successfully defend an action brought by A to recover the money by alleging that the original contract between A and B was illegal. This is the principle decided, and we think correctly decided, and the case is cited." Next paragraph, unquote. Under the same maxim, too, fall cases where equity has refused its aid to unconscionable demands or defenses and was left the parties to their relief at law. And that takes care of BizBam. So we'll do Snell next, section 6. Page 71 in the PDF or page 42 in the book. Snell next. Number 6 in Snell. 42 in the book or page 71 in the PDF. Number 6 has an illustration of the second of the three kindred maxims, viz., he who comes into equity must come with clean hands, may be cited Overton versus Bannister, in which this maxim received a very pointed illustration. There an infant, fraudulently concealing his age, obtained from his trustee part of a sum of stock to which he was entitled on coming of age. And when of age, a few months after, he applied for and received the residue of the stock. Then afterwards, a suit was instituted to compel the trustee to pay over again the portion of the stock improperly paid during minority. But the court held that the concealment of age was a fraud on the part of the infant, and neither himself nor his assignees were allowed to enforce repayment by the trustees of the stock paid during the minority. The rule must be understood to refer, of course, to willful misconduct in regard only to the matters in litigation, and not to any misconduct, however gross, which is unconnected with the matter in litigation and with which the opposite party in the cause has no concern. Doctrine expressed, number 7, the doctrine expressed in the third of the three connected maxims, viz., delay defeats equities, which is the next one, really. Well, let's finish that one up since we started on it short. Doctrine expressed in a third of the three connected maxims, viz., delay defeats equities, or as it is otherwise expressed, equity aids the vigilant, not the indolent, may be briefly summed in the language of Lord Camden and Smith versus Clay. Quote, in a court of equity which is never active in relief against conscience or public convenience, has always refused to aid its stale demands where a party has slept upon his rights and acquiesced for a great length of time. Nothing can call forth the court into activity but conscience, good faith, and reasonable diligence, unquote. And it may be added that even a comparatively short period of delay, not satisfactorily accounted for, also tells heavily against the plaintiff in equity. Now we'll go to Gibson's. Section 42, page 62 in the PDF, or page 36 in the book. Page 62 in the PDF, 36 in the book. Section 42. He who comes into equity must come with clean hands. This maxim declares that a complainant who has been guilty of unconscientious conduct or bad faith, or has committed any wrong in reference to a particular transaction, cannot have the aid of the court of equity in enforcing any alleged rights growing out of such transaction. The court of equity was regarded by the ecclesiastical chancellors as a temple into which none could come except those who had clean hands and pure hearts. In the origin of the jurisprudence, the theory was adopted that a court of equity interposed only to enforce the requirements of good conscience and good reason as to matters not equitable, determinable in the law courts, and its interposition being demand a matter of grace. It would not be exercised in favor of a person whose conduct in the matter he had complained of had been unconscientious or in bad faith, or who had violated any of the principles of equity and righteous dealings, which the court had been constituted to enforce. But the operation of the maxim confined to misconduct connected with a particular matter in litigation, and does not extend to any misconduct, however gross, which is unconnected with and with which the defendant is not concerned. Under the operation of this maxim, the complainant must show that the transaction from which his claim arises is fair and just, and there is nothing unconscientious in his conduct relative thereto, and that the relief he seeks is equitable and not harsh or oppressive upon his defendant. Harsh or oppressive upon the defendant. Harsh or oppressive upon the defendant. Hence, a specific performance will be refused when the complaint is obtained the agreement by sharp and unscrupulous practices, by overreaching, by concealment of important facts, by taking undue advantage of his position, or by any unconscientious means, or when the contract itself is unfair, one-sided, unconscionable, or affected by any other such inequitable circumstances, or when the specific enforcement of agreement would be oppressive upon the defendant, or would in any other manner work an injustice. So if a contract is affected with fraud or has a fraudulent purpose, none of the parties to such fraud can have the assistance of the court either to compel the execution of such contract, or to have it canceled, or to have the property or interest transferred thereunder restored. Equity will leave such parties where they have placed themselves and will refuse all affirmative aid to either of the fraudulent participants. It is on this principle that a court of equity is always shut against a debtor, and when he seeks to recover back property he has conveyed to hinder, delay, or defraud his creditors. Ex dolo malo non orbitur actio, or no right of action arises out of a fraud. Agreements and transfers and consideration which is based on the violation of chastity, or on compounding a felony, or on gambling, or on a commission of any crime, or on any breach of good morals, are all deemed illegal, and no participant therein can get any relief in a chancery court, whether the relief sought is an enforcement of the agreement or a rescission of it, in pari delicto portore est conditio defenditus, or where parties are equally and wrongly in the wrong condition of the defendant is the stronger. Let me repeat that. Where parties are equally in the wrong, the condition of the defendant is the stronger. But where the parties are not in pari delicto, and where public policy is promoted thereby, the more excusable of the two may be granted relief by the court setting aside the agreement and restoring him to its original position. The Court of Chancery will not enforce a usurer's contract even when the defense of usury is not made, but will relieve against usurious contracts and will also restore money or property lost upon any game or wager. That takes care of my friend Gibson. Now let's go to my friend Pomeroy. Pomeroy, section 397. That's page 723 in the PDF, 723, or page 656 in the book. Section 4, he who comes into equity must come with clean hands. Section 397, its general meaning. This maxim is sometimes expressed in the form, he that hath committed iniquity shall not have equity. Like the one described in the preceding section, it is not, in its ordinary operation and effect, the foundation and source of any equitable estate or interest, nor of any distinctive doctrine of equity jurisprudence. It is rather a universal rule guiding and regulating the action of equity courts in their interposition on behalf of suitors for any and every purpose, and their administration of any and every species of relief. Resembling the former maxim in its respect, it differs from that principle in some most important essential features. In applying the maxim, he who seeks equity must do equity, as a general rule regulating the actions of courts, it is necessary to assume that different equitable rights have arisen from the subject matter or transaction, some in favor of the plaintiff and some of the defendant. And the maxim requires that the court should, and the price or condition of its enforcing the plaintiff's equity and conferring a remedy upon him, compel him to recognize, admit, provide for the corresponding equity of the defendant, and award to him also the proper relief. The maxim does not assume that the plaintiff has done anything unconscientious or inequitable, much less does it refuse him all relief. On the contrary, it grants to him the remedy which he is entitled, but upon condition that the defendant's equitable rights are protected by means of the remedy to which he is entitled. On the other hand, the maxim now under consideration, he who comes into equity must come with clean hands, is much more efficient and restrictive in its operation. It assumes that the suitor asking the aid of a court of equity has himself been guilty of conduct in violation of the fundamental conceptions of equity jurisprudence, and therefore refuses him all recognition and relief with reference to the subject matter transaction in question. It says that whenever a party or who, as an actor, seeks to set the judicial machinery in motion and obtain some remedy, has violated conscience, good faith, or other equitable principles in his prior conduct, then the doors of the court will be shut against him in limine. The court will refuse to interfere on his behalf, to acknowledge his right, or to award him any remedy. Next section, 398, is based upon conscience and good faith. The principle involved in this maxim is merely the expression one of the elementary and fundamental conceptions of equity jurisprudence. We have seen that in the origin of the jurisdiction of the theory was adopted that the court of equity interposes only to enforce the requirements of conscience, good faith, and with respect to matters lying outside of, or sometimes perhaps opposed to, the law. The action of the court was, in pursuance of this theory, in a certain sense discretionary, and the terms discretionary and discretion are still occasionally used by modern equity judges while speaking of the jurisdiction and remedial functions. Well, whatever may be in the strictly accurate theory concerning the nature of equitable interference, and the principle was established from the earliest days, while the Court of Chancery could interpose and compel a defendant to comply with the dictates of good conscience and good faith with regard to matters outside of the strict rules of the law, or even in condition to those rules, while it could act upon the conscience of the defendant and force him to do right and justice, it would never thus interfere on behalf of the plaintiff whose own conduct in connection with the same matter or transaction had been unconscientious or unjust, or marked by want of good faith, or had violated any of the principles of equity and righteousness dealing which it is the purpose of jurisdiction to sustain. While the Court of Equity endeavors to promote and enforce justice, good faith, uprightness, fairness, and conscientiousness on the part of the parties who occupy a defensive position in judicial controversy, it no less stringently demands the same from the litigant parties who comes before it as plaintiffs or actors in such controversies. Which brings in the other maxim, equality is equity. This fundamental principle is expressed in the maxim, he who comes into the Court of Equity must come with clean hands, and although not the source of any distinctive doctrines, it furnishes the most important and even universal rule affecting the entire administration of equity jurisprudence as a system of remedies and remedial rights. See footnote 1 and A. Next section, 399, its limitations. Broad as the principle is in its operation, it must still be taken with the reasonable limitations. It does not apply to every unconscientious act or inequitable conduct on the part of a plaintiff. The maxim considered as a general rule controlling the administration of equitable relief, in particular controversies, is confined to misconduct in regard to or at all events connected with the matter in litigation, so as it has in some measure affected the equitable relations subsisting between the two parties and arising out of the transaction. It does not extend to any misconduct, however gross, which is unconnected with the matter in litigation and with which the opposite party has no concern. When a court of equity has appealed to relief for relief, it will not go outside of the subject matter of the controversy and make its interference to depend upon the character and conduct of the moving party, who in no way affecting the equitable right which he asserts against the defendant or relief which he demands. Next 400, illustrations, specific performance. I shall now give some examples to illustrate the circumstances under which this principle operates in the administration of equitable relief and in the manner in which it is applied. The first instance which I shall mention is found on the familiar doctrine which controls the equitable remedy of specific performance of contracts. A contract will be perfectly valid and binding at law. It may be of a class which brings it within the equitable jurisdiction because the legal remedies is inadequate. But if the plaintiff's conduct in maintaining it or in acting under it has been unconscientious, inequitable, or characterized by bad faith, a court of equity will refuse him the remedy of a specific performance and will give him to his legal remedy by action for damages. It is sometimes said that the remedy of specific performance rests with the discretion of the court, but rightly viewed, this discretion consists mainly in applying to the plaintiff the principle. He who comes into a court of equity must come with clean hands. Although the remedy under certain circumstances is regulated by the principle, he who seeks equity must do equity. So in other words, the discretion is nothing more than the discretion of the judge is bound by the railroad tracks in which he is riding, and it goes no place other than where the tracks are, and the tracks are the principles or the maxims that he must adjudicate upon. Continuing on, the doctrine thus applied means that the party asking the aid of a court must stand in conscientious relation towards his adversary, that the transaction from his claim arises must be fair and just, and that the relief itself must not be harsh and oppressive upon the defendant. And I'll tell you, that's an example of the mortgage foreclosure today of the at-law contract that you sign where they got the right to foreclose on you and then get you for a deficiency judgment on top of that and then force you into bankruptcy and take everything that you got and clean your clock. But why would you want to go into the at-law side when you can't enforce any equitable rights there? Where if you did come in and invoked equity, you wouldn't be able to, the plaintiff wouldn't be able to take everything from you because you would have to have rights that were recognized by him, and it was only responsible for the amount that you actually truly owed, not upon everything else and taking it all from you. Stay out of those courts over there. We're in the wrong courts. We have no power there. The only power we have is in from equity. Continuing on, by virtue of this principle, a specific performance will always be refused when the plaintiff has obtained the agreement by sharp and unscrupulous practices, by overreaching, by concealment of important facts, even though not actually fraudulent, by trickery, by taking undue advantage of his position, or by any other means which are unconscientious, and when the contract itself is unfair, one-sided. And I might want to add there, just about everything that you sign today, you don't read, and it is all strictly one-sided, and you're not getting your side represented because you want the quick fix, the microwave fix of the thing now, rather than sit there and negotiate and tell them that it's an unconscionable contract. We need to be clearing out that defect by delaying the immediate need for what you're going after and correcting the contract. And you wouldn't be wound up in court, them taking and cleaning your clock. One-sided, continuing on, unconscionable or affected by any other such inequitable feature. Inequitable feature. None of these debtor-creditor contracts have any equitable features in there because they've taken away all your rights. And who put their name on the stinking contract? You did. And then when you can't pay your mortgage, you complain, I can't pay my mortgage, and they take everything from you per the contract which you agreed to, and then you say it's fraud. Let's get real here. You agreed to everything they're doing to you. In fact, you gave them the power to do it. Why did you do that? We all must be idiots, and believe me, I sign my name on those things too. Inequitable features. And when the specific enforcement would be oppressive upon the defendant or would prevent the enjoyment of his own rights or would in any other manner work injustice. Folks, the only way you're going to get this stuff is in equity, not at law. Stop invoking the debtor-creditor side by signing these contracts. These contracts automatically invoke the at-law side. You've made the choice. You made the choice for the at-law. And you can't complain what you got. Don't do that anymore. Don't make these unconscionable contracts. Don't sign your name to them. Form trusts, not debtor-credit contracts. Don't get yourselves into these messes. You won't have to be in court. Learn how to operate a trust, administer a trust as a trust is administered. Do not do commerce. Stay out of commerce. Stay out of that law courts. Can't win there. Continuing on, this application of the principle, better perhaps than any other, illustrates its full meaning and effect, for it is assumed that the contract is not illegal. For it is assumed that the contract is not illegal, that no defense could be set up against it at law, and even that a possession possesses no features or incidents which could authorize a court of equity to set it aside or cancel it. Specific performance was refused simply because the plaintiff does not come into court with clean hands. Get that one on them. Next section, 401, fraud. Another familiar illustration of the principle may be found on all cases where the plaintiff's claim is affected by his own fraud. Whatever be the nature of the plaintiff's claim and of the relief which he seeks, if his claim grows out of it or depends upon or is inseparated, connected with, or his own prior fraud, a court of equity will, in general, deny him any relief and will leave him to whatever remedies and defenses at law he may have. The maxim is more frequently invoked in cases upon fraudulent contracts. If a contract has been entered into through fraud or to accomplish any fraudulent purpose, a court of equity will not, at the suit of one of the fraudulent parties, a participus doli, while the agreement is still executory, either compel its execution or decree its cancellation, nor after it has been executed set it aside, and thus restore the plaintiff to the property or other interests which he had fraudulently transferred. Equity will leave such parties in exactly the position in which they had placed themselves, refusing all affirmative aid to either of the fraudulent participants. The only equitable remedies which they can obtain are purely defensive. Upon the same principle, whether one party, in pursuance of his prior arrangement, has fraudulently obtained property from the benefit of another, equity will not aid the fraudulent beneficiary. Notice they're talking about a beneficiary, and they just mentioned arrangement. Will not aid the fraudulent beneficiary by compelling a conveyance or transfer thereof to him, and generally there are two or more, where two or more have entered into a fraudulent scheme for the purpose of obtaining property in which all are to share. The scheme has been carried out so as all result of the fraud are in the hands of one of the parties. A court of equity will not interfere on behalf of the other to aid them in obtaining their shares, but will leave the parties in a position where they have placed themselves. (402) Illegality. Illegality. Another very common occasion for invoking the principle is illegality. A. Wherever a contract or other transaction is illegal and the parties thereto are in contemplation of law in pari delicto, it is a well-settled rule, subject only to a few special exceptions, depending upon other consideration of policy. The court of equity will not aid a participant criminis, either by enforcing the contract or obligation while it is yet executory, or nor by relieving him against it, by setting it aside, or by enabling him to recover the title to property which he has parted with by its means. The principle is thus applied in the same manner when the illegality is merely a malum prohibitum, being in contravention to some positive statute, and when it is mala in se, it is being contrary to public policy or to good morals. Among the latter class are agreements and transfers, and consideration of which was violation of chastity, compounding of felony, gambling, false swearing, the commission of any crime, or breach of good morals. It should be observed, however, and to avoid any misapprehension and seemingly inconsistency in the decision, that there are agreements which appear at first blush to be founded upon immoral consideration, or to which would at one time perhaps been regarded as contrary to public policy, which courts of equity do not consider to be illegal, and which there will be therefore enforced if properly coming within their jurisdiction. This kind are some contracts made upon consideration of the improper cohabitation being terminated, and those providing for children born from such cohabitation. Next, 403, limitations, parties not in pari delicto. Upon the general doctrine stated in the preceding paragraphs concerning the effect of fraud and illegality upon the remedial rights of parties seeking the aid of equity, there are certain limitations founded mainly upon motives of policy, which require brief mention. Wherever case falls within the limitation and not within the general rule, the court may give relief against the improper transaction, or may even enforce the obligation arising from the tainted agreement at the suit of one of the parties thereto. First, that these limitations may be given in the following general formula, and all the others may be regarded as merely particular deductions or corollaries from it. Assuming that a contract is fraudulent or against public policy or illegal still, where the parties to it are not in pari delicto, and where public policy is concerned as advanced by allowing either, or at least most excusable of the two, to sue for relief, relief may be given to him, either against the transaction by setting it aside and restoring him to his original position, or even in some cases by enforcing the contract if executory. The second limitation I cannot better state than in a carefully considered language of the present Master of Rolls, Sir George Jessel, in a very recent case. quote, you cannot ask the aid of a court of justice to carry out an illegal contract, but in cases where the contract is actually at an end or is put to an end, the court will therefore, to prevent those who have, under the illegal contract, obtained money belonging to other persons on representation that the contract was legal for keeping that money. It does not follow that you cannot, in some cases, recover money paid over to third persons in pursuance of the contract. It does not follow that you cannot, in other cases, obtain, even from the parties to the contract, monies which they have become possessed of by representations that the contract was legal and which belong to the parties who seek to recover them, unquote. One of the parties to an illegal contract may therefore, in some cases, maintain a suit against a third person to recover money which is the latter has received under the contract. In order, however, that such legal relations may arise incidentally and collaterally from an illegal contract, the illegality itself must not be of a nature intrinsically immoral or evil. It must be an illegality resulting from motives of expediency or policy. In all the cases where a right of action arising collaterally from an illegal contract has been thus recognized and enforced, it will be found that the agreement was illegal because opposed to some statute or so-called public policy. Conclusion. Special rules contained in the foregoing paragraphs will serve to illustrate the meaning and operation of the principle. He who comes into a court of equity must come with clean hands, but they by no means exhaust its scope and effect. It is not alone fraud or illegality which prevents a suitor from entering a court of equity. Any really unconscientious conduct connected with the controversy to which he is a party will repel him from the forum whose very foundation is good conscience, A under that. You might want to add to that good faith along with that. So now we have one more maxim to go. We'll pick up that one next time, which is the last one in the enabling maxim, or the restrictive maxims, excuse me. The last one will be equity aids the vigilant. I'd like to summarize what Bouvier says. I'll give you the quote. John Bouvier, Institutes of American Law, 1882, Volume 2, Section 3724, Paragraph 4. Love this here. Law is nothing without equity, and equity is everything, even without law. Just that one sentence there explains it right so well. The law is nothing without equity. Equity is everything, even without law. Those who perceive what is just and what is unjust only through the eyes of the law never see it as well as those who behold it with the eyes of equity. Law may be looked upon in some manner as an assistance for those who have weak perception of right and wrong, in the same way that the optical glasses are useful for those who are short-sighted or those whose visual organs are deficient. Equity, in its true and genuine meaning, is the soul and spirit of the law. Soul and spirit of the law. Positive law is construed, and rational law is made by it. John Bouvier, 1882. He knew and understood equity. And we'll be picking up in the Phelps book again to start off with, and that's in Section 260, or Section 6. That's page 392 in the PDF, or page 352 in the book. So we've been talking about the equity maxims from the Phelps book, and he breaks them down into two classes. He breaks them down into the enabling maxims and the restrictive maxims. And under the enabling maxims, he's got them classified as 8, and we've gone over those 8 in previous recordings. And we're finishing up on the enabling maxim section, which consists of 6 more. And we've done the first 5, and we're finishing up on the last one. And we're picking up on the last maxim in that restrictive maxim section, which is number 6, equity aids the vigilant. Now, each of these maxims in their restrictive classes are broken down into subclasses or subgroups, and there may be several maxims in one group. So in the restrictive maxims, there are the first one, equity follows the law, is all by itself. The next two, number 2 and number 3, between equal equities the law will prevail, and between equal equities priority of time will prevail. Those two are grouped together and they work in conjunction with one another. And then the next 3 are grouped, or the last 3 are grouped within themselves. He who seeks equity must do equity, and he who comes into equity must come in with clean hands. And the last one, what we're doing tonight, is equity aids the vigilant. Those 3 work as a group together, as a subgroup. And also it's the same way on the enabling maxim section. Those are grouped together in certain subgroupings also. And they must be taken into context within their subgroup, the other maxims, because they all work in conjunction. So tonight, the last maxim we're working on, equity aids the vigilant, out of the Phelps book, section 260, number 6, 392 in the PDF, or 352 in the book. Section 260, equity aids the vigilant. Vigilantibus non dormantibus equitis subvent. Forgive my Latin. Referring to what was already been said respecting the close affinity between the last 3 restrictive maxims, their combined effect is well illustrated in the comprehensive doctrine of laches, commonly and often with proprietary referred exclusively to the maxim equity aids the vigilant. See number 3 footnote, which is Choose versus Farmers Bank, and a couple other where the reference must be made to this valuable note for the details omitted in the following outline sketch. Continuing on, closely connected with the laches is the doctrine of equitable limitations. Next section, 261, limitations. Now, although the statute of limitations does not in terms apply to cases in equity, I'm going to say that again, although the statute of limitations does not in terms apply to cases in equity, and there's a footnote 1 there on a case, yet upon the principle that equity follows the law, courts of equity apply the statute to all cases of concurrent jurisdiction, such as to bills for an account, a surety's claim to subrogation, bills to recover possession of land, when such bills are, for any reason, maintainable, the bill for the recovery of money. And that's footnote 4, 5, and 6 there. In such cases, equity is said to act in obedience with the statute, except under special circumstances. I'm going to read that again. In such cases, equity is said to act in obedience to the statutes, except under special circumstances. Now let's go over what those special circumstances may be again. And that's also a footnote 8. It's listing a couple cases there. Smith versus Wood. But the special circumstances is when you have a private trust that is under the exclusive head or in the exclusive jurisdiction of equity, and exclusive means to the exclusion of everything else, in other words, at law or any other legal system, because the trust lives exclusively in equity. That is the special circumstance. And that special circumstance will overpower or is superior to the statutes. So read this again. In such cases, equity is said to act in obedience to the statutes, except under special circumstances. Continuing on, in cases within the exclusive jurisdiction, the statute is not necessarily applied at all, but when applied, it is said to be by way of analogy. And among instances of this class are creditors' bills, bills to foreclose or redeem mortgages, and bills to enforce equitable titles, liens, and trusts. Number 1, footnote there, Noble versus Turner, and a couple other cases. In the case of the express continuing trust, as the possession of the trustee is not adverse, but according to his title, neither limitations nor lapse of time will bar relief as between trustee and city key trust until the trust relation has been repudiated. Now, notice it says trust relation. Trust relation has been repudiated, and we've gone over repudiation on one of the past audios. In fact, I think it's on one of the top audios on Tuesday night. So if you wanted to review that, you could listen there or get the audio tape off of Faith to Trust. She'll tell you where to pick it up at. But continuing on, in the case of implied trust, the statute is generally applied directly, and in such cases the defense of laches is also available. An application for injunction in support of a legal right will not be defeated by delay short of that required at law. Defense of the statute of limitations cannot be converted into an oppressive weapon. It is personal privilege and cannot, for instance, be valid by a subsequent mortgagee to defeat foreclosure of a prior mortgage to which limitations might have been but was not pleaded. The plea of the statute by one defendant does not inure the benefit of the others. In equity, the statute need not, in all cases, as at law, be specially pleaded or even set up in the answer, but when from the face of the bill it can be plainly seen that the bar applies, and no facts are stated sufficient to relieve it from the operation of the statute. The defense of limitations, as well as that of laches, may be availed of on demurrer. Next section, 262, laches. Laches. Independently of a statute of limitations, courts of equity refuse to relief in cases of unreasonable and unexplained delay in the prosecution of a suit. There may be laches in the failure to prosecute with diligence a suit actually commenced, as well as by delay in commencing a suit. Laches may be called the typical equitable doctrine for several reasons. In the first place, there is nothing arbitrary or technical in its rule, which rests upon the plainest principles of substantial justice and public policy. Now remember, when this was written in 1907, say, public policy was actual law, because public policy today is statutes and codes, which is not actual law. But public policy today is different. Back then, equity followed public policy to a degree, but today public policy is not law, and equity doesn't have to follow public policy at all. Again, there are rules that are subject to the sound discretion of the court to be freely exercised in view of the special circumstances of each case, or in other words, every case as to laches is governed chiefly by its own circumstances. And lastly, it runs through the whole system to which an extent that to cite its applications would be to enumerate nearly all the enabling doctrines of equity. In equity, a presumption exists against every stale claim because, as a general rule, persons who have a right and know they have it are prompted to assert it, but they don't always do so, and therefore the circumstances of each particular case which may explain the delay usually control the application of the rule as to laches. In other words, if you were ignorant of your rights, how could you be aware of it? And how could laches take place? And that's the one out in section, I believe it is in Gibson's 71, where the ignorance of rights. Continuing on, courts of equity are not established to relieve parties from the consequences of their own negligence or folly, or to assist those members of the profession who delve for practice in the remains of buried litigation. Quote, a court of equity, which is never active in giving relief against conscience or public grievance, has always refused its aid to stale demands where a party has slept upon his rights and acquiesced for a great length of time. Nothing can call forth the court into activity but conscience, or good conscience, good faith, and reasonable diligence. When these are wanting, the court is passive and does nothing. Latches and neglect are always discountenance, expedient replicia et ses finis litem, unquote. Sometimes the analogy of the statute of limitations is applied. Sometimes a longer period than that prescribed by the statute is required. In some cases, a shorter time is sufficient, and sometimes the rule is applied where there is no statutable bar. We find the principle constantly reiterated that each case must necessarily be governed by its own circumstances, such as the situation of the parties, the extent of their means of information, great changes in values, and want of probable grounds for imputation of intentional fraud, and the loss of evidence, the presence or absence of impediments to the assertion of the claim. Bearing in mind that decided cases can be taken only as suggestive illustrations, attention will now be called to some of the varieties of special circumstances which have been held material to the application of the doctrine of latches, and also to some of those who have exemplified particular cases from its operation. Next section, 263, affirmative defenses, or affirmative circumstances, excuse me. Affirmative circumstances. The following circumstances tending delay have been held as characterize the case of latches. The intervention of an important death, especially when the circumstance is colored by the indications of lying by, quote unquote. The intention of death is of less consequence when the death is one that disables the plaintiff's testimony, or when the invalidity of the transaction depends upon intrinsic nature rather than upon the proof allude, or when the material discovery has not made until after the individual's death. The erection of valuable improvements, except in the case of a void assignment of an illegal municipal improvement, or the improvements are offset by rents. Delays until other interests have become involved, or until after the property has increased in value, or until transactions have become obscured and evidence lost. Where the suit, after a long delay, is finally brought with some indirect motive, where the property is of a speculative character and the party is playing fast and loose, and where the property requires constant expenditure for repairs, etc., or where there is simply long delay, unexplained, especially if connected with such an action or non-action that the party is induced to infer acquiescence. Next section, 264, negative circumstances. Among special circumstances which have been allowed to negative the defense of latches, the following are the most frequent recurrence in practice. Delay is in general excused by infancy, and the infancy of one co-tenant has been held to protect adult co-tenants. Latches will not be imputed to married woman, not sui juris, otherwise quote her separate estate. A sedicute trust, whether infant or femme covert, may, however, be defeated by latches when represented by a competent trustee. The action must be taken with reasonable time after the disabilities of infancy or coverture are removed, having respect to the circumstances of each case. A similar disabilities are mental incompetence, extreme old age, and continuing duress or undue influence. The one that really applies to us is really mental incompetence, because we don't have the mental capacity because we just don't know. Continuing on, non-residence or absence from has sometimes been recognized as an excuse, so also contributory negligence or fault of an adverse party, possessing all material for stating the account, or lulling the plaintiff into security. Neither latches nor limitations will run during the time when there is no one in esse competent to sue, and when a creditor is himself the executor. Pendency of collateral litigation is sometimes in negative circumstances, but not where a tenant disputes his landlord's title. The following has also been held negative circumstances: uniform possession consistent with the relief sought, a wife declining to sue her husband, or a sister or brother living together, remainder man, before death of life tenant, insolvency, or poverty, in connection with other circumstances, natural hesitation on part of a female plaintiff in the case of particular delicacy, where stockholders impeaching a corporate contract have first to effect a change of directors, where the plaintiffs represent a numerous class, where nothing has occurred after the situation. Next section, 265, ignorance of rights. One of the most frequent of all the excuses for delay is ignorance of rights, whether of fact or law. Difference there, whether of fact or law. Where the equitable claim is founded on fraud of the other party, laches is no defense so long as the fraud remains undiscovered. In a reduced form, the same principle has been introduced by statute and is all the actions at law, where a party has a cause of action of which has been kept in ignorance by the fraud of the adverse party. The right to bring suit shall be deemed to have first occurred at the time in which such fraud shall, or with ordinary diligence, might have been discovered. In equity, especially as between trustee and sedicee trust now, when the defense of laches is met by this excuse, the burden of proof is not upon the plaintiff to show ignorance, but upon the defendant to prove that the plaintiff had knowledge. So the burden of proof is not upon the plaintiff to show ignorance, but upon the defendant to prove that the plaintiff had knowledge. But a tenant cannot plead ignorance of a title under which he holds, and if parties will accept the statements of others as to the effect of the deed without taking the trouble to examine themselves, they are liable for the defense of laches. So where the releases are signed and the money received under the circumstances which presupposes knowledge, it has been held that the ignorance is no excuse where it goes not to the fact, but only to the extent of the adverse right. Ignorance of rights is no answer to laches when the result of a deliberate choice and a resolution not to ignore, nor where the necessary information might have been obtained by inspection of public records. In other words, the party may be bound by imputed knowledge from constructive notice. So in other words, if you put something in the county recorder as a notice or an affidavit, and somebody didn't check, then that property, that real estate, they can't be a bona fide purchaser because it's posted in the county recorder as public knowledge. And even if they didn't look, they still can't be a bona fide purchaser. So it's always important to give notice. Continuing on. Defense of want of knowledge on the part of one charged with laches is one easily made, easy to prove by his oath and hard to disprove. Hence, the tendency of courts in recent years has been to hold the plaintiff to a rigid compliance with the law, which demands not only that he should have been ignorant of the fraud, but that he should have used reasonable diligence to have informed himself of all the facts. According to the rule before stated in another connection, also applies here, and where the party has information which puts him upon inquiry, he is charged with notice of every fact which that inquiry would have developed. Others acting in good faith also have rights. The words must move on, and it is the interest of the community that controversy should have an end. On the other hand, a sedicee trust is entitled to repose confidence in his trustee and is not bound to inquiry whether he has committed a fraud upon him unless there be something to arouse suspicion. Now, let me say this again. On the other hand, a sedicee trust is entitled to repose confidence in his trustee and is not bound to inquiry whether he has committed a fraud upon him unless there be something to arouse suspicion. So if all these trusts, everybody's in trust, because no party in that trust needs to know they're being formed and they're in a trust. So these trusts could be highly secretive all over, except when somebody wants to enforce it, and it could be fraudulent upon the trustees, but yet there's no grounds, there's nothing that makes the suspicion arise that there is any fraud. How powerful the trusts really are, superior to all other things, contracts, agreements, sales agreements, and everything else. Oh, this might be a good time to maybe take a little sidetrack here, which I usually don't do, but I found a book. It was out of Merwin, the author of Merwin, 1895, where he was going over on section 30, which is page 15 of the book. I don't know what the PDF is, but the section is equitable subject matter. It really boils down to this. It boils down to the common law explanation of why there can't be a private trust under common law contract forming the trust, or in other words, commonly known as a PCT, private contract trust. There cannot be one. Listen to what it says. Section 30. Equity differs from the common law on the subject with which it deals. Courts of Chancery recognize and enforce equitable titles and interests in distinction from strictly legal titles. The common law knows but one title. Let me repeat that again. The common law knows but one title, and that is the legal title. I want to say it one more time. The common law knows but one title, and that is the legal title. And I'm almost certain that you could put this caveat in there, also the statutes and codes. Continuing on, it is a maxim at common law that whoever has the better legal title prevails, and a party must recover, if at all, by strength of his legal title. Whether the suit is to recover land or the amount due on a promissory note or damages for a breach of any contract, no action can be maintained unless the plaintiff has the legal title to the land, the note, or the contract, as the case may be. But it often happens that although the legal title is property is in one person, the beneficial interest now, that is, the right to the use and the enjoyment, is in another. This beneficial interest, or let's put it this way, another way, a beneficial title, in other words, this beneficial interest is, in legal phraseology, the equitable title and interest, and as you can see, it constitutes the real interest, or the real owner, in other words. The holder of the legal title holds it, so should hold it simply for the benefit of, or in legal phrase, in trust for and another person, and he is called a trustee. The beneficiary being the sedicee trust, that is, the person for whose benefit the trust is held. And yet this great beneficial interest in the common law, it wholly ignores. Let me say that again. And yet this great beneficial interest, the common law wholly ignores. It does not admit, it cannot even conceive of its existence. Like, what? You're going to deny the real owner? Yes, under that law form. Because trusts are exclusively in equity. And this, we're not talking about equity, we're talking about common law or statutes and codes, that law. Continuing on, it furnishes it with no legal remedies and allows it no standing in its courts. And you thought the judges and the system was all corrupt, fraud, because they weren't listening to your substantive rights. You fools. At common law, if a plaintiff counted on the equitable title, his declaration would be demurrable. Next section, 31. On the other hand, it is the particular and beneficial province of equity to take this great class of interest into its keeping. The title of the beneficiary is always paramount title in equity, against the holder of the merely legal title. I'm going to say that again. The title of the beneficiary is always the paramount title in equity against the holder of the merely legal title. There's hardly a conceivable question growing out of the relation of trustee and the city key trust or third person in reference to this particular species of property which a court of equity will not entertain. Do we want to go to 32 or not? Let's pick up 32 here. The trust of which I have spoken may arise in either one of the two ways. First, it may be expressed, that is created by the owner of the property by some express declaration. So, for example, the owner of the estate conveys or devises it to A upon express trust that he shall collect the rents and income payable over to B. And second, well, I don't think that really applies. But the point I want to make is you can't have a common law trust under a contract, under common law, because trusts are exclusively in the jurisdiction of equity, representing the beneficial title which the common law can't recognize. So how can you have a private contract trust that's formed under common law? It's impossible. It would be to the exclusion of the beneficial interest. The beneficial interest being its beneficial nature, and you can't get rid of that. So there can't possibly be a private trust formed by a common law contract or a contract of any sort, because all contracts are under common law. We don't have contracts forming private trusts. We have arrangements. And they're all about a relation, not about a contract. It may be in writing, but the writing is not called a contract. Contract can't form a trust, at least without excluding the beneficial title. And if you can exclude the beneficial title and you're only talking about legal title, what kind of trust have you got? So it's impossible. It's illogical. So that's a sidetrack. Let's go back to Phelps on track with the restrictive maxim there we were talking about. And we left off, and we're going into the next section, section 266, elements of latches. 266, the elements of latches, picking up there again. So far as the subject so elastic is capable of rules, the principle of the extracted from all the authorities may be stated as follows. Apart from the statute of limitation and its analogies, there are two elements, one of the other which may be found before the equitable conception of latches can arise. There must be such delay as, under the circumstances of the case, amounts to acquiescence or waiver, or else the delay must be accompanied by some material change in the situation, making the enforcement of the claim especially prejudicial. Where both the elements concur, the stronger case of latches is, of course, exhibited than when either of them is absent, but even then the application of the doctrine has been prevented by special circumstances of satisfactory explanation, unless perhaps the acquiescence assumes the form of election. And you might want to review the doctrine of election, because really that's, you've got to choose one over the other, to the exclusion of the other. You can't have them both. One or the other. You're either in the public or in the private, one or the other. Can't have them both. So the acquiescence assumes the form of election, or the change in the situation is such as to arise in estoppel, when the interests involved are of fiduciary character. And remember, not all fiduciary characters are trusts, but all trusts are fiduciary character. Continuing on, especially where a trustee interposes the defense of latches against a charge of fraud, the latitude allowed the Seti Key Trust is more liberal than in other cases. Gee, I wonder why. Because it lives in equity. And equity is a special jurisdiction that has superior rights and control over all other jurisdictions. All other jurisdictions. It is the superior, God-conscious mind, the will of the Lord, the Heavenly Father. And anybody who's operating in equity is operating in the will of the God Father head, and that person too is in the will of the Father, because he's one-minded with the Father. And all righteousness, what is fair, just, and it's all holy. Section 266 next, applications. There is no equitable claim under whatever head of doctrine which may not in a proper case be met by its defense. The most frequent illustrations in practice occur in the cases of specific performance, injunction, enforcement of equitable liens or trusts, cancellation of deeds or rescission of contracts for fraud, and reformation or rescission of contracts for mistake. A trustee acting in good faith is to be treated with leniency, and to deprive a trustee wholly of the court's indulgence, he must be guilty of very supine negligence or willful default. Case support that under footnote 1. The executor and trustee made an erroneous distribution to the prejudice of an infant legatee who, upon his coming of age, filed a bill against him and the overpaid legatees to reclaim the deficiency with 15 years' interest. Trustee, being confessedly liable, claimed reimbursement from his co-defendants, to which claim the latter opposed a defense of laches. The defense was held good as to the arrears of interest, but as the good faith of the trustee had not been questioned, he was allowed reimbursement to the extent of the principal sum overpaid. The rule, both in equity and at law, which forbids recovery for a voluntary payment of money under a mere mistake of law, is based upon the doctrine of laches. Courts have not invited litigation, and to those who voluntarily place themselves in the situation of becoming suitors, they decline assistance. If the party would resist an unjust demand, he would do so at the threshold and not delay until evidence may be lost or situation changed. Next, section 268, how available. The defense of laches goes to the merits, which when the objection appears upon the face of the bill, it may be availed of on demurrer or at a hearing and need not be set up by way of a plea or unanswered. Hence, negative circumstances rely on to avoid the defenses of laches must be set forth in a bill of complaint by way of anticipation. In such cases, the plaintiff is held to stringent rules of pleading and evidence, and there must be distinct averments as to the time and when the fraud, etc., was discovered, so that the court can see whether, by ordinary diligence, the discovery might not have been made sooner. The party cannot, of course, avail himself of his own laches, and may be bound by laches of another under whom he claims, although he's been held that the defenses of settlement and laches cannot be coupled so that one may eke out the other. Yet it is clear that whether a lapse of time would not prevail alone, it will sometimes be allowed weight in connection with other defenses, such as estoppel, etc. 269, qualifications. In addition to what has been offered under the head of negative circumstances, it must be noted that neither limitations nor laches will bar the government, either federal or state, unless introduced as formal parties, and the real remedy sought in their name is but the enforcement of a private right. See, enforcement of a private right. That must be my substantive right. Footnote there. Footnote 3. When a state sues upon a private claim in another state, it is treated as a foreign private corporation. The sovereign principle of exemption from the operation of laches or limitation is particular to the state and does not pass to the creditors. To a widower's claim of dower, the statute is not a bar, and a delay for over 4 years does not constitute laches. Relief by injunction to restrain future infringements of trademark, etc., will not in general be refused by reason of laches, although the delay may be such as to preclude the plaintiff from any right to an account for past profits. There can be no prescription in favor of public nuisance, and therefore laches is no defense to an injunction bill to refrain from an injury as pollution of a stream by a slaughterhouse. 270, lapse of time. Equity acts upon two general considerations, one having reference to the interests of the community and the other particular interest of individuals. The first takes account of a mere lapse of time and enforces on behalf of society the policy of repose. It is sound public policy that no court should entertain a controversy after the ravages of time have destroyed all evidence, and when the lapse of time has been so great as to afford the clear presumption that all witnesses are dead and all proof lost. After what lapse of time is disputable presumption, that of payment, for instance, becomes conclusive, has never been fixed, but is left to the discretion of the court in view of the circumstances of each case. After long acquiescence, relief may be refused, not only when it is difficult to ascertain the facts, but also when the facts may be easily ascertained, and even when it is perfectly clear the relief would have been granted if asked for it in time. 271, laches apart from time. In a broader sense, the term laches denotes any negligent omission involving the loss of rights, such as the failure to have a deed recorded, or a want of due diligence of a creditor in collecting securities held as collateral, or notifying his debtor of non-payment at maturity, or the failure of a party to prepare his case for trial. In this sense, laches in the term of frequent application to legal as well as equitable proceedings is the basis of the doctrine of contributory negligence, and is sometimes identical and sometimes confounded with waiver, acquiescence, confirmation, estoppel, and election. 273, acquiescence. To prevent, I'm going to add that Gibson has a good section for acquiescence and waiver. It's in like 70, 71 in there. So 272, acquiescence. To prevent confusion in the use of this slippery term, distinction must be observed as to the time of its application to the particular transaction. Acquiescence, while transaction is in progress, is simply estoppel. To avail as the defense, it must have all the elements of estoppel. Thus, where a party expends money or does some act under a mistake as to the legal rights, misled either by the conduct, language, or silence of the real owner, he being fully aware of his own rights and of the mistake made by the other party, there is such fraud as will entitle the court to restrain the possessor of the legal right from exercising it. Any alleged acquiescence falling short of this standard cannot deprive a man of his legal right. Acquiescence after the transaction is complete, if the fruits are accepted, will amount to election, or it may assume the form of a waiver, by which the party sometimes loses a right by not asserting it in time. Loses a right by the party not asserting it in time. He who sleeps on his right has none. Equity aids the vigilant. Continuing on, if decisive steps of affirmation are taken, it may be merged in confirmation or release, provided the party is aware that he is confirming an impeachable transaction. In case of divorce, it may become condonation. A vested legal right of the action cannot in general be waived without accord and satisfaction or release under seal. A right strictly legal cannot in general be barred by an equitable remedy short of statutory period of limitations, and so as to an equitable claim as to which the statute is applied by analogy. Better look at the word analogy. Applied by analogy. That doesn't mean that it gets applied. Where, however, the claim is equitable merely and the acquiescence is marked by features like those before referred to and is not explained by circumstances such as those already mentioned, it will simply be identical with latches. Whether will or will not be a case of latches cannot be determined in advance by hard and fast rule, but will depend upon the particular circumstances and the sound discretion of the court. And remember, the court is bound by the discretion of the railroad tracks governing it, and those are the maxims. It's not true discretion, I get to do anything I want. No, the court of equity is bound in its discretion to run on the tracks of the maxims. And that's why we're going over this whole maxim series, because how would you know whether or not an equity court was doing what was right unless you knew what the maxims were? So in the sound discretion of the court, renewable on appeal, in any case there must be perfect freedom of violation and action and full knowledge of all the material facts of the law applicable to them, a well-established exception to the rule, ignorant legis nemium excusat. Footnote 5. Case Zimmerman versus Fraley. That ends that section in the Phelps book. Now we will go to Corpus Juris next. Corpus Juris, section 179. Section 179, that's on page 220 in the PDF or page 193 in the book. Section D, equity aids the vigilant, not those who slumber on their rights. Number 1, in general. The maxim that equity aids the vigilant, not those who slumber on their rights, expresses the attitude of equity towards latches and stale demands. This maxim has been regarded as a special form of the more general maxim that he who seeks equity must do equity. It is closely related to the equitable principle that he has the better right who has first in point of time. Number 2, section 180, application of the rule. This maxim of its extended application and of its design is to promote diligence and discourage latches. It is the principle which underlies statutes of limitations and is to suppose of the same reason and upon the same grounds. On it, the equitable doctrine of latches is based. It is by force of the principle that equity refuses to enforce demands which the party has unreasonably delayed in asserting, such as frequently treated as the extent of the maximum, but the courts have been given a wider application as protecting one who with superior diligence has obtained legal advantage, or by denying relief to one whose danger was created by his own neglect. A frequent application of the maxim is in bills for injunctions. It is well settled that even when the applicant had ordinarily ample grounds for equitable relief, it may be denied him if he delays unduly. The maxim has also been applied to bills and to redeem, proceedings to set aside, judgments, accounting, discovery, specific performance, surrender and cancellation of instruments, partnership bills, and in bills for relief against fraud and against illegal forfeiture of corporate stocks. Next, 181, number 3, limitations of rule. The maxim that equitable relief or equitable rewards the diligence. The maxim that equity rewards the diligent has no application to the diligent in concealment of deceit, nor where one displays his diligence in doing of unless and unnecessary things. The party seeking to advantage of the maxim must be free from fault, and he must have done nothing to lull the adversary into repose, thereby obstructing the preventing diligence on the part of the latter. Like its legal counterpart, the statute of limitations, this maxim does not apply to parties under disability, such as a femme covert at common law, an infant, or an insane person. So the principle embodied in the maxim is inapplicable to the proceeding by or in behalf of the state. That concludes that maxim in that book. Now we'll go to BizFam next. Section 39. That's page 260 in the PDF or page 66 in the book. 260 in a PDF or page 66 in the book. Section 39, number 3. Vigilantibus non dormientibus equitis subvenitur. Another maxim is that, I just butchered up probably, the meaning of which is sufficiently obvious. It is designed to provoke diligence, to punish laches, and to discourage the assertion of stale claims. By virtue of this maxim, such claims are rejected in equity independently of any statute of limitation. In many cases, equitable relief depends upon the discretion of the chancellor, and the laches of the complainant is often one of the most important of elements which are taken into consideration when that discretion is exercised. Courts of equity sometimes consider themselves bound by the statute of limitations. It says sometimes consider themselves bound by statute of limitations. In other cases, they act by analogy only. Footnote 3 for that. By lapse of time and the staleness of a claim may constitute a defense in courts of equity, even when no statute of limitation governs the case. This defense is particular to the courts of chancery, in which cases act upon their own inherent doctrine of discouraging for the peace of society, antiquated demands, and refuse to interfere where there has been gross laches in prosecuting the claim, no longer acquiesce in the assertion of adverse rights. The Court of Equity, said Lord Camden, has always refused to aid stale demands where the party slept upon his right and acquiesced for a great length of time. Nothing can call forth this court into activity but good conscience, good faith, and reasonable diligence. Where these are wanting, the court is passive and does nothing. Laches and the neglect are always discountenanced, and therefore, from the beginning of this jurisdiction, there is always a limitation to suits in this court. But this maxim must not be understood as operating to deprive a plaintiff from obtaining redress in equity by reason of delay, where the wrongdoing has been secret and has been fraudulently concealed. In such a case, the maxim has no application. May be added as against the government. Laches cannot set up as a defense in equity any more than a bar of the statute can at law, and also that laches may not be imputed so as to deprive a party of his equitable rights when his delay has caused no harm. That's the end of that maxim in that book. Next, we'll go to Snell. Snell, number 7. Page 72 in the PDF or page 43 in a book. 72 in the PDF, 43 in the book. Number 7. Doctrine expressed in a third of these three connected maxims is delay defeats equities, or as it otherwise expressed, equity aids the vigilant, not the indolent, may be briefly summed in the language of Lord Camden in Smith versus Clay. Quote, Court of Equity, which is never active in the relief against conscience and public convenience, has always refused its aid to stale demands where a party has slept upon his rights and acquiesced for a great length of time. Nothing can call forth this court into activity but conscience, good faith, and reasonable diligence. I might want to add good conscience. A good conscience would really be what is righteous, fair, and just, equal. Equity, what is equitable. And it may be added that even the comparatively short period of delay not satisfactorily accounted for also tells heavily against plaintiff in equity. Repeat that again. It may be added that even a comparatively short period of delay not satisfactorily accounted for also tells heavily against plaintiff in equity. That book, short one there. Now we go to my friend Gibson's, section 49, page 69 of the PDF or page 43 in the book. Gibson, section 49, page 69 in the book, page 43, or excuse me, page 43 in the book, page 69 in the PDF. 49, equity aids the vigilant, not those who sleep upon their rights. This maxim is designed to promote diligence on the part of suitors. Equity requires a party to assert his rights in a reasonable time after he discovers that he has been wronged. A person who delays suit, not only by his negligence, makes proof of his wrongs more difficult, but induces the other party to believe that he acquiesces in the situation. Besides, if courts allow suits to be delayed, a party may wait until the adverse witness dies or moves away before he brings suit. A party in wrong may be also misled by the non-action of the party wronged, as do such acts, and otherwise so change his situation that it would embarrass the court in granting relief. He who seeks equity must himself, in a condition, do equity, and if by his own delay he is disabled from doing equity, he will be debarred from receiving equity. It is bad faith for a party wrong to delay suit until the wrong cannot be righted without doing another wrong. Good conscience requires a party to do no act that will mislead another to his detriment, and even though the other may have done him wrong. Hence it has been said, nothing can call a court of equity into activity but conscience, good faith, and reasonable diligence. See footnote 47. Is Lafferty versus Turley. Also Pomeroy, Equity Jurisprudence, section 419, which probably we're going to next. Continuing on, in many cases, equitable relief depends upon the discretion of the chancellor and laches of the complainant, and is often one of the most important of the elements taken into consideration when the discretion is exercised. This maxim is constantly applied where parties delays too long before he applies for an injunction or may be relieved against in a fraud or seeks a specific performance of a contract or the rescission of a contract. It applies also to persons who do not inquire after being put on inquiry, to purchasers at public sales where there are no warranties of equitable or title, or of quality or title, or there are those whose duty it is to take necessary steps to perfect their rights by giving notice of an assignment to them of a non-negotiable truce in action, or by having other instruments duly registered. I'm thinking that we go back up here. To those whose duty it is to take necessary steps to perfect their rights by giving notice of an assignment to them of the non-negotiable truce in action. Giving notice of an assignment, that kind of comes into all the foreclosures today where they're not, especially involving mirrors, where they have never given notice of the assignments. Take a little weight with that. Continuing on, equity delights in diligence and is slow to aid the slow. It not only requires clean hands and pure heart, but also swift feet. But if the defendant has caused the complainant to sleep, he cannot complain of it, for that would be to take advantage of his own wrong. I could go into 50 and 51, but I don't think I will, though. Go on to Pomeroy next. Last one for tonight. Starting in section 418. 762 in a PDF. $762 in a PDF or $695 in the book. Section 418. The maximum equity aids the vigilant, not those who slumber on their rights. 418, its meaning, its rule controlling the administration of remedies. Principle embodied in this maxim, the original form, which is vigilantis non debinibus equitis subvenit, operates throughout the entire remedial portion of equity jurisprudence, but rather than furnishing a most important rule controlling and restraining the courts and administration of all kinds of reliefs, has been the source of particular and distinctive doctrines of jurisprudence. Indeed, in some of its applications, it may properly be regarded as a special form and yet more general principle. He who seeks equity must do equity. The principle thus used in the principal rule controlling and restricting the award of release is designated to promote diligence on the part of suitors, to discourage laches by making it a bar to relief, and to prevent the enforcement of stale demands of all kinds, wholly independent of any statutory periods of limitations. It is invoked for the purpose in suits of injunction, suits to obtain remedy against fraud, and in all classes of cases, except perhaps those brought to enforce a trust against an express trustee. Except perhaps those brought to enforce a trust against an express trustee. See footnote 2 and under A. 419, its application and effects. The scope and effect of the general principle as a rule for administration of relief irrespective of the statutory limitations as stated by the eminent English Chancellor in the following language, quote, Court of Equity, which is never active in relief against conscience or public convenience, has always refused its aid to stale demands where the party has slept upon his rights and acquiesced for a great length of time. Nothing can call forth this court into activity but conscience, good faith, and reasonable diligence, unquote. The principle has, in fact, two aspects, one of them wholly independent of any statutory limitation, and the other with reference to such statute. In earlier forms of the statute of limitations, the provisions were, in express terms, confined to actions at law. And yet courts of equity, proceeding upon the analogy of these enactments in most suits to enforce equitable titles to real estate and equitable personal claims, applied the statutory periods. In certain kinds of suits, however, especially those brought against trustees to enforce express trust, the analogy of the statute was not followed. The modern form of these statutes in the American states generally declare in express terms that the periods of limitation shall apply to all equitable suits as well as to legal actions. This legislation has not, however, abrogated the principle under consideration. All cases not falling within the scope of the statutory limitations would still be controlled by it. That concludes last maxim series. As to Phelps, who has 8 under the enabling and 6 under the restrictive, for a total of 8 plus 6, which is 14. And there are a number of straggler maxims, I would call them, that tie in with these, and we'll go over those probably next time, and we'll do a summary and a recap. Then we'll be starting a new series after that, so we'll probably have one more on the Maxim series before we start the new series, which will be on the lines of public versus private, how to tell the difference, and how to live in the private. how to live and operate in the private. So it's public versus private coming up in the next. And I'll probably stay on that because the way I see it, that is the biggest mind-boggler to people today. They do not understand what is public versus private, and that even goes for all the gurus out there teaching this, whatever method they're teaching. They do not understand public versus private, and they are totally, totally, totally lost.